Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their court.
The fireworks are not done.
Now we're getting commentary on the case. Dagi mihi Anglican for you, service.
Is that correct?
I didn't ask you to interrupt me.
Good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. Great to have you here this morning. Good morning. See everyone taking their seats. Welcome. It is a beautiful day. Beautiful day. I have to say a special welcome today to Kristen Morona Cameron. Kristen, good morning. How you doing? Hi. Kristen, not sure if you know. You might be like, hey, why me? Why is he saying my name right now? Well, we know. I was just not sure if you know. Kristen, you are what we kindly refer to as a first-time offender. A first-time offender. What did you do? Well, it's sort of what you didn't do that's the issue. Everyone else was being quiet. Everyone else was just silently enjoying the morning, peacefully, I might add, in chat. And you did not. You just blurted out hi to everybody in chat. First, just amidst the silence, no one else had done anything to you. So technically, you were the instigator of chat. We view this as a serious offense here on the channel. We know somebody has to do it, but that person, we can't just ignore the person who does it. Today it was you. So we're going to sentence you, Kristen, right here. I'm judge, jury, and executioner when it comes to this particular law. We're going to sentence you to internet ownership. That's the penalty, the price that you pay for your crime. Hopefully it will teach you your lesson. I know some people like the sentence and they come back for more, and they're weird, but it's okay. We like them too. But internet ownership is all on you now. That means in addition to whatever else you had going this morning, whether it was dealing with kids, whether it was dealing with a husband or fiance or girlfriends or whatever else it was, you now also have to take care of everybody's internet problems. And start with mine, because my internet-connected stove is not lighting on the bottom. You might think, well, that's call a repairman. No, technically, connects to the internet. That's you. That just gives you a little peek into the type of stuff you're going to experience today. Kristen, welcome. Jen says we love you. He's going really hard on you. Just know, I think you're up to the task. It'll be wonderful. Congratulations on being first in chat, by the way. If you want to commemorate this occasion with a frame-worthy certificate, not just worthy of hanging on the wall or your refrigerator or on your office in your office space, but maybe adding as a cover sheet to your CV. People do that. You can go over to the shopping tab on the YouTube page for Recovery Addict and click on there. For the low fine of 50 cents, you can get a copy of this permanent record, and you can print it out and fill in the blank, which will be your name. And you can add that to your resume that way. So wonderful. Thank you very much. Appreciate you, Kristen. You're going to do great. Let's see. Renee Smitty just gave a membership this morning. Thank you very much. Andrew C., member for 12 months. 12 months. Happy anniversary, Andrew. That is awesome. 12 months. Says good morning. Good morning. It's a great morning. Barb Ebert, $5 super chat, says, just got accepted into my master's program starting mid-May. I just wanted to say thank you to you, RA and Mrs. RA, for the inspiration. Barb, that is so exciting. Keep us updated on how it goes. I realize master's programs are difficult. So first, work on your master's program. If you have any spare time, keep us updated on how it goes. We'd love to hear as you progress through the program. That is just so exciting. I have to also say, just briefly, There's one other thing I forgot to mention, and that is that...
Mike. What day is it, Mike? Guess what today is? It's hump day.
Hump day! Welcome to Wednesday. Welcome to Wednesday. New record. It wasn't as high as I normally go, but I can't do high very long. Libby's like, wait, what did I just join in on? I just loaded.
I'm not a camel.
I've got 4 family members just came in to check on me. Mrs. R.A. and 3 littles.
I think I could do longer, possibly.
You want to do a hump day, y'all? No. They all.
Yeah, but maybe later once I have this mint.
Tisha says that was a good one. Welcome to Wednesday. We are halfway through the work week. It's deserving of being celebrated. It really is. I expect to never do one that long again. Longest one ever. I don't know how long that was, but it was a few seconds there. It was a few seconds. It was a little loud too. I thought the stream broke. It was stuck. Did someone clip that? Says Ashley. Yes, it's Wednesday. We made it halfway through the work week. It's exciting. We had a weird start, strange verdicts or non-verdicts, funny little case. We're now halfway through the work week, and we get a sort of a respite as we are between big cases right now. You broke my remaining eardrum.
Roaches fighting.
I'm sorry about that. BGOG that says, that was amazing. Wonderful. Thank you. Amazing 7 months, BG. That's awesome. And Libby says, I made it to the Yellow Courthouse. Congratulations, Libby. 6 months. The Yellow Courthouse looks great next to your name. Wonderful. We also, after that, I'm supposed to sing. That reminded me of George the Jungle Yodel. I think that's a compliment, Amber. I think. Otherwise, I'd time you out. Let's see. Best one yet. Oh, my goodness. I have to say, I'm happy today. I normally have an errand I run, a carpool I drive early in the morning. And I wake up at 5:30 for that. And 5:30 this morning when the alarm went off, I hadn't slept very well. And Miss Sari said, hey, I'll drive today. You just go back to bed. I'm like, that's why I married her. She's amazing. So she was tired as well, but she got up and drove the carpool instead of me. So I got to lay there in bed. And if it looks like I just woke up, it's because I did. I got to sleep in and tremendously. It was wonderful. It was like having a second night of sleep in the same night. It was really, really good. Franco says, when I won the internet back at day 6 or 7 of DB trial, I thought you truly selected me to handle the stream's internet-related issues, kind of like a mod. Franco is like, oh no. Yes, the duties, they sound really important, and we make it sound like it's a very difficult task. But in reality, most people don't notice the difference between days they don't win the internet and days they do. All right, I wake up at 5:30 to get my daughter to the bus stop every day, Tisha. Yeah, that's basically what it was. But it was good. It was good. So I got a little extra sleep. I'm excited about that. So we're looking forward to today. It's wonderful. Red Pen just gifted 5 memberships to kick off the morning. Well, we've already kicked off the morning, but we also have to go back. I didn't miss. I'll pull it up. I've got it. We have to go back because we haven't done the birthday celebration. We can't start the day without birthday celebration. Today, according to Sharon McDonald, who is our birthday keeper extraordinaire, we have Krista, Calamity Jane, Leslie, pronounced Leslie. I like that. Our ex-girl, and Vicky are all celebrating their special day with us today. So Krista, Calamity Jane, Leslie, and our ex-girl, and Vicky. We're going to sing to those who are celebrating. And first of all, happy birthday. Thanks for being here. Hopefully that Hump Day yell didn't dampen your birthday celebrations. So we're going to sing together. Look at this. We have one more to add. Just 1 second. It's a late ad, but I will go ahead and do it manually here. Let's see. Copy. Paste. And then we need Bruce Toby as well. Let's see, Brucey Toby. There we go. Copy.
Sir, you're charged with especially aggravated kidnapping. You're also charged.
I don't want that. Why did it do that? Apparently we're charged with aggravated kidnapping as well. Let me pause that. There we go. Get off that screen. All right, so Brucey, I have 4 keyboards. Need to find the right one. Brucey, we're going to add you to the birthday list at Brucey Toby. Yes, I need somebody with more experience. All right, so the list has been updated and posted right here. Just one second. There it is. There's our birthday list. Please join with me in singing to these fine folks who are celebrating the birthday today. And realize when I say join with me, Rebecca as well. Okay. Hang on. We've got some late ads. Copy. I don't know a better way to do this. Paste and then add on Rebecca. Let's see. Rebecca is Rebecca. I think I would Rebecca. Did that quite backwards. There we go. Why is it saying Rebecca Designs? Is it Rebecca Designs? There we go. All right, we're going to try this again. Here we go. Lots of birthdays today. There they are on the list. Late, it's Krista's birthday. Krista's on the list, Megan. We've got Krista right at the top of the list. We're good. Lots of birthdays today. Might be a 2-verser. I think we're going to do Krista, Calamity Jane, Leslie, and RX Girl, and then Vicky, Bruce, Toby, and Rebecca on verse 2. So when I say this is the birthday song, this is not a solo. Trust me, I don't sing solos. I don't do that. I just don't have that in me. I sing very well in a group. So I'd ask for you to all join with me as we sing to these fine folks who are celebrating their birthday today. You can do that by first standing up, stretching a little bit, roll the shoulders, take a deep breath, warm up with me. La 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 la. Sounds beautiful. Great. The dancers are ready. Looks like the outfits are especially glittery today. Here we go. Blend your voices, people. Happy birthday to you. Happy birthday to you. Happy birthday, Krista, Calamity Jane, Leslie, and RX Girl. Happy birthday to you. Brief interlude. Give the dancers time to show off their new moves. And during that time, read ahead on the words. We're going to sing to Vicky, Brucey, Toby, and Rebecca on verse 2. Happy birthday to you. Happy birthday to you. Happy birthday, Vicky, Brucey, Toby, and Rebecca. Happy birthday to you. To everybody who is celebrating their birthday today. Krista, Calamity Jane, Leslie, pronounced Leslie, RX Girl, Vicky, Brucey, Toby, and Rebecca. We hope you have an absolutely wonderful day. I realize there are a million places you could be, a million channels you could watch, a million people you could celebrate with, but you've chosen to be here with us on your special day, and that is not lost on me. Thank you very much for this privilege. It's our honor to do this. Lavender says, happy birthday, everyone, especially my mom. Hopefully on your birthday, all of you are celebrating, you go out to Denny's and you show them your app and your driver's license or whatever it is you have to show, and you get your free pancakes. Because who doesn't want free pancakes on your birthday? Happy birthday. I hope you have a great one. The dancers are in great shape. This day after day of practicing is really starting to show. They are fit. They are trim. Their high kicks have never been higher. Amazing work, all of you. I appreciate the dedication you put into this amazing performance every morning. It's like Las Vegas. This is like a Las Vegas show where you go and you pay way too much money to see some very good performers. Well, here you don't have to pay anything, and you get the same performance. So, thank you. It's wonderful to have all of you with us. You gave us a lot of time to stretch this morning, Ashley. I did. I'm sorry about that. I was sleeping. Oops, rogue fireworks. Here we go. All right, and Las Vegas has nothing on us, says Holly Mack. Through my 3 dance lessons so far have paid off. All 3. Your dance instructors were like, wow, look at the improvement. This is amazing. All right. Can I go from a very high point to something that I was a little disturbed by yesterday? And I know in doing this, I want to keep it out of chat as much as possible. I know that's weird with me saying I want to talk about something, but I don't want you to. But and I'm gonna do this as best I can without naming names, because I don't think that that's helpful to the conversation. I've never been a big fan of the idea, and I know some companies literally are fans of this. Fan of the idea that any press is good press, right? That any way we can get our name in, trending is good, and that's not been something that that appeals to me. I realize, that statistically, mathematically, yes, it might give you more exposure and things like that, but I don't think it's a good way to build a community. I think it's a great way to build an audience of spectators, but when you're building a community, I think it's better to be genuine and basically to be kind and consistent. I've seen recently some viral stuff online where individuals, some of them even in basically a similar profession to what I consider myself in, acting in a way that I don't think is the best for the community in general. It's not the best for true crime. It's not the best for media. It's not the best for all that. I just ask that we recognize that there's a better way to do it, and instead of joining in the attacking or anything like that, that we be kind and give them some space. I do not condone the behavior at all. We've seen it. We've seen it with celebrities getting attacked, as well as people in the world of true crime. Most recently, those two come to mind. Just it's not cool, right? It's not cool. But let's not fall into the trap of responding or participating, and we can make it better. That's all. So that's if you know, if you don't know, that's okay. Honestly, I think if you don't know what I'm talking about, you're probably better off for it. Honestly, I would not feel in any way that you're curious. That curiosity would pay off by researching what I'm talking about. I would say count yourself lucky that you didn't witness that, and let's just know that if you come upon somebody that we don't have to spell it out in chat. Let's leave it out of there. But anyway, I just wanted to voice that. I don't condone confrontational journalism like that. I don't think it's the best way to really get insight into a situation. But that's where we'll leave it there. All right. And that's just for you guys. I think I say that because I think we as a community are better than just the average, person who's surfing the internet from their mom's basement. And that's it. On your box on the side of the screen, it looks fuzzy. I look fuzzy? Is that any better?
Squirrel.
Yeah. All right. All right, the verdict for yesterday. What was the verdict for yesterday? For those who missed our verdict for our one-day trial in the, I guess we're going to call it, we called it the Green Sky Trial, which is a weird name. It wasn't actually a trial about whether the sky was green or not. But
someone with more experience.
Yeah,
this is not Burger King. People do not get to have it their way.
The state really went for the jugular.
The zombie apocalypse.
They asked for everything. The jury delivered everything, and the state had a mea culpa, where they instead said, we'd like the lightest sentence possible. Now that we've got the strongest conviction, we'd like the lightest sentence possible, which was an interesting transition. And I wonder how the jury felt after that, when they're like, wait, is this the same guy who was saying, give him everything, we want your full conviction? Buyer's remorse. But at the end of the day, I sort of feel okay with the outcome. It seems that the defendant is aware that he had a problem, and that it could have ended differently, although he made some funny comments about why he'd never go to a bar because it's too expensive to drink at bars. That's probably not something you need to tell the judge right now during sentencing. But he does, I think it will end up in being a an opportunity for him to improve himself, and also really for the family to heal and sort of get over it, get back together. Because, I like to see families stay together where they can. So when there's been a hiccup or a bump in the road, and if there's something that can be mended, I like to see that happen. So hopefully that's what's going to happen there. So the sentence was suspended, 365-day sentence, which means he serves no jail time other than when he was arrested. And he basically starts the treatment for substance abuse. And as long as he starts and shows progress in that treatment, he's going to lose his scram bracelet, and it'll be good. So, and the family's already, the restraining order between them, that's already dropped. I think they're already back together. They've sort of moved on, and I think this will help. And I hope that helps him too. All right, so that's where we are. I was going to jump over to Judge Cedric. I'm not sure what he's doing today, but I saw that he came on earlier this morning. Let's see, Cedric Simpson is live. Let me go back just a little bit. We're not going to be the most current. Let me see when he popped on live. Just a few minutes ago, I think. Oh, very, very recently. I think we're only, what is that? We're 7 minutes behind. There we go. So we're going to start in Judge Cedric's courtroom because it's always fun to visit there as they get set. It is a court hopping day. So we're let's see. It's gonna be a lot of fun. Let's see, Lindsay, what were you saying? Trying to trace conversations back to see what you guys are talking about. Britt Bottoms, I missed your 3-month message yesterday. I am so sorry. Post it again. Say Recovery Addict 3-month, and then what your message is. I'll read it. I'll read it just like you had just posted it. What is the next trial we're watching? Was that your message? Well, we're going to start with whatever is going to happen here in Judge Cedric Simpson's court. Looking at the schedule of upcoming cases, we've got a little bit of a dip. Karen Reed starts. We have, let's see, Karen Reed has started in the jury selection, so that's going to take a little bit. Tomorrow we have a spicy one with Judge Cedric Simpson at 3 p.m. that we want to jump in on. Obviously, the Delphi case doesn't have video on that one. Corey Richens has an update coming up in the next 2 weeks, which should give us a schedule for trial, which will be very, very interesting. Let's see. We got Richard Walter Bradley Jr., the 4 gold digger murders. That one's out of Washington. Scott Peterson has some motions coming up also at the end of next month, about a month away. There's sort of like a lull right now. As some of the cases we thought would be happening right now, say for instance, like Sarah Boone or cases of that nature. Whatever happened to Shannon Gardner and Fernandez Saldanha? That joint trial down in Duval, Florida. What was the update on that? Anybody know? Pauline Anna says, RA in chat, can I make a new request for a new soundbite bit from the Rust trial? It's the quote, "He was kind of playing dead on a horse." I found it hilarious. That was funny. That was a question asked of one of the witnesses that was on the scene, saying was Alec Baldwin like controlling the show and everything. He's like, no, he wasn't really demanding. He wasn't doing anything, because when I saw him, he was playing dead on the horse. And it was pretty much just like, well, did she just slam into that wall? Just hit the button? The court looks exciting this morning. Lots of movement. Edsel Dog, how can I be a court watcher for you on the Shannon Gardner trial in Jacksonville? Okay, that Shannon, that's the one I asked about a little bit. Edsel Dog, what's the date? And by the way, congratulations on 11 months. What is the date for Brett Bottoms?
There it is.
What's the date of that trial?
You may be seeing.
That's probably the least heartfelt intro I've ever heard for a judge coming to court. I will be streaming when I'm on Gone for a Month. I will be streaming. I'm taking my gear with me.
On behalf of people.
Jeff Hall on behalf of Stephanie Julian.
My cat has only come back twice in the last 4 days.
Stephanie Julian.
Thank you. All right. Where are we, folks, on this? I did receive the email this morning, or the message this morning. So.
Yes, I did let him know about the videos, and then I just received them after 11 o'clock last night. Opened them early this morning. We do have all of our witnesses today. It's my understanding that Mr. Hall would be objecting to admission of the videos. As a result of that, I would be requesting an adjournment so that he has adequate time to review them with his client, and we would be able to use them at the next available bench trial date. I do want to note for the record that I did previously request all media associated with this case and was told that we had everything. So at this point, I'm not exactly sure where the gap was between that request and us receiving these surveillance videos. But at this point, I did not receive them until after 11 p.m. last night.
Your Honor, I received them at 8:30 this morning. Once Sister Counsel told me that they were in my inbox. And according to the police report, they were downloaded on January 24th of 2023. So they
downloaded to.
Police report just says they were downloaded. I'm not sure if it was to evidence.com or where it was downloaded to. That would be my assumption. And this case has been going on for nearly 15 months. So I would also object to the adjournment.
Your Honor, I checked evidence.com yesterday. I had 4 videos, actually, or 2 videos, I believe. I did not have the surveillance videos yet.
And these, the description that the court got was that they're ring videos of, what are these videos? Yes. Ma'am, you can have a seat. No, you can sit right there. Okay, it's okay.
Britt Bottoms, thanks for the 3 months of support. Perfect way to spend my
surveillance videos of the victim's home.
From where? No, I mean, I guess I'm trying to figure out.
It's surveillance videos, ring videos, which the ring systems are operated by the victim, equipped to his home, and includes video of the alleged conduct by the defendant.
Judge is thinking.
And those are the only videos in this case.
There's body cam, and that was already submitted and uploaded into evidence.com, which was the video that I had available to me prior to 11 p.m. yesterday.
That's what I'm trying to figure out. What I'm trying to figure out is, Mr. Hall, when you reference something in the police report that says the video was downloaded, are we talking that video or are we talking other video?
It says David emailed me his surveillance videos of his front and backyard.
Got it.
I downloaded them on my computer.
Okay.
My understanding, Your Honor, is that they were downloaded to the internal Pittsfield public safety server, but not uploaded into evidence.com. I don't know what the gap was when I asked for all media associated with this case, why they were not uploaded.
Did we ask why that happened, or?
I have not had an opportunity to hear back from them as to why that did not happen.
Excluding video of the crime being committed, that's a big exclusion.
And you viewed the video?
Briefly. I viewed the original video, which is body cam of the video on a computer.
Oh, whoa.
Say it again.
So
the other videos you've seen.
A video of a video.
Body cam video, yes.
Right.
Melissa, thank you. Love my true crime fan.
Is the one that you're saying you just saw this briefly?
Yes.
11 months. Melissa, thank you so much.
The ring video, they're much clearer and
they're clear.
Yes.
They're better evidence. Oh, they're
Those
coming.
HD cameras now.
Yes. I have like 8 of them.
Judge has 8 HD cameras.
And your grounds for objecting to the adjournment is solely because of length of time, as opposed to.
Well, that and, yes. And this case there was a plea offered and entered into at some point. And then that during the pre-plea version, that plea was pulled and it continued on a trial and a resolution was never reached.
I don't think that's an accurate statement of the record at all. Plus, we don't do pre-plea diversion in this court.
So I don't know what that is.
Maybe it was just a regular diversion.
There was no diversion in this whatsoever.
Yeah, I can help. This was a case where Patricia Reiser had offered, and she was to complete a mental health assessment and recommended recommendations of the therapist, along with do not violate the state law for 3 months and no contact with the brother for 3 months, that the case would be dismissed. My client did, or Ms. Julian did do everything required under that. However, after it was completed, the plea was essentially pulled. She was no longer able to do that.
Your Honor, we have been over this multiple times. There was no note of that offer whatsoever made.
Well, I understand that, but
it also wasn't discussed with the victim whatsoever.
Well, that may be somebody else's issue. So,
and after,
was that offer given?
Your Honor, I have not been able to confirm either way, but what I do know is we had went on to additional negotiations afterward where another offer was formally recommended, offered, and discussed, and we had agreed on it.
No.
Your Honor,
If the offer, so
Patricia Reiser, in the case, me and Morgan Barroso were on a Teams chat. She did confirm that the offer was there, and that was the offer on I think it was the second final settlement date.
And Ms. Julian also did the psych evaluation. She completed it and a report was produced.
And I do have that report available. I can print it off if you'd like.
That was not my understanding of the communication with Ms. Reiser.
Okay, so hold on a second, folks.
Judge has a headache first thing in the morning.
If I guess, was there, Ms. Kuhn, something to your understanding or anybody's understanding that if that offer was made, that as to a reason why it was pulled?
Because the victim did not agree to that.
And
the reasoning that was given.
And there was a change in the APA.
Yeah, and
there was a what?
Change from Patricia Reiser to Morgan Barroso.
Yeah, it wasn't that the victim didn't agree to it. The victim was never consulted about any resolution whatsoever, which he is entitled to because he claimed his victim rights under the Crime Victim Rights Act.
But that's not my client's responsibility to make.
Well, okay, I get that. I hear all of that, but
Tish, hang on, we're gonna talk this to
you. I mean, I guess the problem that I have outside of the alleged victim, their approval or their whatever, at some point, Ms. Julian is told to do something. She's told to do something that is sort of the ultimate resolution. That being, the case would be dismissed if you do these things. It's not, if you do these things, we'll give you a misdemeanor or something along those lines, that you still have to plead to something. For her, it goes away. And so then so from my understanding, and folks can correct me if I'm wrong, she does those things.
Correct.
At that point, then I guess the victim is contacted, the alleged victim is contacted, doesn't agree. And then and so then that offer doesn't happen. There's something wholly wrong with that whole scenario.
Your Honor, my understanding is not that the victim was contacted, it was that there was no documentation of that offer whatsoever. And the victim
but Ms. Barroso, that's not my issue. My issue is that there was an agreement to do something. Defendant does it. Now, if on that side, what you needed to do wasn't done, that's a whole other thing.
It's a contract. If it was verbal and both parties acted like it existed. The judge might dismiss this case with prejudice. And that
stands at recess.
All right.
Oh.
You see it?
He just up and left. Now he up and left to think this one over, because he's got a dilemma on his hands. We're going to skip forward a little bit because we were 7 minutes behind. Let's see if he comes back. He's still gone. He's still gone. Okay, now we're live. He's still gone. So here's what happens. I don't know what this crime is about. Okay, we don't know the offense that was charged, but we have a defendant and we have a victim, and there were charges that were filed, and there were other people involved aside from the prosecutor who was there right now. The other people involved met with the defense team, and it appears that, at least to the defense knowledge, they were told, hey, if you do X, Y, and Z, including a psych eval, then this will be dismissed. They did it. Okay, we're not even talking about the videos yet, about the videos coming in. The video of a video, I think best evidence is late ad. I don't know. That might come in. I think either way, they have the body cam video of the video being played. But defense believed they had an agreement and acted as if there was. He's going to go check case law. The problem is the victim under the law has the right to be consulted and on the agreement, which he wasn't. So now we've got two people's rights being trampled, right? We've got the defendant who has done everything they're supposed to I'll set up Daybell right now. Has done everything they're supposed to get this to go away. They've complied with all the things that were laid out for them. And then the victim, on the other hand, saying, wait, if you do that, I don't get justice. And the judge now has to divide the baby. Where do you do that? This is crazy. I wonder how long he's going to be gone. The evidence doesn't matter at this point. They made a deal, and the defendant got their part of the deal. I think the defendant's going to win because you've got attorneys vouching for it. The best thing that prosecution can say is we can't find any record of that. The fact that you forgot to make a record or somebody didn't make a record, it doesn't mean it didn't happen. You've got the other side, a meeting that occurred, actions that took place because of it, and it seems a bit far-fetched to say that a defense team contrived this scenario where they would say that prosecution offered them a deal and then step through all the steps that prosecution normally would request and then say, see, we took action. That to me is not believable. To me, I think there was probably a deal. There was probably something discussed. It looks like this was a problem on the side of the prosecution where they didn't do the paperwork right, or there was miscommunication there somewhere. But I think the defendant might have this case dismissed. And if it's dismissed with prejudice, that means it cannot be refiled. Okay? That means it's gone. It's done. This part of your life, it can't be brought back up to haunt you, at least from a legal perspective in court. If it's dismissed without prejudice, which we often see in this court where you're not able to get the witnesses or things like that, the charges could be refiled at a later date. So Judge Simpson is out consulting the books and maybe phoning a friend saying, hey, help me out with this one. I've never seen something like this. It seems like something so basic to record an appearance. But they apparently, the defense counsel says that in a prior meeting that somebody from the prosecutor's office has vouched for and acknowledged that the deal was out there. Okay, so you've got that confirmation from the prosecutor's office, even though it's not the prosecutor who's at the table there, and defense and the defendant all seem to be on one page, and now prosecution, because they didn't talk to the victim, is on another page. So I think prosecution loses out here, and sadly, the victim as well. Okay. What day is it in the Chad Daybell? Are we on day 8? I cannot type today for some reason. Here we go. There we go. Okay, public. Just go into top mark. All right. Judge is still gone. He's been gone for about 10 minutes. It's day 10. Day 10. All right. Thank you very much for that. Just getting up the feed for J-Bell. We'll be set to go. Sorry, guys. Thanks for your patience here. There we go. And I'm going to make it go live, even though we're just on the splash screen. Sorry, I'm trying to make it perfect. All right, Chad Daybell's, at least the pre-thing is live. I didn't add day 9 to the title yesterday. I'll need to go back and fix that, Ashley. I can do that. Let's see. Witchy Mama, did you see my question? Are you the one that sent me the text about the Ohio trial? I was not looking at the questions here. Just one second. Let me scroll back up. Was it a super chat? First of all, let me do this while we're waiting for the judge to come back. Okay, Tish, a member for 15 months. Tish is one of our great moderators. Did have real life calls, and as all my moderators know, real life comes first. Tish, we love that you're here. We're here for you as well. Thank you very much. Great to have you here. Congratulations on 15 months. Can't wait to get back to the best chat ever. Thank you, Tish. Thank you so much. And Melissa Bartholomew says, love my true crime fam. Thank you. 11 months for Melissa as well. Let's see. Witchy Mama, I'm trying to see your comment. Dang thumbs. Looking for your question, Witchy Mama. Just one second. I'm a little behind here. I did not see it. You might have to type it again. I'm partially transparent. Hey, I am. Should we fix that? Oh, wow, I'm really transparent. What would have caused that? We'll fix this live so you guys can see how that works. I need to connect to my other switcher. Close that one. Need the ATEM Mini. All right, here we go. Switcher, palettes, upstream keyer. See, that's a foreground, right? Oh, that's bad. That's bad. My camera got knocked around too. I think that's better. I could have a blue shirt. Do you think a blue shirt looks better than the green? I think green's pretty good. I like this color. Background. Neighbor's dog's going nuts. Judge still not back in court, by the way. Key edge. Oh, there. That's more transparent than it needs to be. Okay, there we go. We're fixed it. I think that's pretty good. We'll keep that where it is. Thanks for the heads up, Lee. All right. Can't connect my Sony cam to OBS. Do you use a USB cable? Vicky, I don't use OBS. I know OBS works with a lot of stuff, but for me, it's a bit. It's redundant because I use hardware instead of software. OBS is software. I don't use USB cable. I use HDMI. So if your Sony cam is an HDMI out, you would need an HDMI to USB converter, which a good one runs about $300 from Magewell. Is probably the best that works 24/7. You can just run it nonstop and it will never stop working. It's really good. One day of floating head. You like your YouTubers transparent. It's tough when you have a green shirt on and you have a green key behind you. And as daylight changes, as different windows are open and closed in my office, it changes things. I have Star Trek sparklies. I do right up here. Let me see if I can. They're a little harder to get rid of. Just one second. They're bugs. Ghosts in the machine. Let's see. Okay. Let's see if the spill will take care of this. Nope. Is that a flare? Nope, that's definitely not it. It's going to be on the foreground then. That's the best I can do here. I'd probably have to change my lighting, change the angles of some of my lights to get it any better. So we're going to go back while we're waiting for the judge to walk back in. I'm not sure what he's going to rule on, whose rights he's going to trample. Vote for the floating head. I could have this box, like in theory, I could have the box be gone instead of having a courtroom. My head could just appear like it's floating over whatever we're watching. But it seems a little. I think I've actually done in the early days. I think I did a live stream with just my head floating over the video. Tammy Dunlap, Tammy made this shirt for me. It has a Courthouse with RA on it, a nice logo, and she chose the color. I think it's fantastic. She did a great choice. We are right now, we're waiting for Judge Cedric to come back. We had a bit of a spicy moment where the judge has been made aware of a situation where the defendant was told they had a deal, they had a plea deal, and the defendant complied with everything, with the ultimate result of the complying should have been the case being dismissed. But now the prosecution is saying, we never made the deal. And she's gone to all the efforts to comply. And so the judge now has to decide if he forces the prosecution to honor the deal and dismisses the case, or if the defendant is just out of luck and has to face the charges. Let's see. Michaela Haney says, so glad to have this chat on RA. In reality, I've been here for about 6 months. Wonderful. Thank you. Yeah, the courthouses generally lag behind how long people have been here. I will dispense with the floating heart over on the Daybell case. I will do that. And I'll also make it full screen. Sorry. Just 1 second. I just saw that went full screen. There we go. Okay, so there's the better view. If somebody could figure out how to change my settings to always have the live reaction turned off by default, I would love it. And I let me just say this as well. Apparently, we are 10 people away from reaching 4,000 subscribers on Top Mark Media, which is really cool. I'm excited. All right, let's see. We have Kowalski, J Hatch, and there's the right one. Not made for kids. Customization, live reactions off. Okay, fixed. Floaty heart thing is gone. Thanks for the update. Let me know as soon as that starts, as long as we have audio. That would be great. All right. Are you going straight through YouTube Studio on Top Mark? Vicky, I go through... no, I actually use StreamYard. StreamYard costs about $50 a month for the version I use, which allows me to do multiple streams. So StreamYard currently is running the JHatch counter, which is this right here. So it's running that a live stream on Top Mark Media's channel. And then it's also running the Chad Daybell case as a separate live stream on Top Mark Media's channel. And like tomorrow, in addition, it will also run not at the same time as Chad Daybell, but it will also run the podcast on the Recovery Addict channel. So I have a bunch of different channels that it can feed to, and it can actually do them multiple at a time. So what I do is I feed I got to 4K. Ashley, thank you. That's awesome. That deserves a party. 4K on Top Mark Media. But we got, we take the feed as an input as a shared screen in StreamYard, and then have no other cameras or audio turned on. So it only brings that audio in, so I don't get like dings from my computer or clicks or updates or anything else. Thank you for the last 10 subscribers who just subscribed over on Top Mark Media. That is my channel. That's my company name that I operate under. So Recovery Addict is operated under the Top Mark Media brand. And when we do court filings, when we have cases that we are following that, hang on 1 second. I think the garbage man's here. I just need to make sure the cans are out. It's in your YouTube studio settings. That's why you're going to have to turn it off in YouTube Studio when you set up to schedule, unfortunately. I know that's how I can turn it off, but I wonder if there's a default. Oh, Judge is back. Judge is back. Or will be very shortly. Let's see what his ruling is. Everyone's just sitting quietly in court. The cans are out. The garbage cans, not the kids. The kids like watching the garbage man. Okay, the judge has to make a ruling here, and he should be out in just a moment. One of the problems with StreamYard is it's impossible to have a default monetization enabled on StreamYard. So every time I do a stream, like the other day when we did our big interview stream with all the people that came on, it was cool. We had lots of watch hours. Probably, I think we had 12,000 views, something like that during the course of the live stream. Not monetized. So I don't get any ad revenue for that because I did it through StreamYard and forgot to go in and then change the settings to make it monetized. The frustrating part as well is that people get ads, but I don't get monetization revenue. So YouTube just collects the money and doesn't share if you don't do that. Let this be a lesson. Get everything in writing. Yeah, there's no writing here that the judge has to make a decision on. Amy, have fun on the Daybell case. We are streaming it over on Top Market Media. It should be starting here in about 15 minutes. Some great people over there watching right now, getting set to follow the court through today. And the judge has changed the schedule for Daybell. I think he skips the afternoon break and now ends trial around 3 o'clock local time. So, thoughts on Prism Live Studio? I have not used it to detect vids. It sounds like, is it similar to StreamYard? Or is it similar to OBS? I changed it after the fact, Vicky, after it was all done. But let me see. What day was it? What date was Friday? Was it Friday that the video was? That was Friday the 19th. Yeah. It's monetized now, but all the views didn't count. It's closer to OBS. I'm a big fan. I like OBS for what it does. If you run it on a PC with a powerful machine, OBS can do amazing things. So if that's your setup, it allows you. First of all, OBS is virtually free. It allows you to do a lot with very little, but it is very processor intensive or memory intensive. And so if you have a sort of like an older machine or something that doesn't have a lot of RAM, a lot of CPU power or graphics power, you're going to be having some poor results with OBS. If you got a good machine, it's incredible. I know some very big streamers who swear by it. For those who want to see the things, I use 3 plugins: TubeBuddy, 1 of 10, and is YouTube monetized? Oh, man. I think prosecution's going to lose out on this one. I think the judge, the questions he asked led to the decision. He's like, the problem is the defense thought there was a agreement, and they took action as if they thought there was agreement, which means that they believed a contract was in place. So if you study contract law, that's a big part of if it's just verbal and one side acts as if the contract is in place, that goes a ways. I mean, both sides have to act as if the contract's in place, and I think they have enough evidence that both sides did at one point act like there was a contract in place. When it comes to StreamYard, there is no easier way to bring guests into your live stream that I know of. It is amazing. The quality, the lack of delay, the ease of using virtually almost any equipment. I mean, Android phone, no problem. iPhone, no problem. iPad, doesn't matter. Samsung phone, MacBook, any way. You just click the link and you're in. It just works. And I really like that. But it does not shine in the audio department when you start trying to do tricky things. We're not sure exactly what this defendant is charged with, but what we've been able to glean from the discussion in front of the judge is that whatever the crime was, it took place outside the defendant's house and was caught on Ring cameras in HD. The officers who responded used their body cam to film the Ring camera being played back. I'm not sure if it was on a phone or on a computer, but there is some video of the Ring camera footage being viewed, and then obviously the defendant was arrested. Now, recently, the original video in HD has been downloaded from Ring, and the state is trying to admit that, which, should be pretty interesting. But the defense is objecting because it was admitted late, and they have not viewed the original high-definition videos, although they have viewed the old body cam video that shows the police officer watching the video. I have not, Dog Lover, I have not talked to Dr. Joe. I've not reviewed the sanctions from the Maya case. As far as I understand, it's the IJ and the interest money, everything else. We've still got the counter running, and we're, honestly, when it comes to the counter, we are one day away, where in the next 24 hours, we're going to hit $5 million in interest, if that is still accruing. So that's a big benchmark. I think there's another meeting that's going to be scheduled in the Maya case, or has been scheduled. I hate it when the Ring camera catches me in high def. Yes. How many times has Ring been used in court? It's just not going to be used in Karen Reed's, right? Or is that too soon to bring that up? Suspiciously, it didn't catch anything. August 1st is that date, says Alita. Chris, there's no way to see how long you've been here. If you've been a member, if either a gifted membership or you've purchased a membership, the courthouse next to your name, in your case it's green, it changes colors on a set schedule. So the first month it would be blue. The second month it would be, I think, green. It changes. Let's see. First month is dark blue. Second month is light blue. Third month is green. Like, I think Brandy's in the second month here. I think you're in the third month, Chris. Then at the 6th month, it goes yellow, like Nurse for God right here. At 12 months, it goes orange, and it sort of slows down. But eventually, I think it's the 2-year mark, it goes purple. I think that's the top. Dr. Joe wants to talk to you about August 1st for information. Awesome. Let me know. Does he need some equipment down there? Oh, Shark, thank you very much. The term you described in contract law where you take action based on the assumption of agreement is called detrimental reliance. Did I explain it properly, or am I a little off on that, Shark? Please feel free to straighten me out if I got it a little wrong. You can go to the membership tab on Recovery Addict home screen. It will tell you how long. Speaking of membership anniversaries, Silky Mom, congratulations on 5 months. As you can see what your months are with the free member chat. Right there, 5 months. Tomorrow is the podcast, by the way, for those that are familiar or unfamiliar. Thomas and I, Thomas is Weather Watch right here. He's one of my great mods. We'll be yakking it up again in the evening. We've had some great guests recently, but we're going to be having a lot of fun tomorrow with you also, with your appropriate comments and commentary, as it is a live podcast. So look forward to you guys joining us tomorrow. Lots of different ways to check where you're at. If you're a member. If you're not a member.
District Court for County of Washington, State of Michigan, is now managed J. Center.
You may be seated. You may call another matter before I go back. Court does call the case of People versus Angel Wilson.
Assistant Prosecuting Attorney Morgan Barossa on behalf of the people. Would you like me to do the waiver, Your Honor?
Yes, please.
The people waive the potential conflict in the Honorable Court and Public Defender's Office. We do not believe that any conflict is
Lots of papers.
Bridget Coons on behalf of Ms. Wilson. We likewise do not believe that a conflict of interest exists under court rule or state law. However, we do make this waiver out of abundance of caution and would waive any conflicts of interest.
And the court for its part, also does not believe there's a conflict either in the Michigan court rules or the cases decided there under to the extent a conflict exists. Given the waivers, the court will consent to hear the matters. All right. We're here on
Laura, thanks for
bond
13
violation.
months. Tomorrow, Troy, happy hump day.
They're
7 months
on the violation.
And also 7 months for Christina's the problem. Good info to know. Thank you.
Did you get the new report?
Yes, I did, Your Honor.
Dressed for court appropriately?
Is there anything you want to say before I?
Yes. Well, I'd like to start off. Ms. Wilson is a 22-year-old. She's very apologetic to the court. For the initial violation, she was upfront and honest about the dirty blow. And she admitted when presented to her.
The dirty blow?
There was a delay for the tether, which I believe is what you're referencing on the report. The day of court, she did, that was April 17th, she did go to community corrections, but because she had her child with her, community corrections do not allow kids within the facility. She did not have a babysitter at that time, and she wasn't able to get the tether fitted that day. On the 18th and 19th, likewise, she did not have a babysitter. She also does not have a valid license right now, so she is not able to drive herself to the facility. She relies on others to help her out with rides. So that is why she wasn't able to get the tether fitted until Monday. She was going to try to go on the weekend, but since the community corrections is closed on the weekend, she wasn't able to do that. She is working full-time, works at EHM Senior Solutions in Saline. She's been there for the last 4 years. She works, she also is enrolled inside school full-time, inside the nursing program, and she's a full-time mother. She has no one to really help her with watching the kid during the day. So we'd be asked that she be allowed to continue on bond while this case is pending.
Anything from the people?
We leave it on the court's discretion.
The problem that I have, Wilson, is that on the 17th, you admitted to the violations. I set the sentencing out to today. In the interim, because there was a dirty blow, I had told you to report to community corrections to get on a scram tether immediately. That was on the 17th. It was not until Monday of this week that in the late afternoon on Monday that you put yourself onto a scram tether. I'm trying to figure out why.
Can I talk? Yeah. I worked both.
What'd you say?
I worked Thursday and Friday, and yeah, I have my kid up until I go to work. And I also didn't know that my son couldn't go in there because I went over there after court. And
I understand that, but that was on Wednesday.
Right. And then I worked Thursday and Friday, and they weren't open the weekend.
Did you work Monday?
No.
Then why did it take you till 3:50 on Monday to get there?
Drop my kid off to his dad, or he can come get his kid. That's why.
So she usually starts work at 3 p.m. until 11:30, and that's whenever the father of the child takes the child. Before then, she is usually watching the child.
Well, not watching.
Tell me how I know that you weren't drinking over the week. I mean, young lady, you're here on a drunk driving case. I put you on a sober line, right? alleged blood alcohol content was 0.085. There was an accident.
Just over the legal limit.
During the course of this, you're not blowing when you're supposed to, and then I have a dirty blow. I should have sent you to jail that day, and I didn't do it. And I didn't do it giving you an opportunity to maybe show during this week that you could exist with a scram tether, not drink.
I'm confused with the last part you said, because I got the tether.
Oh, I know.
Oh.
5 days late. So I guess the record's clear. Between the time of the 17th to the time you got the tether, you didn't blow into a sober link either.
Yeah, because the device locks. I didn't know if that was because
Because you were supposed to probably be on a scram.
Right.
And she did inform me of that. She did inform me of that yesterday when she tried to test on the sober link on the 18th. It gave her an error that it had to be reset.
And you did nothing.
Kevin, congratulations. 7 months.
Bring my
Cool
kid in there.
stories,
I can't.
But you did nothing. And then let me ask you this. Do you not take this seriously at all?
I do take it serious. I'm busy. I'm a very busy person.
No. That's
okay.
And that's not an excuse.
We all are.
But it's kind of inconvenient for me.
No, it's getting worse.
That doesn't mean that I'm not doing anything. I've been coming to court
This is all inconvenient. It's all inconvenient because you decided allegedly to drink, get into a car, and have an accident. That's all inconvenient. But if true, no one in this room is the cause of that inconvenience except you.
Right.
Here comes
I
revoke
think her
bond.
youth plays an age inside this. She's only 22. This is her first criminal case.
I'm not even 22 yet. My birthday's Friday.
So she's 21. This is her first criminal case. I do think that going forward, she's going to take this very seriously. Whenever I talk to her.
But Ms. Coons, I appreciate that. But at what point? Because if you look at this report, I have 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21. Well, let's say 20 violations of basically, well, actually, it's not quite that many. It's about 15 violations of the program itself in terms of when she was supposed to blow. Then on the next one, she drank. Then, even after that, that was on April 5th. By the time we get the report, she reports back to court. I have on April 6th, she didn't test during the time frame. On the 7th, she didn't do any test. On the 8th, she didn't do any test. On the 10th, she did not test between 7 and 10 as scheduled. On the 12th, she didn't test on 2 occasions for her testing that day between 7 and 10 a.m. and 2 to 5 p.m. She didn't test as scheduled. On the 13th, she didn't test between the 7 and 10 a.m. She did do a makeup test an hour and a half later. On the 13th, she didn't test between 10 and 1 a.m. as scheduled. She tested at basically 2 o'clock in the morning on the 14th. She was negative. On the 14th, she then on that day still didn't test between 7 and 10 as she was required to do. And then basically 40 minutes later, after the testing window, she tested. And then later that day on the 2 to 5 test, she didn't test as scheduled. That was on the 14th. That's just this month. And then she appears before me on the 17th. I give her a break by not remanding her and tell her that she has to get a tether. And then I get here, I'm now and set this out to the 24th. And now I get here and she's too busy and it's inconvenient. Really.
I can understand the court's frustration.
Oh, I'm not frustrated. I'm just, I don't get frustrated.
Yeah. Well, she does have the tether on, so it would negate any further missed test, Your Honor. If she's able to continue on to bond.
So I'm just supposed to say, don't follow anything I told you to do.
Absolutely.
Just go on your merry way.
No, absolutely not. But when we spoke, she did state that she'd like to continue this case. She'd like to stay out in bond. She's able and willing to comply with all further court orders.
How do I know that?
I've been coming to court all year. I haven't missed the court date.
Yeah, you're right. You haven't missed a court date. You've missed a lot of tests. You miss going to community corrections. You went there when it was convenient for you. Young lady, that's not how this works.
I mean, I didn't have a choice. I can't bring my kid in there.
I get the 17th. You needed to find a way to make an arrangement on the 18th and 19th. You didn't do it. In fact, so that we're also clear on the 19th. On the 18th, community corrections talked to you that day. Mm-hmm. And you told them that you would report to them on the 19th.
Yes, because I thought I could, but I couldn't.
That's a Friday. Mm-hmm. And you didn't report on the 19th. You didn't call to reschedule or offer to them, according to this report, any explanation for your not reporting. You just didn't show up.
I think she's going to spend her 21st birthday in jail.
And then on Monday, even if I accept your rationale that you were working and that in terms of working, you couldn't make it, even if I accept that rationale, which I don't, Monday, you weren't working and you still didn't go until late, actually after the agent that's assigned to your case at community corrections had left. And you're lucky that somebody else there stepped in and put you on a scram tether. Because otherwise you'd be showing up today with no tether. And mind you, the person that did that did it after the agent that's assigned to your case had terminated you from community correction supervision because you weren't compliant. Anything else?
And further, nothing further, Your Honor.
The other case has been set back. It's going to be handled next. It's not a good start when this goes between the two.
Hey, you're going to have to learn to just pay attention. When court tells you to do something, you're going to have to do it. This isn't all about you. Everybody has busy lives. And I can appreciate it when I see people try. What I see in this report is somebody that's not trying. That somebody is putting other priorities ahead of what your obligation to this court is and what your obligation to this case is. And again, allegedly, you made the decision to drink. You made the decision to get into that car. You made the decision to drive. You made the decision to have that accident. So the sentence of the court, defendant remanded to the Washtenaw County Jail to serve 5 days for the violations to date. Mr. Allen, you may take her.
Her 22nd birthday is on Friday. I think that's what I heard, and she will be spending it in jail. 5 days. Yeah, the bailiff moves into position in case you get a runner, right? It is a tough lesson.
Are you leaving? Will you do me a favor and hand a copy to Ms. Barroso? Counsel, you may want to read that.
I wonder if the judge did some research on the agreement. Maybe he made a phone call, tried to sort of get down to the facts of the matter.
Yeah. You guys got through that. You got through what the communication I have. All right.
That is not correct.
What's not correct?
That she did not complete it.
That what?
That she did not complete it. I went back through my emails, and on February 8th, prior to the February 9th final settlement conference, I forwarded along what Ms. Coombs sent me about what Ms. Julian had done to Zappa Reiser and asked her if this passed muster for an offer, if there was one extended, and I never received a response. There was nothing from Ms. Reiser. There was nothing documented about an offer. There was nothing documented about a dismissal in our file. Without anything documented in writing about an offer or a dismissal, we appeared the next day and we had the conversation in your chambers about how I didn't have any information about it, and without any confirmation, I did not feel it was appropriate to dismiss the case, so it was set for bench trial, especially with the victim being present on that day.
Okay. So, okay.
Your Honor, I have an email here from Ms. Combs to Ms. Julian on December 8th, and it specifically outlines the plea offer, no contact with the victim, no violation of state law, and get a mental health evaluation. And then I also have a mental health evaluation that was done on the 28th. And then a follow-up from the mental health coordinator on February 1st. And
I don't think the people are, I mean, from what I'm hearing, she's not disputing.
That was conveyed to Ms. Reiser. I just did not receive anything saying that that was an offer from Ms. Reiser, that was confirmed. I understand that Ms. Coons is saying that there was a Teams message on the day of final settlement. My understanding that Teams message was not explicit that that was the offer that was extended. I did not understand it that way.
Your Honor, if I can, I laid out the offer inside the Teams message and I said, can you confirm this is the offer? To which Ms. Reiser replied, yes, that is the offer. To which Ms. Barroso had replied, the victim did not consent to that, and that was the issue.
And then it wasn't until February 9th, which is the day after the 3-month period had run, and Ms. Julian was coming to court thinking that her case would be dismissed that day, when the rug was pulled out from under her and the offer was supposedly withdrawn.
On what day?
February 9th.
I'm not disputing any of that. I'm doing the best with the information that I have that was not confirmed to me.
I mean, the agreement was that she completed
Folks,
the 3
folks, everybody stop. Everybody just stop. I get what the agreement is. I have now this communication from Ms. Reiser that's her recollection of the agreement. I also have at least confirmation in my understanding that Ms. Julian did what she was supposed to do under the agreement of the parties, or that was between the parties at some point. The issue here, however, is, I guess, that the victim did not or wasn't consulted about it. But that's not what I am taking, and I don't know if we need to have Ms. Reiser here. This is certainly her recollection, but specifically in the communication she sent, Ms. Reiser was of the belief that the victim has said that they were okay with that resolution, and that ultimately out of all of this, they wanted to be left alone.
Yes.
But now I'm hearing today that the victim is not okay with that resolution.
My understanding is that resolution was not even raised with the victim as a potential resolution.
Donna, the victim was at the final settlement conference. From my recollection, there was a conversation on what his position was at that time of mental health and the no contact, and it was a creative solution. The plea was.
But you were, I understand what you're saying, Ms. Coons, but you weren't a part of that communication. You believe that there was a communication that may have taken place either with the victim's advocate or with Ms. Rice, with the alleged victim in this case. Is that right? I mean, you're giving me your impressions of what you thought a conversation that happened.
Correct.
Betsy Jean, thank you so much for 5 memberships.
And on this day, I'm presuming the victim is here.
Yes, he is.
He is not okay with the resolution that was.
After all of this, he says whether we have the trial today and go forward with it or dismiss it, he's going to just be seeking a PPO. He says he's just tired and just wants to be left alone. So if we're not proceeding today, that's fine. If we are proceeding today, that's fine. He's been run through the ringer. He just wants to be left alone and will be seeking a PPO, whether it is stipulated to or not. That's all that he is caring about at this point.
And based on that and everything else, Your Honor, I would move to dismiss.
Well, I have to deny your motion. Okay, I could dismiss it. Because the agreement, there's an acknowledgement of the agreement, but And I had my staff check to, because if the agreement had been placed on the record, then everybody would be stuck with it. It wouldn't matter. But so my understanding now, I guess, based upon what you said, Ms. Barroso, is that the victim in the case
who might be
is
in the courtroom
indicating exactly what Ms. Reiser has said. They said that they just want to be left alone.
That is the first time he has said that today. In all of my conversations with him and all of my advocates' conversations with him since I was speaking over the case, that is the first time I have heard that out of him. But at this point, he's now appeared 3 times and he's done.
Well, maybe, maybe not. What I'm inclined to do is, your client was trying, I don't know if she was trying to say something to you. She may want to mute the microphone if she's saying something.
They haven't had contact in over a year and a half, so it's not like, she's stalking him or trying to get a hold of him. She doesn't want contact with him either.
Hey. Can I talk? No?
Well, here's what I'm inclined to do, folks. What I'm inclined to do, and I be very careful how I say this, but I'm inclined to disallow the evidence that was just provided and excluded from any trial, and just proceed to trial on the matter. The parties can't come to some resolution. In doing that, I want to make it very clear that I'm doing that because defense counsel just got that information, but in no way am I making that ruling attributing that there was any indication that the Pittsfield Department of Public Safety or Officer Richler was attempting to try to not provide that information. And I say that because this officer's been before me for a couple decades, maybe. I don't know. 20. So right after I started. So a quarter century. Anyway, and has always been forthright, would not engage in anything to withhold anything. I would see it as being an error, but that error in terms of it happening and then ultimately getting corrected has inured to what may be a not a benefit to the defendant, and certainly may cause, so I haven't seen the tape, so I don't know, but may cause some issue. So what we'll do is I won't allow it. We'll proceed to trial. And you guys have 15 minutes to get yourselves ready, and fortune position.
50 minutes, we're going to start trial. It's not being dismissed. Defendant's frustrated. The victim doesn't want anything to do with this. The victim might not show. One Man Army says, I'm just too busy to give more. I'm sorry to be in such an inconvenience to you, One Man Army. That is hilarious. Thank you very much for your generous super chat. Love it. Love the humor as well. Wow. So I don't know why when the prosecutor hears from the victim saying, I just want this to go away, whether we go to trial or we don't, I just want it gone. Why then does it not get dropped? Clearly going forward to trial, probably not the best. The victim then has to testify. It extends this problem. He has to then face the witness, who I don't think he's even in the courtroom right now. Why does it not just get dropped? We've clearly got the defendant who has taken steps which may have bettered the situation or improved the situation or at least brought some resolution to the situation. It's a clerical error, But instead, we're going to trial, but not with the HD. We're going with the body cam only. Body cam only. Very similar to the case yesterday. The older brother did not want to be there in court. Simpson doesn't believe the victim. Simpson disallowed the high-definition video, which so the Ring commercial will not be played in court. Get the feeling you had already seen this trial better. Nope, it's happening live. We've got 15 minutes. Hey, Siri, set a timer for 12 minutes.
It's starting now.
All your timers are going to go off in 12 minutes. We'll be back. We'll be back to Judge Simpson's court for that one. We'll see what happens. They might drop it. They might do what they did before and say, hey, we tried to get our victims and witnesses here, but they're not here, so we have to move to dismiss. Judge Simpson has some great videos. Bench trial. I believe it is a bench trial. I don't think they have a jury there. We do get a little light cases. We always have a few light cases between the big ones. We just finished the Kelly case. That was a long one, with the Apple River trial being inserted in the middle of the Kelly case. So two sort of big trials back to back, and now we got a few days of break here. I want all the footage and the evidence. What case is this? A larceny? Larceny case, I think. Under $200, $400, something like that. It's a small case. What was the guy's name in the Thurston trial? Farag or something like that? Yes, I think it's Faraq was his last name. I have not seen him back. And I've never seen him picked up on the outstanding warrant that he has for just skipping out on court at lunch. All right, let me see who else is out and about as far as that goes. Let's see. Just saw an update on Twitter that an attorney represented a group of people who want to protest outside the Karen Reed trial, the courthouse, has filed an appeal to saying that the buffer zone that the judge put in place that puts a space limit on how close they can come to the courthouse is unconstitutional. Interesting. I think there was some pretty good argument on that. And I thought the judge did a fairly fair job of, and I say that because you have to think about what happened A, this morning, B, yesterday in that trial. This case, the Karen Reed trial, has some very vocal people on both sides. And that entryway into court seems to be like a gauntlet you have to run. And I believe the jury has to run that same gauntlet. Is that true? They might have a separate entrance. I'm not sure. So, interesting. What do you guys think about a buffer zone, about protesters? As a general rule, I don't like it. I don't like the buffer zones. I don't like the time, place, and manner restrictions that are placed on free speech. But I also feel that, some protests are just plain right offensive, and I think at what point do we say you have to subject yourself to this gauntlet because it's their free speech when they're required to go there by law, when they're subpoenaed and have to be there? Is there some sort of agreement? Can't we all just get along? Hold your signs, say your piece, don't be offensive. For safety reasons, I feel it's okay in certain instances. I think legally, that's where the law stands on that. So I think the challenge will probably be upheld, although it might change the distance. That judge is atrocious. Interesting rulings, I'll say that. I haven't followed all of them, but it does seem like some of the rulings have come in suspiciously. All right, let's see. Betsy Jean, thanks for gifting the 5 memberships. I had it up on the screen, didn't get a proper shout out to you, but I appreciate that. Kevin M. said, I'm getting closer to 1 year. Started with the Cavalcante escape, and now I'm dating someone on his defense team. Weird how life works out. That is funny. Bug Duggar also gifted 5 memberships in there. And Appreciate all your generosity. If it's really about the case, the buffer won't matter. Courts always refuse to uphold buffer zones. Clinics, why should courts get them? Well, it quickly we get into the politic realm here, so we're going to try to steer clear of that a little bit. But there's a buffer zone at elections, safety and no pressuring voters. Yeah, buffer zones exist, and they've stood up to challenges in some situations. But I think I wish we could just be better people, and in the way we protest, not make it a safety concern for the people who were protesting. All right, something's funny out in the hall. Let's see what we got. All right. Parole hearings are up in Louisiana. That's the new board. I'm not sure if they're doing any better there. Warren County Common Pleas Court. Lots of Chad Daybell all over the place. Funny news, well, interesting news. The Federal Trade Commission today banned non-compete clauses. And you say, what's a non-compete clause? In some industries, and I saw this when I worked in the media. When you work in the media, as a term of employment, you sign a contract saying, when I leave this job, I won't work for a direct competitor for the period of, 12 months, 24 months. And the FTC basically just struck those down. So that is going to be challenged in court. But it makes it so that you don't have options without moving. Yeah. Pap says, I have a non-complete. Wow. A non-compete. Well, FTC banned them. That just barely happened. And I saw the news this morning on my email feed. So there are going to be some challenges to that one. I've seen it in the news media. A lot of times you'll have an anchor, right? Somebody who's been the face of, let's say Channel 13. I've been the morning show anchor on Channel 13, and I am the face of the channel. When I quit, if I went to a competing channel, I said, hey, I'm Channel 7, here I am. I'd like to be your morning show guy. The non-compete clause would say I can't do that in the same market for an extended period, so that Channel 13 can rebuild their brand, and I wouldn't be associated with that. And I can't just take people who followed Channel 13 because of me and my face. I can't just have them drag them over to Channel 7 with me because I'm the person you want to watch. He had non-competes for years in tech. All you guys are like, thanks for the heads up. Submitting my application to the competing company as we speak. It is terrible for workers. It will drive up wages. Because it makes competition in the marketplace. Yeah, media jobs are much more limited where you can go unless you want to really move markets. It's tough. Let's see if Judge Wolf is live really quickly. You mentioned Judge Wolf. Let's see what he's doing this morning. He's been gone for a few days. What's up with that? He is live right now. Looks like he's doing some, are they arraignments? Just one second. Oops.
Full name for the record.
Shyla Michelle Hardy.
Pardon, you're here today charged with violation of your probation. Do you understand you have a right to plead not guilty and to have a hearing in this court where the state would be required to prove to the legal standard that you had violated your probation?
Yes, sir.
You understand that you would have the right to have a lawyer and to have one appointed as we've done with the public defender?
Yes, sir.
You understand if we had that hearing and I found you guilty, you could appeal whatever you did, whatever I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir.
You understand that by pleading guilty, you're waiving your right to a hearing and to that appeal. All I'm going to do is approve what your lawyers worked out. And that's going to require you to serve 60 days with credit for time served and then be returned to supervised probation with these additional conditions. Do you understand that?
Yes, sir. Yes, sir.
Do you wish to plead guilty according to this agreement and waive your right to that hearing?
Yes, sir.
Then upon your plea of guilty, I find you guilty, order that you be revoked to serve 60 days in jail with credit for time served. Your order to then be reinstated to supervised probation with the additional requirements and conditions of your probation. That one, that you undergo an alcohol and drug assessment and follow the treatment recommendations. Two, that your drug screens will be required of you on a monthly basis for the remainder of your entire sentence. A single failed drug screen would be zero tolerance as a special condition and require a violation against you. Three, parenting classes are going to be required that you attend and complete.
Ooh, parenting
and four,
classes.
Mandatory in-person reporting for the remainder of your sentence. Those are the conditions of the court. That's the judgment of the court. Thank you.
Thank you, sir.
Brittany Parker, page 6 of the docket.
For those that are asking, and I got this thanks to my wonderful mods, Franklin Tucker trial.
Parker, you are
next date is
here to be
June 17th.
Arraigned on an indictment charging you with possession of methamphetamine with intent to sell or distribute, simple possession of or casual exchange, and unlawful drug paraphernalia. You have the right to a lawyer. Do you wish to have a lawyer represent you?
Yes, sir.
Public defender will be appointed.
Wait, one reading the indictment here, plead not guilty.
Plea of not guilty is entered. Trial date, General?
Your Honor, trial date would be August the 14th for trial, August the 12th for plea.
August the 12th is your last day to enter a plea, and August the 14th is going to be your trial date. Public defender has been appointed. Mr. Hooper will be over to speak with you and get you ready for your trial.
Your Honor, if I may, I think she's in Williamson County. Is
Are you in Williamson County?
Yes.
Be in Williamson County.
I'm sorry.
You guys hear that duck?
How long will you be in Williamson County?
I have court there Thursday, and I think I'm supposed to get out. I'm not sure. That's what my lawyers are telling me.
Before you leave, I'll make sure you have my contact information so you can contact me if you're released, okay?
Yes, sir.
Thank you.
Thank you.
So
Elgin 5, page 6 of the docket.
Non-competes are going away.
Ms. Five, I filed an amended violation on her this morning.
Ms. Fye, you're here to be arraigned on a charge of violation of probation, plus there's an amended charge of probation violation that was just signed this morning. My understanding is that you'll be served with that as well. We're going to give those. You wish to have a lawyer represent you?
Yes, sir.
Public defender will be appointed.
Enter plea not guilty.
You're not guilty is entered on both the original and the amended violation of probation, and it'll be set for hearing on June 26th. Public defender will come talk with you and get you ready for your hearing in June. Thank you.
Thank you, sir.
Ashley Redstadt, page 6 of the docket.
All very respectable. We're about to jump back over to Judge Cedric's court as soon as he pops back on live. So hold tight. We might have a trial here. We'll interrupt these.
All right. Ms. Redstadt, I've been handed a document indicating that you're going to enter a plea of guilty to admit your violation of probation, be revoked, and placed on community corrections, but you will remain in custody until you are picked up by the drug court to be transported to the renewal house to complete a one-year rehabilitation as a condition of your community correction. You will be required to undergo drug screens at least once a month for the entire sentence and report monthly for the entire sentence. A single failed drug screen will be a zero tolerance, requiring a violation to be filed. One missed meeting will be zero tolerance. You will be under pre-2021 guidelines for community corrections. Any violation will result in resentencing, and you're required to follow the aftercare recommendations of the rehabilitation for the entire sentence. Do you understand that to be the agreement?
Yes, sir.
All right. Raise your right hand. Let's place you under oath. You solemnly swear from the testimony you're about to give in this case to be the truth and nothing but the truth, so help you God.
I do.
State your full name for the record.
Michelle Redstadt.
You can put your hand down. Ms. Redstadt, you heard me go over what the agreement is. Do you understand you have a right to plead not guilty to the charge of violation of probation, to have a hearing in this court where the state would be required to prove to the legal standard that you have violated your probation?
Yes.
You understand if we had that hearing, you would have the right to have a lawyer, to have one appointed. Of course, we've done that with the public defender. You understand that if we had that hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals, and you would have the right to have a lawyer appointed to help you with that appeal.
I'm gonna cut away from this just for a second.
You understand that by pleading guilty, you're waiving your right to that hearing, to that appeal. All I'm going to do is approve the agreement as I read it out to you just a moment ago.
Yes, sir.
Okay.
You understand everything I've explained to you?
Yes. Yes. And you're still going to plead guilty? Yes. Yes, you are. Okay. So let me bring this up. You guys had some questions about the non-compete. This is from the Federal Trade Commission, the news feed from the Federal Trade Commission, Protecting America's Consumers, dated April 23rd, which was yesterday. I'm going to go ahead and read this to you, and then when court comes back from Judge Simpson, we're going to jump to that. But here's what we have. The Federal Trade Commission's final rule will generate over 8,500 new businesses each year, raise worker wages, lower healthcare costs, and boost innovation. This is under the heading of FTC announces rule banning non-competes. Today, the Federal Trade Commission, this is yesterday, issued a final rule to promote competition. They issued the preliminary rule back in January. A final rule to promote competition by banning non-competes nationwide, protecting the fundamental freedom of workers to change jobs, increasing innovation, and fostering new business formation. Non-competes clauses keep wages low. They suppress new ideas and rob the American economy of dynamism, including from more than 8,500 new startups that would be created a year once non-competes are banned. Every year, 8,500 new startups, said FTC Chair Lena M. Khan. The FTC's final rule to ban non-competes will ensure Americans have the freedom to pursue a new job, start a new business, and bring a new idea to the market. The FTC estimates that the final rule banning non-competes will lead to new business formation growing by 2.7% per year, resulting in more than 8,500 additional businesses created each year. The final rule is expected to result in higher earnings for workers, with estimated earnings increasing for the average worker by an additional $524 per year, and is expected to lower health care costs by up to $194 billion over the next decade. In addition, the final rule is expected to help drive innovation, leading to an estimated average increase of 17,000 to 29,000 more patents each year for the next 10 years under the final rule. Non-competes are widespread and often exploitative practice, imposing contractual conditions that prevent workers from taking a new job or starting a new business. Non-competes often force workers to either stay in the job they want or leave or bear other significant harms and costs, such as being forced to switch to a lower-paying field, being forced to relocate, being forced to leave the workforce altogether, or being forced to defend against expensive litigation. An estimated 30 million workers, nearly 1 in 5 Americans, are subject to a non-compete. Under the FTC's new rule, existing non-competes for the vast majority of workers will no longer be enforceable after the rule's effective date. Existing non-competes for senior executives, who represent less than 0.75% of workers, can remain in force under the FTC's final rule, but employers are banned from entering into or attempting to enforce any new non-competes, even if they involve senior executives. Employers will be required to provide notice to workers other than senior executives who are bound by an existing non-compete that they will not be enforcing any non-competes against them. In January 2023, the FTC issued a proposed rule, which was subject to a 90-day public comment period. The FTC received more than 26,000 comments on the proposed rule, with over 25,000 comments in support of the FTC's proposed ban on non-competes. The comments informed the FTC's final rulemaking process, with the FTC carefully reviewing each comment and making changes to the proposed rule in response to the public's feedback. In the final rule, the Commission has determined that it is an unfair method of competition and therefore a violation of Section 5 of the FTC Act for employers to enter into non-competes with workers and to enforce certain non-competes. The commission found that non-competes tend to negatively affect competitive conditions in labor markets by inhibiting efficient matching between workers and employees. The commission also found that non-competes also tend to negatively affect competitive conditions in product and service markets, inhibiting new business formation and innovation. There is also evidence that non-competes lead to increased market concentration and higher prices for consumers. Alternatives to non-competes. The commission found that employers have several alternatives to non-competes that still enable firms to protect their investments without having to enforce a non-compete. Trade secret laws and non-disclosure agreements both provide employers with well-established means to protect proprietary and other sensitive information like customer lists. Researchers estimate that over 95% of workers with a non-compete already have an NDA. The commission also finds that instead of using non-competes to lock in workers, employers that wish to remain employees can compete on the merits for the workers' labor services by improving wages and working conditions. Changes from the NPRM. Under the final rule, existing non-competes for senior executives can remain in force. Employers are prohibited. I'm going to skip ahead a little bit there because that doesn't apply for most of us. The final rule defines senior executives as workers earning more than $151,000 annually and who are in policy-making positions. Additionally, the commission has eliminated a provision in the proposed rule that would have required employers to legally modify existing non-competes by formally rescinding them. That change will help to streamline compliance. Instead, under the final rule, employers will simply have to provide notice to workers bound in an existing non-compete that the non-compete agreement will not be enforced against them in the future. Let's see what the date is. See, the commission voted to approve the issuance of the final rule 3-2 with Commissioners Melissa Holyoke and Andrew N. Ferguson voting no. Commissioners' written statements will follow at a later date. The final rule will become effective. This is important. The rule will become effective 120 days after publication in the Federal Register. Once the rule is effective, market participants can report information about suspected violation of the rule to the Bureau of Competition by emailing noncompete@ftc.gov. So 120 days after publication in the Federal Register. So look for the Federal Register, the posting. I mean, this is the press release here, but I'm not sure if this counts as the press release. And 120 days after that. So there's your update on your non-competes. So now what Thomas says, I can go mod for law and crime now. Yes, I guess all you mods are released from the non-compete. We didn't have a non-compete. We had a share and share alike clause. That's funny, Thomas. That is really, really funny. All right. We are waiting for Judge Simpson's court to start, which is a couple minutes late. I zoned out. Say that all again. Tisha, if you work in a job where your boss made you sign a non-compete, meaning you are not allowed to go work. If you left your job, you're not allowed to go work for the competition for 12 months, 2 years, something like that. It's gone. The FTC says that's not legal anymore. So that'll be interesting. This will result in higher wages because if your boss knows that you can't work for the competing company for 12 months and the other company says, hey, we'd like to pay you more, he knows you can't go. He could sue you if you go, right, and win. And so he doesn't have to pay you more. But now, knowing that the competition is paying more and that you can go legally under this new rule, odds are he'll pay you more to keep you. Or she'll pay you more. I'm saying he, she, but the genders don't matter there. I'm changing my channel name to Recovery Addict, and everyone is allowed to follow me there, says Vicky. Love it. I love it. Willows in the Winds, good morning from the Coffee Club. Thank you, Willows in the Winds. Good morning to you as well. I see pines in your profile, though. I love willows as well. We're waiting for court to start in this spicy little case up in Judge Cedric's neck of the woods. So give us just a minute. It should be beginning momentarily. It's interesting. Never liked non-compete clauses. I didn't like them either. I have good friends that were in the news industry. Actually, that I went to school with. There's one girl who's incredibly talented. And she went to work for a news industry. First, she went, your first job, you always end up somewhere like Montana or Kansas. I'm sorry, there's nothing wrong with those locations. But as far as markets go in the media world, they're smaller. it's an entry level position. And so she went and she sort of did her time and, earned her way into the business, proved herself in one of those markets. And then she went to a major market in the top 25. And I got a job at a radio station or a TV station that I had worked at previously before. And she's great. I mean, I literally helped film her demo reel for her first job. And she does a great job. She did phenomenally there. It wasn't the best working environment. She didn't like it. She wanted to switch to another channel, and she couldn't because of a non-compete. And so instead of moving somewhere else, she quit the industry and waited the year for the time to go run out. And once the year ran out, then she was able to start work at another industry right there in the same market. But non-competes are different from non-disclosure agreements. Can you comment on that? Yes, non-disclosure agreements are still legal. Say, for instance, I have a really good business idea for an app. It's a really fun game, and nobody else is doing this, and I've got this idea, and I say, look, I'll tell you about it, but I need you to sign this non-disclosure, meaning that you won't go tell anyone else about it. You won't do anything about this. That's legal. If you sign that, and then you go somewhere and tell somebody else, and they make the app, I could sue you and win lots of money in theory. Those are still legal, and your company could still do that. That's to protect their interest as far as trade secrets, as far as protected information. Customer lists often may fall in this, because if you leave and go to competition, the last thing your boss wants you to do is take the book with you, right? The book of all the customers, and like, hey, we've moved. I know all your old pricing. I know all your old deals. We know what you do as a business, so we're just going to transfer you over, and it's a new company, but it's the same face here, okay? And we'll get you a better price than they were giving you. That would be a violation of a non-disclosure. I get everyone I work with to sign an NDA, says Vicky. Amber's here. Amber, are you announcing your 2-week notice to go work for the competition now?
No. You are the competition. What are you talking about? And I'm pretty sure Chat would agree with me. I just kind of wanted to add my 2 cents in here, because I understand the concept behind the non-compete. I understand not wanting former employees to go sell trade secrets or the recipe to the secret sauce. I get that part. However,
the
for
13
people like me,
spices and herbs, if you're KFC, right? Yeah, that's the secret. That's the trade secret. You can still protect that. Go ahead.
Vicky's looking for mods on Recovered Addict.
Vicky, it's one thing to go and do your own thing, but to poach on my channel for mods, that's something else.
I myself have been subject to a non-disclosure, non-compete. And what's funny is that I had an NDA agreement and a non-compete, so it was like they were double dipping. And unfortunately, I was offered a better paying position doing the same thing I was doing for a company who valued my skill set more and was willing to pay that to me, but I couldn't do it. Otherwise, I would have been sued. So I think this allows for a lot more room for companies to actually essentially go on bidding wars to keep employees, because not every employee is the best employee to keep, right?
There's a flip side, and let me argue that for a little bit, okay? Because as an employee, as someone who's been an employee, I'm thinking, this is great news. My paycheck's going up, or I can finally go work for the competition who's been trying to steal me away from my company for all this time, and it'll be a better environment. I get to work at a little bit more than what I like. This is great news for the worker. There's a flip side, and yes, wages will go up, but guess what? Corporations don't foot the bill. They always just pass it on. So when wages go up, prices also go up, and so they're going to be a bump on both sides. Most people will say it's a net win for the worker, and I think it is, because it gives them flexibility they didn't have before. Anytime you can get somebody in a job that they like over a job that they're stuck in, I think you're going to have higher productivity. I think you're going to have happier workers. I think overall it's a win. But there is, on the other side, it's not like all roses. It's not all good. For other people, prices are going to go up a little bit because you have to pay the employees more to keep them now. But I think being a good boss goes a long way to keep an employee, and not all of that is money. Obviously, everyone works for money, right? But a lot of times people want recognition. They want some flexibility. They want to be able to be to experiment and get credit for what they do and improve their environment. They want a little flexibility and a realization that, home is important too, not just work. And a good home-life balance. If a good boss, I think, will be able to keep their employees through this anyway.
I think so too. I mean, it comes down to loyalty, not just one-sided loyalty, though. I mean, I'm loyal as an employee in any job I do, and I often end up wearing more hats than what I'm hired for, and then I end up getting taken advantage of because I offer to do all of these extra things without the pay.
Can I share an experience, a story? Sure. I worked for a company where they should have had me sign a non-disclosure or a non-compete. They didn't. I worked my way up from literally being a temporary employee that was brought in from a temp agency just to fill a position for 2 days. Within about 3 months, I was a shop foreman in their shop, and that's very quick. I became a safety inspector for the whole plant. I moved from when I got up to that position in the plant, I transitioned over into sales, worked my way up from a junior salesperson to a regional salesperson. And this is over the course of about 9 years. And I never, throughout any of that, signed any non-disclosure, signed any non-compete forms. But at the end of the day, I had the books. I had the master price list of whatever the discounts we gave every customer, what they were paying, how much they bought, where they lived, all the contact information. And when I left that job, and I left because I didn't like what they wanted me to do. It turned out to be an environment that I wasn't really happy with. Basically, I wouldn't take customers to strip clubs. And the customers complained because the previous person in that job would. And I said, hey, that's not something I'm willing to do. And so I left. I quit. And I still had all this information. And immediately I get contacted by a competitor who was in the area and said, hey, come on down. And I came on down. I'm like, what's up? I drove to their place and he walked through the plant and they said, we'd like you to be our senior sales exec. And it was made clear without actually saying it that we'd like you to bring that information to our company so we can steal their customers. And I said, I can't do it. I didn't have any legal. Oops, sorry. Court's starting here in just a minute. Didn't have any legal obligation to comply, but it was the wrong thing to do. It was the wrong thing to do. And I told them, I appreciate the offer, but you're not hiring me because of my skills and abilities and what I can bring to the company other than this competitive information that belongs to my former company, and I don't have any right to give to you. But anyway, Judge is back. Amber, we have to let you go. Sorry.
Okay, the last thing I wanted to say before you took off on story time is it's actually going to hold companies accountable to their whole mantra.
Jeff Hall,
how good they take care of their
I hear
people, but their
you.
people
Judge is talking. I've got to let you go.
Okay, bye.
Thanks. Bye.
Thank you. All right.
Patricia, Vice President, Assistant Prosecuting Attorney. Your Honor, I'm sorry to intervene, but could we approach for a moment?
Why don't we go into chambers?
Okay.
We're staying in recess.
Amber, call me back.
All rise.
Is that the lady who made the deal? The lady who made the deal is here now, saying, "Judge, sorry, we need to talk before we move forward." They're gonna go back in the judge's office. I didn't see the victim there. But Amber, call me back. I'll let you finish your thought. Is that okay? We could have paused that for Amber. I know, but we like to take it live. It was live in the moment. We'll keep watching. I'll keep the audio on from the judge's court. I miss the Green Sky trial. Very short. Probably the shortest we've ever been on the record in any court right there. Judge always has a non-compete with all callers. He gets precedence and privilege. A Chambers resolution. I think we're going to hear what the resolution is. But let's see. Hey, guess who's on the phone? Guess who's calling us? It's Amber. Amber, talk quick.
Okay, that was hilarious. So just to wrap up my last thought is that a lot of companies say that they put a lot of investment into their people when they really don't. I've worked for plenty of companies, as I'm sure many others have, where they advertise that they take such great care of their people, but yet their people aren't compensated, aren't treated, aren't.
Our greatest
aren't
asset
given
is our
anything that they're
employees, right? You've seen the sign on the wall, and the employees
Right.
are complaining, and there's high turnover. And it's just
Vicky is saying she would never cut off my call. She's kind of working hard to get me to be a mod for her.
Vicky. How do we? Let me just time out Vicky for just a couple minutes here.
I know, all right, you might have some competition.
Vicky's great. I loved having her on the other day, getting to meet her face to face and hear her analysis and commentary. It was really good. She's, I would be up for competition. That's great. Free Vicky.
Vicky would give you all the airtime ever. No. There's a reason I don't have there is a reason I don't have my own channel.
I hear you. This will force companies to behave a little better, because
I really think so.
And it's not just we focused on the working for the competition, but honestly, the American dream, the idea of starting your own company, of doing your own thing, being your own boss, that's sort of like the pinnacle of the American dream, right? It's like I want to do my thing and I want to do it my way, instead of working for the man and getting wages and maybe making some good money. I'd like to be the one who decides and really puts my idea out there and see if it will take flight. And so the FTC has said that we expect 8,500 new businesses, which will be able to start a year now that these non-competes are gone. And under those new businesses, they looked even further and said those new businesses, obviously, they're creating something new, or they're trying to do something different. Very few of them are just going to try to do the same thing the other company did and for cheaper. That's not a good business model. It fails over and over and over. But the innovation that you find in new companies like that is really high, where you see the creation of that's why they say that we'd see new patents come out, we'd see new products, we'd see companies who look at things a little differently than the big company has for all these years. So I think it's a win. But
I do too. Ashley's saying that there's a lot of spice happening over in Daybell if you want to swap over. But I'm going to hang up now because I have a meeting to jump into.
You don't want Judge to cut you off twice. So.
No. Well, the judge didn't cut me off. You did.
Technicality. Thanks, Amber. Good to hear from you.
Not a
Thanks
problem.
So much.
Bye, guys.
Bye. Amber, thank you. I appreciate the call. Sorry I cut you off before. I say that with you, not on the phone. Vicky, with your new channel, I'd love to be your first guest. So I can poach back all my employees, all my mods from your channel. It'd be awesome. Okay, so we're keeping an eye on what's happening in Judge Cedric's court. Let me just pop in really quickly with Chad Daybell. See if there's anything happening here.
Judge, at this point, I've got the report of his Officer Greenow. With the court's permission, I could give it to the bailiff. He could take it to her and she could scroll through. I think that would protect in terms of being able to refresh her recollection about the report, if that's acceptable to the court.
All right, I'll let the prosecutor take a look at that first before it goes to the witness to make sure it's appropriately identified.
I'm not sure. They're trying to refresh recollection. It's always fun when they refresh recollection.
See? That has... And I could have printed it off.
You guys are shopping between people. I'll mute you if you don't play nice. I love it.
Mr. Pryor, we've got that report also admitted as an exhibit. If that's
okay. We're gonna jump away from Chad Daybell for a minute. Let me say this, and I kid you not, because I've helped many people and I'm willing to help many more people. I get a lot of phone calls from people who say, how do I do sort of what you're doing but different? Or how do you solve this problem? I'm trying to set up my channel. I run into this issue. How do I resolve that? Is there tech that will make XYZ happen? I love to help with that. Honestly, I love to help. I'm not a consultant. I don't get paid for my consulting there. I really do feel, and I apologize for getting close to the politics line one more time, but I really think that the more involvement we have in the process, no matter where you're coming from, the better the end result is. So I feel that YouTube in general, LawTube adjacent, is better with more voices. And with different voices. If we all say the same thing, it's not better. But I love the variety. I love hearing other people. That's why I do support channels that do things very differently than me, that allow things that we don't allow here, that will look at cases that are probably outside the realms of what we look at. I think it's better. I think it makes the environment better. I think it gives more. I think more options are better for viewers, even though. Yes, in the short term, I think it might hurt me financially if I'm telling people about channels that they might like more than mine. That's great, but I think it's a better fit. So I'm a big fan of that. So Vicky, go at it. Name your channel Recovered Addicts. I think it's great. I think there'll be some cross advertising available there too as well. Mike Fenn says $20 says this trial doesn't happen with Judge Cedric Simpson. Let's see. Jokes aside, I already said from the start that I will not be live at the same time as RA or Brandy. That's a hard one to keep, Vicky. It's a hard one to keep. Because we all follow day trials. And if you're following U.S. trials, they happen at the same time. I would say instead, let's just be friends. And cover it the way you want to cover it. I'll cover it the way I want to cover it, and it will work great. I do try with Brandy. I think we've got a more of a special relationship between our channel and Brandy's, and I try not to cover the same cases that she's covering. We have covered the same ones before, when times are lean and there's not much else out there. But I have a lot of respect for Brandy, what she's going through, and with the grace that she's approaching it with. So. That's the only person I have that agreement with. Everybody else, it's a free for all, and I just love all the commentary. All right, Craig Perkins says you recommended 2 channels. I checked them out, and here I am. Craig, thank you. I love that you're here. Appreciate that. All right, the Treehouse case. What's the state doing? June 17th is the next date for the Franklin Tucker trial. That's the Treehouse murder trial. Retrial, we have a new judge. There's been some talk of possibly trying to get this new judge off the case, getting him dismissed as well. I'm not sure where that's at. Franklin Tucker has his own channel on YouTube now that I think he's providing some of those updates on. Still think he's going pro se, that he's defending himself. He thinks he can do the best job doing that. Nobody knows his case better than him. He, quite frankly, had some good advice and counsel from some good lawyers, so the things he did before were pretty spot on, or very close to, even if it wasn't polished, what a professional, defense attorney might have done in his case. So he might do. I think he's the best pro se defendant we've ever seen. He has some character traits that might challenge him, that make it challenging for him. But I have a non-compete with Brandy. It's consensual, though. It's consensual. Are there cameras allowed in court in other countries? Not Canada, I think someone said the other day. Not to the same level. I know UK just barely started allowing some cameras in courts, but I think they only show the judge. So we're interested in seeing where that goes. I personally, because of the language barrier that would be involved, I'm not really interested in countries that don't speak my language, because I'm not up to learning another language to follow a crime, a court case. That for me is a little too much. So unless technology can come a long way really fast and do instant language translation for me live, that'd be something that I wouldn't be following personally. Trias Judge's staying was ruled on the last hearing. Thank you, Psychosaurus Rex. Appreciate it. I love the name, by the way. The new judge will stay. That's good. I think he was a good judge. I think so far I haven't heard anything bad about him. You see the case out of Monroe, Michigan, with the 66-year-old woman who drove drunk to the birthday party and killed 2 children. Yes, I think they've already sort of put a defense out there that there was either her leg cramped or the the gas pedal stuck or something like that. That there was they're not going with the I was drunk and didn't know what I was doing defense. They're saying it was something more technical or medical. Here the media sets up their own mics and cameras so the audio is at least top notch. Vicky, I love it. All right. Is the Treehouse retrial is actually happening on what channel? Court TV. KRAB, it probably will be followed by maybe Court TV and possibly Law and Crime. Also, some local stations down there in Key West might air it as it's sort of got more. It's sort of grown, right, as it's up for a retrial. More people are interested. More people have heard about it, so the interest is higher. Scroll up to find my question, please. You see it still goes unanswered. I'm scrolling up. Since you ignored it the first time, I have to repeat myself. Since you have had every job ever, when do we get the stories about your time as a male dancer? Anyway, that's... I haven't had every job. I will definitely put that on the list of one that I have not ventured into. They're saying seizure for the woman who was driving drunk. Yeah. Leg cramp and steering wheel stuck, seizure. That's going to be a hard one to prove. I could tell you the live bomb story. We could. The judge is taking forever in chambers. If you ever leave YouTube, please don't forget us. I have no desire to leave YouTube. This is the most rewarding career change I've ever made in my life. As far as personal satisfaction for what I'm doing, the community, just the feeling like that what I do matters a little bit. It's been very beneficial for me that way. Did the judge stay the trial? What does that mean? It's funny when court uses weird things, weird names. Because you have words like continue. The lawyer says files for a continuance. You would think that they want this to keep going, when actually it means to move it out. And when a court stays, it means the proceedings stop litigation from continuing. So stay is stop and continue is stop as well. How about that? But a stay is temporary. Officially, the definition says a stay is an action taken by a court to stop a legal proceeding or the actions of a party. So a stay may have been issued with the court, say in Judge Boyce's courtroom with Judge in the BK trial. If he had issued an order saying don't do any more telephone surveys, that would have been a stay, an order to stop doing that. Or maybe there temporarily was one in that case. Does that help? Male dancers dance all the way to the mailbox. Amy, some of you guys jump in at the wrong time. I can use technology to make my shirt disappear. So technically, I guess I'm halfway there as far as qualifications for that job. Congrats on having a career you love and created a community that reflects your values. Recovery Addict. Jamine, thank you very much. That's very kind of you. I appreciate the support as well. It's a community I discovered. You guys are already out there, and we just sort of discovered each other, so it's really cool. All right. Kate says, RA in chat, thinking of a job change myself. Anyone have experience as a legal transcriptionist? Would love some advice. Yes, we had somebody was on yesterday who just barely started. Brand new first day on the job, did their first transcription. Legal transcriber. I don't have any personal advice that I could give you on that one because I have no experience there. I can barely type. And even that, the B key doesn't work very well for me. So, Rob helped me find you. Rob is amazing. One of the pillars of LawTube, as I like to describe him as. But also, I love his balance, like his work-life balance. He works a little hard, right? A little too hard, but he understands the importance of creating something. And for him, it's woodworking. And I mean, it's amazing. I have a pen that he made for me personally. That, I mean, he planned it out and made the pen specifically. He didn't like pull something out of stock. He's like, oh, I'll send him this one. He found out. He literally called. He talked to me. He found out what I was interested in. He did some research on me, and he designed a pen that fit me perfectly and fit my life. And then sent the most amazing handwritten note to go along with it, explaining why he made the choices he did in the pen design, even to the type of wood and how he treated the wood. But just incredible guy. I've rarely heard someone who can give a compliment or express sympathy more sincerely than Rob can. Just an amazing individual. And incredibly generous, especially to our little channel. Rob's pens are pretty. It's not just that they're pretty. It's the meaning, the work he puts behind them give it a huge added value in my eyes. It's not something I could sell. Mrs. Ari, do you want to talk?
The thing I love about Rob is that he just, I can't think, like, what's the opposite of scarcity mentality? I can't remember what the word for that is, but that's what he has. That he has such a sense of there's plenty for everyone and it's going to be fine and everything, room for all, everybody welcome. We're so glad that everybody's here. He never at any point does he get panicky and feeling like, oh no, I can't tell other people about, anybody's channel or what they do well because then I might not have enough. He's just very generous and he's like, it's going to be fine. And he very welcoming. So I like that. He really affects the mood of all of LawTube.
It's true. He's awesome. Thank you, by the way. Sorry. Thanks for joining me.
Yeah, it's cool.
Did you come in here because it's warmer in this room?
It's way warmer in this room.
It's because I've got all these devices who are trying to cool off.
I know. I don't know what's wrong with our house. I don't like turning on the heater because it makes me sneeze a lot, but it is cold everywhere else.
Abundance mentality.
Abundance mentality. That is what it is. Yes.
Opposite of scarcity. Thank you for that, Karina. And he's welcoming. He's amazing. He's funny, and he's witty. He's fun. Great guy. Love Rob. I did see him on with Hogue the other day. That was really cool. And just anyone who knows the history and what happened there, and the amazing support that LawTube overall provided for when Hogue had his stroke. It's cool. And you throw Ian in there with what Ian does philanthropically. It's really cool.
What I really like about Ian is that he is very well balanced emotionally. Like he just doesn't, I don't know. I've never seen him completely go off the rails and freak out about things. He's able to look at really hard subjects and be able to talk about them in intelligent ways without getting emotional, even though the subjects themselves they are personal, they hit home. And so it's easy to get emotional about them, but he just doesn't. He has a very Canadian approach to that. He's just very positive without getting all riled up. I like that.
Yep. Ian's a great one. Plus, he recommends really, really spicy food.
Does he?
Like not just scald your tongue, but like blister your tongue. Just he has a steel stomach. I think amazing. The heat that he can consume on a daily basis is phenomenal.
Ian Does he do like the hot chip challenge?
Ian gets animated about some of the things that he's very passionate about, and firearms are one of them. And when somebody is spouting things that are not true, or pretending that they know something that they don't, when it comes to firearms, he can really lay down the law. It's pretty good.
I have not seen that.
Anyway, and runkleisms are the best. Yes, he has the best runkleisms. I have not watched much of his gaming stuff. Really, I haven't.
Scott's in recovery.
I'm in recovery, so there are some things I just don't. I've seen him play a couple games online, but he's a spice extremist and a good one. I love that he dives deep into some technical stuff sometimes. That is a lot of fun because I like. I think if I hadn't been interested in law, I would have probably followed a path of a technical writer or a technical proofreader maybe. I like that sort of stuff. Kevin, I've thought of covering cases outside the U.S. It presents a lot of challenges, Kevin. The idea intrigues me from both a technical standpoint and just from the novelty of it. But I don't have a lot of familiarity with how courts work in other countries. So I would be at a severe disadvantage. I would need to partner with somebody that could probably help me both with access and with understanding when it came to that. But there are some cases that you hear about in the news internationally that you'd be like, wow, I'd love to be on a fly on the wall in that case. But just without knowing how they work and how to get access, or if you can get access, that's the challenge. Ian is Runkle of the Bailey. That's his YouTube channel. If you don't know, he's a great one.
Do we know what that means, Runkle of the Bailey?
I've never asked him the meaning of that.
Because a Bailey, in my mind, has to do with like a place where you make alcohol. But I'm not sure if that's even accurate. I don't know what a Runkle is.
He's just Ian Runkle.
Oh, that's his name. Oh, yeah. So then I don't know what...
His last name's Runkle, but I don't know what of the Bailey...
I don't know what that means.
He also has Rule of Law, which is more his gaming stuff, I think, right? He's the Runkle. The Runkle. I don't know the Ode to the Bailey. Ian's Ode to the Bailey. Who's the Bailey? Runkle of the Bailey TV show. I think I grew up without a TV, so you guys are all getting this reference. I have no idea. It's a British TV show, Runkle of the Bailey.
Oh.
The only British TV show I've ever heard of is like EastEnders.
Spam, eggs and spam.
No, not that one. The Detectorists. The Detectorists is my favorite TV show from Britain. Anyway, we're still waiting for court to come back in up here with Judge Cedric Simpson.
It's private. Well, it's just us and our closest 1,000 friends.
This case, it should have been dismissed like 3 times, I think. What we have going on is the defendant, I think it's a larceny case, as our understanding. The defendant was filmed committing the crime on Ring cameras, okay, outside the victim's home. The victim reported the crime. The police came. The body cam image shows the police watching the Ring camera footage. And that's being admitted in as evidence. But then you also have like the original high definition videos, which were just barely admitted. And the judge said it's too late. It's too close to trial because today's the trial date. And so those are not coming in. You don't get the HD Ring camera. But the issue was last year, the defendant met with someone from the prosecutor's office, and the prosecutor extended a deal to them and said, if you do these following steps, one of which was included getting a psych eval, then we'll just dismiss the case. And they did those steps. And now the prosecutor is saying there was no deal because the victim was never consulted on that, had never agreed. And so they're trying to backtrack and yank the rug out from the defendant, who is expecting the case to be dropped now, and now it's going to trial. And the judge is, trying to weigh the whole thing is like, well, do I violate with the expectations of the victim who's complied with everything they were told to do by this deal, which really didn't exist, or do we violate the rights of the victim who has a right to weigh in on any plea deal that's offered? The victim has said...
Well, would the victim be okay with this deal?
He's okay with it just going away. He wants to be done with it. He says if it goes to court, fine. If it doesn't, fine. But the prosecution is not dropping it.
Okay, so the victim wants to drop it, and the person who's being charged wants to drop it, and everybody's done everything they want to do except the prosecution? They're bored? Need to do something today?
Yes, I think so. I think it would just look bad on them if they went out and it was, if it was widely broadcasted that they made a deal with a defendant without the victim approving it. That's not a good look for prosecutors.
Yeah, forcing them to go to court against the victim's wishes is also kind of a bad look.
But which one publicly looks worse? And it's really just a clerical error. I think the record, first of all, the record was not made on the prosecutor's side that a deal was extended. So all the records came from the defense side, and they do have receipts showing that there was this deal.
That the prosecutor signed.
The prosecutor never just informed the victim and said, hey, what do you think about this deal? That's all they needed to do, usually before you extend the deal. It didn't happen.
I hear that, but if the victim's okay with it right now, this doesn't make any sense.
Elfin says, Aria, the Bailey is the name for British High Court. There was a TV show called Rumple of the Bailey. He was a criminal defense lawyer.
So you're saying that this is really, really witty, if only we know the references.
Yes. Old Bailey is the highest criminal court in England.
Oh.
And Ian being in Canada.
Close enough.
And the British monarch rule and all that. So, yeah. Good stuff. All right. It's really witty. It's extremely witty. Much wittier than Recovery Addict. I can tell you that. All right. Nothing coming in. We covered already the FTC announcing that non-compete clauses were illegal. They announced that yesterday.
What?
Yeah. Non-compete. When you go to work for somebody and you sign a non-compete order saying I won't work for any competitors for 12 years in this market area, or 12 months after I quit or I get fired,
That's
the
now illegal?
FTC said no more. You can't do that anymore. There's going to be a like 120 days after it's published in the register, they become illegal. And the way they handled it and say, because instead of requiring all lawyers to rescind their non-competes, all they have to do is inform the employees, which usually is done by a sign in the break room. Honestly, this is how they do it. They put a sign up in the break room that says, we will not be enforcing non-compete violations.
You're talking about lawyers. I mean, are we talking about like
News media.
Apple?
Like, yeah, you work, well, non-disclosure agreements are still valid. So you can still protect trade secrets. But just saying you as an employee, you worked for Tesla, now you can't go work for Ford in their electronics car division because, for 2 years after you left Tesla.
Right.
Now you can, day one, go work for Ford or switch over to Tesla if you want. So it's pretty cool. It applies to everybody except for top executives who are involved, earn over $151,000 a year and are involved in policymaking. So executives can still have a non-compete, and they in theory know a lot more about the company and have those inside trade secrets than somebody else.
And so how does that impact you?
Well, Vicky is going to go and make a channel called Recovery Addict, and she's going to solicit mods from our channel and pay them more.
And, that won't be too hard.
Yeah. Anyway, it's funny.
I mean, does that impact what you do for a living? Does that affect our ability to get video or anything? We don't. It doesn't affect anything in the law. It's more affects how employees and employers interact. Specifically, once they cease their employment agreement, what the employee can do and what the employer can prevent them from doing. So interesting. I think I'm definitely on the side of let them live, let them play, do whatever.
It'll mean that there's higher wages because you can now literally poach your competition's employees.
Oh, corporate espionage is going to go through the roof.
It's going to be great. You can poach your employees, which for the employee, if you're being fought over, generally it means your pay is going up.
Yeah.
Okay.
Or you're going to get hurt.
Well, no, your pay's going up. That's what we're going to focus on. For the end consumer, there will be a slight increase down the road of
cost.
Cost. If it costs more to make something, including hiring the people who make the thing, then the thing is going to cost more at the end of the day.
This is fascinating that it is actually possible to outstrip your target market, that what you are offering is better and better and better and better, all the time better, and it costs more and more and more, and your target market eventually just gets priced out. And so even though what you're creating is better, nobody's there to buy it because nobody cares about it that much. I watched that happen in education, and that's a really fascinating arc that they have gone on. But it could also happen with widgets.
Widgets are the perfect example for any business model. Mr. Fix-It says, I'm just going to change my name to Scott. I think it's better than sleeping a Holiday Inn. Mr. Fix-It doesn't want to be adopted anymore, I guess, now that the NDA or the non-compete clause thing is gone. Mrs. R.A. is incredibly well read. I respect her knowledge in just about everything. Unless
Did you guys hear that little just about everything?
Unless we disagree, and then I'm right.
What happened with Karen Reed? Are they not starting yet?
Karen Reed, the news of today, I think they're still trying to see. They're trying to get to 20 jurors, and they have 19 maybe.
Lance, do they need all of us to be on the jury? Like, what's their cap?
They need a lot of jurors. They need a lot of jurors because they don't have the ones they want yet, I think.
That's understandable.
The news today is that the protesters outside the courthouse, through their lawyer, have filed an appeal saying that the buffer zone on the courtroom or on the space they have to stay away from the courthouse violates their constitutional rights to free speech. And so they're trying to either eliminate the buffer, which will get them right next to the courthouse doors, or maybe reduce the buffer, which will make
I bet JLR helped that situation. Oh, is that a not talk thing?
We went all morning without saying a name.
Oh my gosh, the rules on this channel are stifling. Sorry. Okay, I guess I don't know anything about that. Sorry, guys.
This is why we can't have nice things, guys.
Sorry. I thought you were going to talk about that.
We did, and we didn't mention any names. We were very,
that's
very,
not a name.
very careful.
That's an acronym.
Yes.
I don't even know what it stands for.
It's his name.
I don't know what Runkle of the Bailey stands for. I don't know.
You guys, I have all these rules, right?
I know. I'm sorry.
You'd think they'd be easy to follow. I have asked that we not talk about individuals specifically. I've said that I don't approve of the type of behavior that happens. Look, guess who's back to save us in the nick of time? Judge Simpson.
All right.
I'm sorry.
Washington District Court for County of Washington, State of Michigan is now back in session. The applicant, they said it's
You may be seated.
I'm just going to take this.
The court recalls the case of the people versus Stephanie G.
Prosecuting Attorney Morgan Barroso on behalf of the people.
Jeff Hall, on behalf of Stephanie Julian.
All right. And there's been a in-chambers conference. I'm going to adjourn the trial out to, what date is that?
May 1st.
Jury trial to May 1st, 2024 at 9 a.m. That's a special time.
A special time. We got adjourned. Boo.
Just to put it on the record.
Yes.
If I get the order signed before then, the hearing will be.
The trial will be canceled.
And the case will be dismissed.
Dismissed. Is that correct, Mr. Hall?
That is correct, sir.
All right, very good. Have that all on the record. Okay, thank you, folks.
Thank you for your time.
So that case looks like it's going to get dismissed. They adjourned it so they can get everything done that they need to there. But I think that was the right thing to do. Sad for the victim, but I think it's the right thing to do. When the prosecutor's office extends an offer, I think they need to be bound by it. All right. Amber just called. I just unplugged the phone and handed it to Mrs. R.A. So I talked to her directly because mods need to straighten Mrs. R.A. out about the rules we have on the channel. But technically on the books, it's now for a jury trial next week. But I don't think it's going to happen. Victims have input on the case, but the prosecutor has the ultimate decision. I agree. In this case, the victim wasn't even consulted. And I think that's the optics of that are really bad. Really bad. All right, let's see who else is up and about in court. Looks like Chad Daybell's on break right now. Yep, on break. Amber isn't straightening it out. She's giving her to Vicky, says Brandy. Oh, my goodness. That was all part of the plan. She's actually just recruiting her. Krista says, I can no longer work under these conditions. I'm going to work for Vicky Mack. I love it. You guys are hilarious. I love this. Krista Johnson live with Mrs. R.A. in 3 minutes. Come through. Do you want me to portal over to you, Vicky? Is that what you're saying? I mean, why not? Why don't we go all the way and just surrender, wave the white flag. Okay. Doing a quick check of court to see who is live today. Obviously, Young Thug is still going. Not interested there. Let's see, Judge Humphrey's criminal. Judge Wolf. Nope, that's not it. Okay. Ooh.
An expired tag.
Judge Webster. We haven't watched
Unclassified
Webster for a long
misdemeanor with a
time.
fine up to $2,500 and 30 days to 6 months in jail. Do you want to look into diversion or explore some other options?
Yeah, let's look into a diversion. I do have a question about that though.
Okay.
About 4 years ago, I'd already gotten a diversion. Does that affect this process now?
The county attorney will have to look at that. They'll look at the existing charge, they'll look at your past record, and then they'll make a decision.
Okay, so I need to apply first before I get that answer?
I think so. I think so. Now, maybe there'll be some instructions on the website that will let you figure that out before you apply.
I'm not sure what iPhone's doing, but
okay.
But if you look at that and decide you don't want it and you want an attorney, let us know. Otherwise, I'm going to expect you to be diverted or reappear July 17th at 9.
we are in Kansas. She's wearing a Kansas State High School.
You do not have an A or B misdemeanor,
trap
so you
shooting.
do not have to have your fingerprints taken.
I think it's a trap shooting club.
Alrighty.
All right, Mr. Regier, is there anything further?
Not on this matter, Your Honor.
Very well, Ms. Montgomery is excused at this time. We'll be in recess on her case.
Thank you.
You're welcome. Now, there's some other people here. I don't know who you are. I see a picture of a lady that says iPhone and some kind of string top. What's your name?
My name is Ladina Fulbright.
Ladina Fulbright. Okay, let's
Dressed
take up your
appropriately for
case.
court. With the ceiling
We'll
fan.
be on the record in 2023 TR 2873, State of Kansas versus Ladina Tamika Fulbright. Jared Regier for the state, Ms. Fulbright in person and pro se. Looks like you were supposed to be here January 17th at 24, but we had problems getting your summons issued for whatever reason. So this is your first appearance. Count 1, the sole count of operating a motor vehicle without a valid license. This is a B misdemeanor. If convicted, the maximum fine could be $1,000 and the maximum sentence could be 6 months. If you're able to get your driver's license and pay some fines, costs, and a diversion fee, do you want to look into that diversion?
No, ma'am. I have license. I had my ID on me at the time, and I did come out there in January. But when I came to El Dorado, they told me that they would mail me a court date, so I left. But I do have a valid driver's license through the state of Oklahoma. I just didn't have my license on me at the time. I just had my ID. I just had an ID.
Well, they are saying that's a different charge if you had a license and you just didn't have it on you. They are charging you with not having any license at all.
Yeah, I have a license. I really, I don't understand how I got charged with that. But yeah, I tried to take my license to El Dorado back in January, and they said they will mail me a court date.
Good. Well, do you want to talk to an attorney? You can hire any attorney of your choice, or you can apply for court appointed. They can help you sort through that. See if you.
What am I don't. Can you explain to me why I need to hire an attorney if I already have license?
Because you're
Well,
charged.
if you have presented proof of your license to the state and they don't find it valid or find that it was valid August 27th, then you're going to need to defend that if you think you did have a license.
So I need to get an attorney to.
Well, if you don't have to have it, let me go through this.
Okay.
You can hire an attorney.
Mm-hmm.
If you cannot afford to hire an attorney, you can apply and see if you qualify for court appointed. but you don't have to have an attorney. You can waive your right to an attorney and represent yourself. What we're looking at right now is the state in an amended information filed October 10 of 23 is alleging that on August 27th of 2023, you were driving in Butler County, Kansas without having a valid driver's license. Now, they're not just saying she was driving without her license in possession.
Right.
That's a lesser offense. They're just saying this lady was driving a car and she didn't have a license, or a vehicle and she didn't have a license.
Okay, so is there an option that I can maybe set a date to come to El Dorado and show them that I have a valid driver's license?
Well, they have the means of running your driver's license through the computer database. And
okay, so
apparently the database is saying you did not have a license on August 27, 23, or that seems to be what they're saying.
Yeah, I've had a license. It's just through the state of Oklahoma, so I don't know if they ran it through Kansas.
No, they would recognize an Oklahoma license. That's
okay. Well, I guess I need to go to Oklahoma and see what's going on with my license. I mean,
I've
been pulled over since then for speeding, and I've gave them my Oklahoma driver's license, so I'm not sure what's going on. I need to find out then.
Well, if you want to waive your right to an attorney and represent yourself, you can contact the county attorney and see what they have to say, or you can get an attorney and let them figure it out. Let him or her figure it out.
Okay. Yeah, I guess I'll see if I can get a court appointed then.
Okay. And are you employed at this time?
Yes.
Where do you work?
I'm a CNA and I work I work in a private home with this guy named Warren.
Okay, and what do you get paid per month for doing that?
$1,122 a month. It's just part-time. Okay. So every 2 weeks I make $561. So $1,122.
Okay, and are you married or single?
I am single.
Do you have any children that you legally support?
Yes, I have 3 kids.
Family of 4. Any other income?
No.
You don't have child support?
No. I get food stamps. I don't know if that matters, but.
Okay. I'm going to appoint an attorney. Are you able to write down his name?
Yeah. Let me see.
Anyone listening, always come to court with pencil and paper.
Yes.
Okay, you ready? It's Darren, D-A-R-R-E-N, Patterson, P-A-T-T-E-R-S-O-N. His phone number is 316.
I'm going to 867-5309.
3227.
Correct.
Okay.
And call him as soon as we're through here and tell him or his staff your contact information.
Tell Darren Patterson my contact information.
Yes, so the two of you can be in touch with each other.
Okay.
My clerk Destiny will send him an order of appointment and give him the court date. When is that? 7/1 Destiny, July 1st?
That's correct, Judge.
You'll need to be back here by Zoom. That's a Monday, July 1st, 8 a.m. by Zoom with Mr. Patterson. But if you call him and talk to him in advance, he probably can tell you pretty quickly if your license was valid on that date of August 27.
Okay, so can I call the state of Oklahoma and maybe get some information, maybe to speed up the process that I have a valid driver's license?
Sure. But remember, it's not whether your license is valid today. That's important. But the charge dates back to August 27 of 23.
Yeah, there has to be a misunderstanding. My license is valid and has been valid, so I'm not sure what's going on.
Okay. Now, it could be that if you're living in Kansas, you have so many days to transfer that. And maybe that's an issue, but that's for you and Mr. Patterson to sort through.
Okay.
All right. Anything further, Mr. Regier? We do need to have her go to the breakout room with $1,000 OR bond. You don't have to put any money up unless you fail to come to court. Mr. Regier, anything further?
Nothing from the state, Your Honor.
Very well. Missy, if you would please put the lady in an iPhone and court security 2 in a breakout room.
There they go.
And then I have a gentleman in a blue shirt, looks like maybe chewing gum in a car or automobile. What's your name, sir?
Chewing gum. That's your request. That's your sign.
Thank you.
Maybe chewing gum in court. Yep, it's gum. All right. We see it. We believe you, dude. Judge Webster does call people out.
Say your last name again, please.
West, W-E-S-T.
Oh, I thought that's what you said, but I'm not finding you. Let me check on the computer screen, see if you've been added.
Some licenses.
Okay, Destiny, do you see a Mr. West on here?
If you move.
Judge, it looks like his hearing was canceled. I'm looking at his case now.
All right, Mr. Regier, can you tell us anything about Mr. West?
If you move and don't update your license to show
Your Honor, I do not appear to have
it may cancel the license.
An individual by that name on my docket. If I could respectfully inquire as to the case number.
Do you have his case number, Destiny?
I do. It's going to be BU 2023 TR 3557.
The Android is checking the computer. iPhone's back. And she's gone.
Your Honor, if I may.
Please.
Your Honor, the state's understanding is that previously there was a summons filed in this matter for today's date and time, April 24th at 9 a.m. However, I am also showing in my file an appearance bond for a hearing date back in February, specifically February 21st of this year at 9 a.m. Based off of my notes, it would appear that the court did take up that matter at that time, at which time the defendant failed to appear.
FTA.
Okay, so you're not showing a dismissal?
Your Honor, based off of my files, I am not showing a journal entry of any kind filed in this matter.
All right.
Thank you, Data. I mean, thank
One
you, sir.
moment, please.
Yes, the guy who testified from his car.
And Destiny, did you tell me that, or tell us that that was BU 2023 TR 3557?
That's correct, Judge.
Okay. All right, my notes show February 21st, 2024, traffic docket, first appearance. The defendant did fail to appear, as Mr. Regier referenced. Bond was set at $300,000, cash or surety required. April 19th, that'd be a few days ago, the defendant and his bondsman were mailed a motion for judgment on bond. So actually,
So you guys messed it up?
nope, we guys didn't mess up anything.
No, I have the.
Hold up,
I have a
hold
lot of
up.
documentation. Go ahead.
Hold up.
Go ahead.
Thank you.
Go ahead. No problem.
I do show the motion for judgment on bond is to be heard July 1st, 2024. And I trust you've received that motion and you've been in contact with your bondsman about it, sir?
No, I haven't contacted any office in Butler County since February 20th, 2024 at 11:12 a.m. I spoke with Nancy. Back in January, I received a letter in the mail saying that I no longer had a court date on February 21st because I would have been there. It said it's scheduled for today with a Zoom meeting. It was rescheduled for you are hereby committed to appear via Zoom, audio visual conference on the 24th day of April 24th, 24th day of April 2024 at 9 a.m. with the meeting ID.
Sir, do you want to give me control of my courtroom back, please? Now, I will tell you the history of this case.
Oh, no. I'm fine. I was just trying to be clear because that $300,000 and all this other stuff is crazy. I'm sorry, man. Go ahead.
Thank you.
Oh, no. Judge Webster's taking a deep breath.
AAA Butler County Bail Bonding posted a professional surety bond for you, $1,500 on November 9th, 2023 for a list of charges, including no registration, operating without registration, operating without a license, operating without proof of insurance, and speed violation. Shoot. I just lost you there. Frustration.
Oh, man.
All right, so the bond was posted November 9th.
Yes, ma'am.
Case was filed 12/5 of 23. Affidavit supporting the charges was filed January 13th. An amended information was filed. They modified the original charges, they being the county attorney. Count 1, operating a motor vehicle without a valid driver's license. That, sir, is a B misdemeanor. If convicted, the sentence could be up to 6 months and the fine $1,000. Count 2, operating without a valid registration or tag is a misdemeanor. The penalties could be 30 days to 6 months or $2,500. Count 3, no proof of insurance, a B misdemeanor. The penalties are $300 to $1,000 and up to 6 months in jail. And count 4, speeding 48 miles per hour in a 30 mile per hour zone. Traffic infraction, no jail time, but the scheduled fine for 48 in a 30 would be $93 and 108 court costs. So that's what you're charged with.
Yes, ma'am.
It would be best if he
Summons
does not
was
say
issued
anything.
January 18th of 2024.
Yes.
and Judge.
Yes.
So I talked with Savannah and Ashley, and in my notes on that hearing for today, it looks like the hearing was canceled and it was ordered to be canceled. And then the motion for judgment on bond was sent out. We just got it filed on the 19th. So that motion for judgment on bond has been set out.
Till July, right? Well, let me keep walking through the dockets because I don't seem to have the notes you have, Destiny. My notes are only that 2/21/24 traffic docket failed to appear and 4/19 mailed motion for judgment. Now, do you have notes other than those two entries?
I have notes on the hearings themselves, Judge.
Now, where do you keep those in the file?
So I have them on the hearing notes, just on the cancellation reasons, but it's not in the notes section in Odyssey.
Okay, well, I'm gonna have to, okay, so I couldn't get those if I wanted to?
Not that I'm seeing, Judge, now.
Okay. Well, let me finish the process I was going through. So the summons went out.
Mm-hmm.
And then I have another appearance bond. Let's see what that is. That is the Butler County bail bond from November 9th. For some reason, they didn't get that filed until much later, but it did order you to appear. That bond ordered you to appear February 21st, and you did not.
Yes. Okay. Can I speak for a second, Judge? Please.
Go ahead.
Okay. Yeah, I do. I have the initial bond right here, February 21st. Okay, so I was just when I received this letter that was filed on January 18th at 10/11/2024, I got this letter in the mail, and it said I no longer had a court date on February 21st, but a Zoom meeting on April 24th. And so I called Jill at the clerk's district court office because I wrote her name down here. I called her on January 26th at 3:11 p.m. And it just how you're sitting there looking confused, it took her a minute to find it, and she said, okay, you do not have a court date on February 21st. That Zoom meeting that you got right there, that is the day that you need to show up to court. And then I called back again on February 20th, and I spoke with Nancy at 11:12 a.m. I wanted to confirm that because that's not the information I had. I had the bond out. I know if you don't show up for court, there's other fees and things that go along with that. So I'm like, hey, look, called the day before, and she said, no, you do not have a court date tomorrow. Follow the Zoom meeting that you have in your hand. And I said, okay. And now I'm here.
I'm not seeing the letter in the file that he's in reference to, Destiny. Do you know what he's talking to? He said he got a letter in the mail.
I mean, I don't know if you can see it. Man, it's not, you
I can try. Okay, it's on a letterhead?
Yeah, it's on the letter.
Okay, that's not a letter. That is, let me pull your file, your letter down just a little bit more. I think I know what that is. Yeah, that's a summons.
That's a summons. So Judge, yeah, he was sent out the summons on January 18th for this court date, but he bonded out and they set him a court date for February 21st.
Correct.
So why would we summons him, Mr. Regier, for a date after his bond date? I guess I am now. I agree with you. I'm confused because he bonded out for February 21st. He failed to appear. We issued a warrant for failure to appear. But then January 18th, he gets a summons for today. So I can see where he would be confused thinking that this overrode his bond.
I also was told this as well. I didn't just go off of the letter. I called and spoke with, a couple people, and that's what they told me to do. That's what I was informed to do. Otherwise, I would have just went to court on the 21st of February.
Okay. So, clerk, Mr. Regier, can anybody tell me why he was given a summons date after he bonded for February 21st?
Your Honor, it would appear based off of my notes that the summons for the April 24th date was filed with the court in January of 2024. while the appearance bond for the February 21st, 2024 date was subsequently filed with the court in February of 2024. At this point, under those circumstances, I believe the state would respectfully defer to the court as to how it wishes to proceed.
Well, I still don't understand how this happened, that he got a summons after he made bond. And the bond told him to come. I don't get this. It doesn't make any sense to me.
Judge, the summons was sent out before the jail put that bond date on there, before they put the court date for the bond on there.
The first thing that happens, he gets arrested. They take him to jail. He posts a bond. They turn the paperwork over to the county attorney. The county attorney formally files charges, typically setting it on the date that he bonds out for. And if he has a bond, they typically don't issue a summons.
I'm sorry, I received the court date that day I bonded out. It's
Sure,
on the
but
back
you
of
have
my
to. You have to. That's the way the bond works.
Yeah.
So I appreciate what you're saying, Destiny, but that's not the way it works. It should work. I just don't understand how this happened. Well, the first order of business then.
Judge Webster, are you in a good mood?
Sure.
Because I have no reason to ever come back to Butler County ever again. I had a job there. I was working at D&J Engineering, and that's how it happened. I came out in front of that Walmart. I didn't know it was 30 miles per hour right there. You know, it's Kellogg. So when I turned out right there, he was sitting right there. It was 48 and a 30. I had just got the car. I had the title.
Let's hold up there. You're.
No, I'm just saying, like, is there?
No, you're not gonna.
No, I'm sorry.
Yes.
I'm going too far. Yeah.
You're going.
What I would say is like, because there's so much confusion. He said $300,000. I'm like, whoa, like, hold up. I'm just an average citizen here, man. I don't have.
Well, hold up. If I said 300,000, I was misspoken. It was a $3,000 bond.
That's still too much.
Let's hold up.
Yeah.
When you were released from jail, you were told to be here February 21st, and you intended to be here, but then you got a summons. They gave you a date in April, so you called the clerk and talked to two different people who told you to disregard the 21st and come on April 24th, right?
Yes, ma'am. Yes, ma'am.
Okay. Well, so we are going to set aside any bond forfeitures. We're not going to have any judgments on bond because the failure to appear, I understand, was not something intentional on your part.
And Your Honor, if that is indeed the court's order, the state would respectfully move to withdraw the motion for judgment on bond at this time.
So granted. And I've just given you so we're treating this as your first appearance. So everything's going to work out. It's going to work out. I still do not understand how you got that summons, but it all works out. The question now is, and I will reinstate that bond, by the way, that $1,500 bond, the first one. And you understand that the charges I've gone over with you.
Yes.
You have the right to an attorney. You can hire any attorney of your choice. If you cannot afford an attorney, you can apply and see if you qualify for court appointed, or you can waive your right to attorney and represent yourself. Do you want to talk to an attorney about these charges?
Yes.
Okay, are you able to hire an attorney?
I apply for the court appointed lawyer.
All right, are you employed at this time?
Yes.
Where do you work?
TMX.
And what do they pay you per month?
Take home is about $2,800.
And do you pay rent or a mortgage?
Yeah, I pay mortgage.
How much?
$700.
Married or single?
Single.
Any children that you legally support?
Yeah, my son.
Okay, so your family of two. And what kind of utilities do you pay for water, electric, those sorts of things?
Yeah, water, electric, and trash.
And how much do they come to each month?
Trash is $150. My electric bill is $250 and water is about $70.
Where do you live? What town?
Wichita. Jeez. So that diversion was not an option?
You can look into it, certainly.
Okay.
And then you have other debts, any kind of other bills?
No, nothing. Nothing major. Car notes and stuff like that.
Well, that counts.
Yeah, that's another $550 a month.
All right, I'm going to appoint Attorney Darren Patterson, Darren. You ready?
I'm ready.
Darren Patterson, and his number is 316-322-7700. And
Sorry,
if you
that's the
call
attorney's
him
number.
and give him your contact number, he can tell you whether diversion is an option for you and whether you want to do that or not.
Okay.
And we'll set your court date for July 1st at 8 a.m. That's Monday, July 1st, 8 a.m. Your attorney is Darren Patterson. You've already made your bond. I will continue that bond. And for the record, we are on case number 2023 TR 3557, State of Kansas versus Desrick and Twain West. Jared Regier for the state and the defendant in person and pro se. So Mr. Patterson is appointed. Your bond is continued with the added conditions that you reappear July 1st, 8 a.m. Anything else, Mr. Regier, we need to address?
Your Honor, given that the court has appointed Counsel Patterson to this case, the state would respectfully suggest any communications to my office should be through the court-appointed attorney.
Okay. So in other words, he's saying, don't call me yourself, let your attorney do it. That's an ethical thing he has to abide by.
Okay.
All right. Anything from you, Mr. West?
No, that was it. You scared me for a minute.
Well, you confused me, and I'm still confused on how that summons got out there. But we're good, so we'll see you July 1st unless something unforeseen happens. But
all righty.
Thank you for your diligence in pursuing this and working through it.
That's funny. Next time, no gum,
Thank
sir.
you.
You'll do
You're
better.
welcome. You take care now.
All right.
Bye-bye.
Bye.
Hot mic.
Okay, Samsung SMA, is that a defendant waiting there for us? Who is Samsung SMA? Oh, and there's a Galaxy 23. Oh, that's Mr. West. That's Mr. West. Mr. West is free to go.
Babs
But
Austin,
who is
thank you very much for
Samsung
the
SMA?
super chat. Thank you for being about people, not just money. I appreciate your support and helping me grow my legal
Samsung SMA
mind,
want to answer?
which grows my relationship with my son,
Thank you.
lawyer, Hugsby. Thanks, Babs. Thank you so much. Appreciate that.
We are on, if you'll start your video, please, sir. I have to be able to see you.
Paging Samsung.
Mr. Richburg? Thank you. Very good. Richenberg. Is it Richenberg or Reichenberger?
Reichenberger.
Reichenberger. Boy, I was all over the place on your name until I looked at it. On the record in 2024 TR 224, State of Kansas versus William John, you said Reichenberger?
Yes.
Jared Regier for the state, Mr. Reichenberger? In person and pro
That
se.
his name.
Tell me your name one more time, sir.
We pronounce it actually Reichenberger, but we say Richenberger for easiness, I guess.
Now, it looks like a German name that would typically be Reichenberger.
Correct.
Okay, well, what are you comfortable with me saying?
Reichenberger's fine.
Reichenberger, okay. All right, Mr. Reichenberger, you're for the state. Mr. Reichenberger, in person and person. Sir, you're charged in count 1 with driving while suspended after a prior conviction. This is a Class A non-person misdemeanor. If convicted, your fine could be up to $2,500. You could be looking at a jail sentence up to 1 year. The court would impose a 5-day sentence, but could impose up to 1 year of actual service. Count 2, you're charged with operating a motor vehicle without proof of liability insurance. If you had insurance, get that to the county attorney and they'll probably dismiss it. If you didn't, then you're looking at a B misdemeanor. The penalties could be up to $1,000 and 6 months in jail. There is a minimum fine that must be imposed of $300. And then in count 3, you're looking at operating a motor vehicle without registration or with expired tag. This is a misdemeanor. The penalties could be up to $2,500 in fines and 30 days to 6 months in jail. Because you are looking at some mandatory jail time, do you want to talk to an attorney? You can hire an attorney or you can apply for court appointed.
He's on the run.
I want to ask for diversion, Your Honor.
Okay, you can look into diversion. I'm not sure they give it to you on a second, but you could certainly look into that. In the event, do you want to hire an attorney? In the event that they don't divert, do you want to hire an attorney or apply for court appointed?
Apply for court appointed.
Very well. Are you employed at this time, sir?
Yes.
Okay. Where do you work?
Self-employed.
You're self-employed? What kind of work do you do?
Remodeling.
And,
tree work.
Okay, and I understand being self-employed, it varies, but do you know what you filed as your annual income for 2023?
23, I did 33,000.
33,000, and if I divide that by 12, will I pretty much get what you think would be an average per month?
1,000 or so.
Yeah, okay.
No, more than that, I guess. Be about 2,500, I guess, a month.
Mm-hmm. And are you married or single?
Single.
Do you have any children that you legally support?
No.
He might not qualify.
Do you pay rent or a mortgage?
Rent.
How much per month do you pay for rent?
$600.
This is in Kansas. Rents are lower there in this area.
How about your utilities? What do they total per month?
They're about 20. Oh, I'm sorry.
How much?
About 300.
Look on her face, it's not adding up. Maybe a car payment might put him over the limit.
And do you have car payments or any other expenses?
Yeah, 425.
Did you tell me you did or did not have children?
I have children, but they're older.
They're grown. Okay.
Correct.
I think he's close. Does he get a court appointed?
I'm going to appoint attorney Darren Patterson. And it's Darren Patterson. His number is 316-322-7700. And I'm going to set this for July 1st. That's Monday, July 1st at 8 a.m. by Zoom.
Okay.
Darren's a busy man.
All right. Can you see and hear me okay? My computer was doing some strange
Yes, sir.
action.
Yes, I have everything.
Okay. All right, so Darren Patterson and July 1st, and do we need to get a bond on him, deputy? Get his picture and prints? All right, let's give him a $2,000 OR bond. So, Mr. Reichenberger, you will need to look on your screen for an invitation to a breakout room.
Okay.
And the deputy will go through what he needs to with you.
An OR bond means on his own recognizance, meaning he just promises to return.
Is there anything else, Mr. Revere, we need to take up?
Your Honor, besides, I'm respectfully suggesting that any communications to my office should be through the court-appointed attorney. I do not believe I have anything further at this time.
It's not what to speak
Mr.
to you.
Reichenberger, anything further at this time?
No, Your Honor.
All right, thank you then. You are excused from these proceedings other than you need to click on the breakout room.
Breakout room is a Zoom function, which allows him to and court security to go up in their own little meeting and talk to each other without the judge. So the judge can keep meeting.
Missy, is my computer working? Can you see and hear me?
Yeah.
Well, all I get is black with a Zoom picture, a little blue Zoom in it. And then my cases over here are doing something bizarre too. But I think that's the last one on the docket. Is that right? Other than the ones that fail to appear. We don't have anybody else waiting on the screen?
No, there's nobody in the breakout room. I mean, the waiting room.
Okay, Mr. Regier, are you ready to take up a number of failures to appear?
At the court's leisure, Your Honor.
He seems happy at the court's leisure. He does have the Android appearance. I bet he's very efficient.
Okay.
And precise.
I have gotten one of my screens back. Hey, I think I'm back in business. Sort of.
This is his favorite part.
Okay. It's too late. I got it. Normally, Missy has to bail me out of these. That was one bizarre event. All right, we will start with the top of the docket. Yesterday I had an Alexandru. Today I'm not seeing her. Was she taken off the docket then, Helen or Betty? Or Betty.
Got a
Destiny?
potential spam risk. Hold on just one second. Hello? Hello?
Hi, this is Marin. The reason for the call is there are some new state-approved $0 premium Medicare benefits in your area that might be available to you. So do you have Medicare Part A and B?
Yes.
Okay, let me transfer your call to my senior supervisor, who will further assist you.
Hi, this is Daniel here, calling from Medicare Ease on a recorded line. How are you doing today?
I'm doing well.
Sounds good. Basically, this call is about the Medicare benefits and savings. Do you have Medicare Part A and Part B active?
I do. I think I just need C.
All right, that's fine. And how old are you, sir?
72.
Okay, got it. So, sir, first of all, whenever you visit your primary doctor or your specialist, do you have to pay any copays to them?
I have one doctor I just pay under the table.
All right. Do you have like any prescriptions that cost you money? Any medication for which you have to pay?
Yes.
All right, got it. You know, basically that's one of the exact reason we're giving you a call today. Could basically help you to eliminate these copays and update your prescription plan. So all of your prescriptions would be covered for this year. You don't need to pay.
I just have the
one. More
one.
thing
I just have the Viagra is the only one I need. He hung up on me. He hung up. I'm sorry. Oh, I'm sorry. I don't know what to say to these people. I realize you guys helped me out a little bit, but I just don't know what to say. Apparently that's not the prescription they want to cover. Let's jump back with court here for just a minute. Let's see what's up.
Alexandra, correct?
Right.
Yeah, it looks like an amended information was filed and the second charge was dismissed. So it just leaves the speeding charge on the ticket.
Okay. So we will be on the record in, it looks like Brown, 2023 TR 3257, State of Kansas versus Joanne Denise Brown. Jared Regier for the state. The defendant had an alias summons issued after failing to appear January 17th of 2024. Looks like we didn't get that one served either, Mr. Regier.
Your Honor, I am showing a return on the alias summons in my file. It would appear to include a notation stating, quote, moved NFA, which I would interpret to mean no forwarding address, and that was back in February for a date served.
All right, she's charged with operating a motor vehicle without a valid license. I'm inclined to issue a bench warrant and make her bond. 1,000 cash or surety required.
No objection from the state, Your Honor.
Yep. I'm just going to have to limp along here. My computer's gone weird again. We're on 23 TR 2834, State of Kansas versus Alex Jacob Berghart. Jared Regier for the state. The defendant failing to appear.
I think Mr. Reiger could be replaced by an AI bot, and people would not notice.
Recommendations, Mr. Regier?
Your Honor, I do appear to have a return on a summons in my file for today's date, April 24th at 2024 at 9 a.m. The return would appear to indicate there was or rather at least that there was a residential service, although it does appear to be indicated on the return in a different line than its customary position, but it does appear to include a date served of January 25 of this year. If the court is satisfied in all other respects, the state would respectfully suggest a bench warrant, 2,500 cash or surety would be appropriate pursuant to the amended information filed with the court in October of 2023. The same would appear to dismiss counts 1 and 2 while retaining count 3, drive while habitual violator, class A non-person misdemeanor.
On forfeiture bench warrant, 2,500 cash or surety required.
And forgive me, Your Honor, the state's recommendation is bench warrant. I apologize if I misspoke previously.
Oh, bench warrant, but no bond forfeiture.
Bench warrant, 2,500 cash or surety would be the state's recommendation. The summons I have in my file appears for today's date.
Okay, thank you. I just heard that wrong. Bench warrant bond set at 2,500 cash or surety required.
He's very efficient. I like him. I really do. Thank you, Princess Buttercup. Eyeing the 7 chicks. No, don't do it. Don't do it. Never say yes on these spam calls.
Okay, we'll now be on the record in 2024 TR 174, State of Kansas versus Danny O. Burkett. Jared Regier for the state. The defendant fails to appear. Recommendations.
Okay, it sounds like they're just going to go through and issue a whole bunch of bench warrants.
Your Honor, some new information has recently been brought to my attention regarding this matter. The state would respectfully move to dismiss without prejudice at this time.
Ooh. Failure to appear.
Prejudice is granted. We'll now be on the record in 2024 TR 865, State of Kansas versus Paula Chambers. Jared Regier for the state. Defendant fails to appear. Recommendations?
Your Honor, this is another case where some new information has been recently brought to my attention. The state would respectfully move to dismiss without prejudice at this time.
Granted.
With prejudice usually is done as
Will
a
now be
punishment
on the
against the
record in
prosecutor.
24 TR 220, State of Kansas versus Kayla Downing, Jared Regier for the state. Defendant failing to appear. Recommendations, Mr. Regier?
Your Honor, based off of my notes, my understanding is that there was residential tack down service. I also have a return on the summons in my file, which would appear to indicate that although none of the usual boxes are checked, there was residential tack down at 11:21 hours, approximately 2 months ago in February. Pursuant to the information filed in this case, this is a case that has at least one Class B driving while suspended currently before the court. Bench warrant 1,000 cash or surety would be the state's recommendation.
Court will order a bench warrant with bond set at 1,000 cash or surety. Being in recess on Downing will now be on the record in 2024 TR 870, State of Kansas versus Casey J. Dunlap. Jared Regier for the state, defendant failing to appear. Recommendations, Mr. Regier?
Your Honor, the state's understanding is that on the ticket, there is a notice to appear for today's date, April 24th, 2024 at 9 a.m. Upon further review of the ticket, this is a case that appears to involve both an infraction and a misdemeanor, at the very least a Class B. To my understanding, state would respectfully suggest bench warrant 1,000 cash or surety would be appropriate.
Destiny, don't we usually, if it's the date on the ticket, don't we usually call that in Butler County an answer date?
We have in the past, Judge, but if it is a Kansas Highway Patrol ticket, we've been having to go by the date that is set on the ticket after a certain date.
Oh, thank you. And that's a bench warrant. What did you recommend on bond, counsel?
1,000 cash or surety, Your Honor, based on the charges presently before the court.
Very well. Bench warrant will issue with 1,000 cash or surety bond. Being in recess on Dunlap will now be on the record in 24 TR 170, State of Kansas versus Jacqueline Roxana Gonzalez. Jared Regier for the state, defendant failing to appear. Recommendations?
Your Honor, the state's understanding is that a summons was previously filed with the court. I am showing a return of service in my file, which would appear to have a notation suggesting residential tack down back in January of this year. If the court is satisfied, the state would respectfully suggest a bench warrant would be appropriate in the amount of 1,000 cash or surety. Pursuant to the information filed with the court in January of this year, this is a case involving at least one Class B.
Bench warrant will issue. Bond is set at 1,000 cash or surety. Being in recess on Gonzalez will now be on the record in 23 TR 3688, State of Kansas versus Holly Ann Graves. Jared Regier for the state, defendant failing to appear. Recommendations, Mr. Regier?
Army Mom, thanks for the
Forgive me, Your
55
Honor.
memberships.
Could I respectfully inquire as to that case number?
Yes, it's 2023 TR 3688.
Your Honor, the state's understanding is that in this matter, a summons was filed with the court. It appears to include a date of May 22nd, 2024 at 9.
Very well. Continue to May 22nd, did you say?
That is the date and time I am showing on the summons in my file, Your Honor.
All right. Being in recess on Graves, we're now on the record in 2024 TR 823, State of Kansas versus Kobe Michael Huggins. Jared Regier for the state, defendant failing to appear. Recommendations?
Your Honor, the state's understanding is this is a case involving a ticket by the Kansas Highway Patrol. That same ticket would appear to include a notice to appear date of today's date, April 24th at 9 a.m. Pursuant to the same, this is a case that would appear to involve multiple counts, including at least one Class B. As I understand it, bench warrant 1,000 cash or surety would be the state's recommendation.
Court's order will be bench warrant, $1,000 cash or surety bond. We'll now be on the record in 2024 TR 052, State of Kansas versus Carlene Marie Lovelady. Jared Regier for the state. Defendant fails to appear. Recommendations?
It's a lot of FTAs in one day. Got a court in Ohio that's going live right now. Let me see if we can see what's going on here. Sorry, while they sort out their FTAs. Looks like we have either a victim. Oh, well, it's going to be a defendant sitting at the table there. That's the defense table. No audio yet from this court. I think they're waiting for something to happen. We had prosecution on camera as well. This is out of Ohio. Let's see what part. This one is Warren County. Warren County, Court 3. Zoom's been muted, apparently. Fist bumps. Fist bumps all around. It's always good when your lawyer gives you a fist bump. We're going to see. Judge Webster's just wrapping up her docket with those FTAs. We'll see if we have anything else we can jump to today as far as live courts. Judge Wolf seems to be in break right now. Whoa. Just stumbled across a little trial, day 2. Pritchett and Robinson criminal trial. Hang on, let's pop in on this live little trial, see if this is something we want to watch. This is over on
I don't know if it's on the formal witness list, but she'd also been sent to CP. I'm not saying that Ms. Minot is, and I could have ended up adding it on the amended, and it might not have been, but there's been several witnesses filed.
Did Sluss prepare a report?
So yes, it's the same report that I guess would have been more or less everything else. It is, and I turned that over.
When did you turn his report over?
So it kicked back last night because it was in PowerPoint form. I don't need, it can be a demonstrative. I don't need to put it in like I normally do as a summary of the records.
Is this worth going back and rewatching?
I did turn it over, but it is very clear. It is one phone call that we were talking about. And it was reflected on the records as they were turned over in the original discovery.
So the report that Investigator Sluss prepared, the PowerPoint, whatever we want to call it, that's something that you didn't provide to Ms. Mignot until at the earliest last night, but it didn't go through last night.
Until this morning at 6.
Okay, so
we're going to jump back here. This is Judge Robert McBurney. I just want to see what's up here. We've got, let's see. The criminal trial started yesterday. We've got 8 hours of video from yesterday. Probably some of that we can fast forward through. There We've got some final pleas. Just a ton of stuff here. This just popped up on my feed. Let's start with yesterday.
Well, we're not on the record right now.
Let me show it to you and explain it to you, and then you can make whatever argument you want.
This is day one. We backed up. Hang on a second. What was that? I do apologize. The audio in this courtroom is awful. It's got hardwood walls everywhere. The sound just echoes. Okay.
Said here's a video of what we were.
Oh, sorry.
So let's go.
I rewound a little bit.
So this is from his cell phone. He recorded it prior to the incident.
What is?
So I'll make it. Yeah.
Everyone's got the cables ready, plugging everything in, or she lost her power plug.
It's just only two pieces of evidence. I think he showed me only up to the shoe when he gets back.
I need some background on this one.
That's the only. Counsel, you stopped at the shoe. Is there anyone?
Oh yeah. There's. I'm sorry. There's not a lot left.
Okay, I'm gonna fast forward just a little bit. Let people sort of take their seats. Looks like it's about to start right about here. Need the background here. What is happening? See notes above, says Nikki. Soft sit hats at ready, folks. Oh, we've got a soft sit. And Law Talk with Mike might have covered this one.
The same thing.
Yeah, so like I've been trying to tell you this one.
I need you for another person to do that.
Oh, that's, yeah, there's like the other stuff is like videos or something. That's like folders. So.
Oh, okay.
It's like when I label all my pictures that way. And there's other stuff that's going to be like that.
Where's Jackson?
I just keep.
Okay, we're gonna skip ahead. I don't need all this noise of people walking around in court. People still walking around. Let's see, back up. Everyone's in their seats.
Yeah, it's updated.
Okay, we'll try this. We got about a minute or two before it looks like court starts. I know nothing about this right now, other than it's soft sit, and it's supposed to be incredible.
Look at that.
2 defendants.
You got it? No, it's still.
All right, let's get on the record in State versus Robinson and Pritchett. We have our prosecutors here in the courtroom on Tuesday, the 23rd. Ms. Mignot and Ms. Blake are here with their client, Mr. Robinson, who looks like he got a haircut. Is that correct?
You got a haircut, Judge.
Thank you. Are we satisfied? I mean, is it okay for Union City standards? Okay, great. I'm glad that worked out.
Thank you, Judge.
Thank you. You're welcome. I just asked. I didn't do it. I think we are good to go with Mr. Robinson. There may be a few things we need to talk about. What I'd like to do first, though, is bring Mr. Pritchett out to see if he's going to join us this morning. And then we'll take up anything we need to discuss outside the presence of the jury. So if you all could bring Mr. Pritchett, make sure that chair's available for him just in case he chooses to sit. It looks like it's right there.
Okay, what a setup from the judge. It's like, we're all ready to go. Let's bring Mr. Pritchett out, and we'll see if this flies. I know nothing about this other than what you've told me in chat. And I missed all the messages, Deanne. I'm sorry.
Thank you. My copy? Yes. Thank you, sir.
We're good except for that one. Okay, thank you.
Your Honor.
Thank you, sir.
Mr. Watson says you want to speak with you. Knows you can.
Okay, we'll do that whenever we can. Thank you. All right, good morning, Mr. Pritchett. It is the start of the trial. We've got our jurors and they are about to come in. I wanted to check with you this Tuesday morning to see if you had a change of heart and wanted to engage meaningfully, constructively, and non-disruptively and participate in your trial. Any update from you?
I'm on the record. I'm not here to say I'm here improper persona sue jurors under the rest of coercion. I am not here in the legal name or legal person, Max Pritchett, that the state in this court has against my presumption of innocence, presuming me and forced me to be. I am here in my private God-given Christian name, which I do not consent to being used for any commercial purposes in this courtroom. Furthermore, that the record show I do not understand the nature and cause of the proceedings and claims against me, nor do I understand the nature and authority of this court. How can I possibly understand these things and participate properly in this trial when the court has failed to disclose what jurisdiction they are operating under? The court has arbitrarily assumed personal jurisdiction over me by forcing me to be the legal name and person Max Pritchett when there has been no evidence proving such claim that I own that name or ever consented to that name on record. The court has denied my presumption of innocence in regard to those elements of the charges. The court has also prejudiced me by declining my request for full disclosure of the discovery that showed the evidence proving all the elements of the claims and charges against me so I can prepare a proper defense.
Okay, Mr. Pritchett, Mr. Pritchett, I'm going to stop you because everyone in here has heard this now a bunch of times. Nope, you
continue to make the record for this violation of the rights.
Tell me how much more you have, because if you've got 30 seconds or less, you can. Otherwise, you continue to disrupt these proceedings by repeating baseless allegations about lack of personal jurisdiction and these things about improperio personam. And you've made a record of that a whole bunch of times. We don't need to remake the record. But if you want to spend the next 30 seconds adding what you want to add, then I've got a couple questions for you. If you want to answer them, great. If you don't, then we'll check in with you during the morning break.
Okay, let the record show that the court has stated I can only see the full discovery only if I have an attorney. The judge of this court has practiced law from the bench by entering pleas on my behalf against my consent. I have been greatly injured by this court and state that I cannot properly participate or prepare a proper defense in light of these due process violations and the impartiality shown toward me. Mr. McBurney, are you prepared to rectify these issues and help me understand the full nature and quality of the claims and charges against me, along with the nature and authority of the court? If you cannot do that at this moment, can you please recuse yourself of the fact that you're impartial?
Hold on 1 second. Okay, I'm sorry. Ms. Mignot was adding a machine. It was creating feedback, but it stopped. So keep going.
Again, I just want to repeat, Mr. McBurney, are you prepared to rectify these issues and help me understand the nature, the full nature and cause of the claims and charges against me, along with the nature and authority of this court? If not, can you recuse yourself from the fact that your impartiality and bias toward me have been brought into question?
All right, thank you, Mr. Pritchett. I think that it's important that the record reflect that the issues that are being prosecuted in this case are things with which you're most familiar, since you represented yourself at your revocation hearing in your other felony case, and the basis for your revocation in that case with the facts and circumstances of this case. So I'm confident that you're familiar with the allegations. We've already discussed that. And when you were represented by counsel, you had full access to all the discovery, including discovery that you may not possess as an inmate at the county jail. When we had our discussion about you representing yourself, okay, well, we have differing perspectives on that. Regardless, this is an opportunity for you to join the proceedings. Do you care to sit?
How can I possibly participate properly if I don't have the evidence of all the evidence and claims against me? You're not allowing me the opportunity to even understand the full nature of the cause and the authority of this court.
Well, I am by inviting you to join us for these proceedings, but you're declining. You don't want to sit and you don't want to engage in the way that someone who is meaningfully participating in the trial would engage. So I find once again that because you're unwilling to follow the basic rules of decorum in the courtroom, that I'm going to excuse you. I'll bring you back out in the next break. And if you want to participate, you remain welcome to do so as your own advocate, which is what you requested last week and is what I granted you. So, Deputy, if you would remove Mr. Pritchett from the courtroom, we will try again later this morning.
I'm sorry. I think he understood what he was saying a little better than Mr. Darrell Brooks did. But they've clearly studied at the same school.
Mr. Hiles, is there anything we need to discuss from the state's perspective before we bring in the one juror?
I just want to put on the record that I did provide all parties with an exhibit list, and I do have an extra copy for Mr. Pritchett. I just want to make sure that I'm bringing everything for him if he would like to participate. Making it available for
Great. If you don't mind putting an extra copy over there where Mr. Pritchett is invited to sit every time he and I have the same conversation, I'll make sure that he picks it up and adds it to his collection of papers that he brings out and reads from to tell us about whether we can use his God-given Christian name or not. Anything else from the state?
That's all I have.
Judges
all right. Back. Ms. Mignot, anything on behalf of Mr. Robinson?
Good morning, Your Honor. Yes.
Good morning.
This morning, the state was kind enough to go through the exhibits that they anticipate presenting in their case in chief. And I have a concern about at least one of the exhibits.
Which one is that?
Exhibit number 16 is a picture of shoes. And throughout the pendency of this case, there has been no discovery provided to our firm. And I want to be clear with the court, we didn't just go to previous counsels because there had been several. We provided the state with the terabyte, 2 terabytes, however many terabytes they requested. And they assured us that all the discovery that was in the states, that the state intended was associated with this case was produced. There has never been a photograph of any sneakers. There have been mentions of photographs of sneaker, but there has never been any. This morning, Mr. Hiles advised me that one of the victims or the alleged victims, Mr. Chris Riggs, produced last night the picture of the tennis shoes that's depicted in Exhibit 16. And I have concerns. And the reason I have concerns is because we are now, as defense, unable to do any type of investigation of when that photo was taken, to get any type of IT person to go in to make sure that it wasn't produced at a different time than it said it was produced, looking at a cell phone, any forensics associated with that photo. So now my concern is, we're here at trial, we have a jury ready, and we've mentioned sneaker, 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 and there's been no evidence presented about any sneakers, and boom, voila, trial by ambush, here's a picture of a sneaker that we're intending to show a jury today. So we would object to Exhibit 16. As it pertains to Exhibit 19 and 20, Judge, we do have that in discovery. However, my concerns is it's a different address from the incident address location, and it may create confusion for the jurors as to which house are we actually talking about here as the Airbnb house.
Okay, but that may be, should the state seek to admit it, a relevance objection. It's not a, we've never seen it before.
Correct.
Okay.
That is correct.
All right, so I'm going to table 19 and 20. We need to see the context in which it's presented. It may be relevant, but maybe it's a 403 because it's unduly confusing. But I appreciate you flagging that. Can you get Exhibit 16 up on the screen?
I have it for you.
Okay, great.
Okay, we're putting the link out for the thumbnail. We live here now.
This is something, the picture that we had at the beginning, it was turned over with the original file. This case has been going since 2019. At some point, I did lose part of my file. We had issues with the game server. So it may have very well not been turned over to Ms. Minot. And last night when we met with, it's actually Jackson Heil. That was not with Christian Riggs.
Okay.
Those are his shoes that were reported as being stolen off his feet. He has it on his phone, so maybe if the defense would like to see when the picture was taken, I don't know if it's still got that data, but it's a picture of the shoes taken. He bought the shoes the day of the robbery.
Okay. So the way you would use state 16, I'm assuming, would be through Mr. Heil, and he would authenticate it by saying, those are my shoes. I recognize them. Those are my legs attached to the feet that are in the shoes. And I took this picture the night of the incident.
Or the day.
Whenever it was, he took the picture. Not only could he provide a foundation for this, it's a fair and accurate depiction of his shoes on his feet, but he is the creator of the image.
Yeah.
Okay. All right. Ms. Mignot, I'm going to preserve your objection. You're free to renew it. You don't need to. You've made a valid objection that this is untimely disclosed. You don't need to make that full objection should the state seek to tender Exhibit 16, but I'll make sure on the record that I acknowledge you're renewing the objection you made now before the jurors came in. There may be other bases to object as well. So you're waiving nothing and preserving this, but I don't find that given how it will be presented, you aren't in a position to meaningfully cross-examine this person. I hear you that you didn't get a chance to have a forensic expert look at the metadata and this and that, but I don't find that disadvantage is such that the state shouldn't be able to use this photo, not of what they say was the weapon that someone used or et cetera, but shoes actually on the feet of one of the victims. I think the victim, alleged victim, is in a position to provide sufficient foundation for this picture. I also, as an officer of the court, I credit Mr. Hiles's claim that it was provided to your predecessor, but I credit you as an officer of the court. You started with a clean slate, which you should have. Here's the empty drive. Give me everything you've got. And if I were you, I wouldn't have relied on it trickling across from a predecessor. So I don't know why State 16 didn't make it across, but I'm not finding that the prejudice that this might cause is such that it ought to be excluded. I'm not finding bad faith by the state in this reappearing at this point. Okay, anything more you want to get on the record about State 16?
Just that counsel had previously communicated to me that it was not produced, and now he's telling the court that it may have been produced.
Yeah.
So
I communicated that it was not produced to you, but it was produced to your predecessors. At some point, I lost part of my file, and we had to go back and get additional information especially in 2019, at the end, our server went through issues and parts of our files were recreated. So I know it was turned over in initial discovery, and by initial, I mean to whoever entered the first appearance back when this case was.
How do you know, Mr. Heil? You're actually both correct, because what Ms. Mignot said is that you told her you didn't produce it to her, and you just said that as well. How do you know it's not in the 2 terabytes of data, or you're just relying on Ms. Mignot saying, I didn't find it in the 2 terabytes?
No, I haven't. I had that photo initially, and I've gone through this file, and then there was a couple ring videos that were gathered along with that. We're never able to recover. It shows the cars driving at different angles. We have recovered most of them.
Is there anything else that you intend to use at trial that you know you didn't produce to Ms. Mignot? What's that?
It's video states 27. I wanted to bring that up right now. It was not produced. It never has been produced to anybody But last night when Miss Green met with Mr. Heil, our out-of-town witness, he said, hey, here's a brief 30-second video of the party, and here's what was going on before anyone arrived. It just shows them engaging in a party game.
So
15 seconds.
Doesn't matter if it's an hour. Unlike the sneaker photo, which you believe you did provide to previous counsel and didn't intentionally omit from what was submitted to Ms. Mignot based on the server woes you had, et cetera. And we've all talked about these sneakers before. It's not a surprise that someone had green sneakers, and there was going to be testimony about it, whether it was corroborated by a photo or not. You've made plain in justifying in part the two videos in which Mr. Robinson appears that the green sneakers were taken from one of the victims.
Well, they're arguing this just for a moment.
Are part of
this is a home invasion robbery case, I believe.
Build between the defendants
That's why
and
we've got some thumbnail work going on already.
This is an alleged victim saying, oh, by the way, here's this. Ms. Mignot, have you had a chance to view that video?
I have, and I have concerns, and I would object to it being used out of time discovery. Also, Your Honor, it really is not a picture of the party. So you're not getting a full room view of everybody engaging in games. What it is a short video of somebody just showing what looks like a Wheel of Fortune kind of thing with handwritten notes on it.
Okay. Tell me why you have to be able to play that. You just got it. So, and you immediately handed it over. So it's not a discovery violation in the sense that you noticed it in the officer's file and it's been there for 3 years. But it gives Ms. Mignot zero opportunity to prepare for it. Why should you be able to play it?
So may I allow Ms. Green to answer that? It is her witness. And
Sure.
She's the one that wants it to be. So I will defer to her.
Sure. Tell me the significance of States 27.
So it's just a Wheel of Fortune game, taking a shot. It corroborates my witness's statements, a lot of the victim statements of what they were doing prior to the incident. It does not invoke any issues it doesn't have any allegations towards the defendant. This is way before the alleged males came into the home, but it just simply 15 seconds, probably like an Instagram video to show what they were doing right before this happened. It will show people were taking shots, why they were taking shots. They were playing a drinking game. So you're gonna get like evidence of underage drinking. It kind of just shows, it gives a visual to it. It's only 15 seconds.
Okay, yeah, you've emphasized it's only 15 seconds. It also got handed over today.
Yeah.
So, Ms. Mignot, I'm gonna let you think about it more. I'm inclined to not allow it in because it's not late disclosure, it's immediate disclosure by the state, but it's late arrival for the trial. And so I'm inclined to exclude it, but you should think about it more. You may want to have the jury see these people drinking. So 427 should not be tendered. If you think about it more and decide you don't have an objection based on the time at which you received it. Again, I'm not characterizing it as late disclosure by the state. It sounds like they got it to you about as quickly as they could once they learned about it. It was late provided to them. I'm going to provisionally exclude it, but let you think about it a little bit more because you may decide, go ahead and play it. Does that make sense?
That makes sense, Your Honor. I just wanted to be clear for the record. I was shown the video from the state's computer this morning. It wasn't emailed, nor has it been produced in.
Okay, but you were alerted to its existence this morning.
That is correct.
As soon as we all convened. And so I want the record to be very clear. I don't find any bad faith or anything like that on the state side. They just got it. Now, why this gentleman didn't think until now to hand it over, don't know. I don't see anything sinister in that either. They were doing witness prep and he said, hey, I have this. I was a little late for the state. Not their fault, but I'm not going to allow that to compromise your presentation. So you should think about it. And with which witness would this come in?
It would be Jackson Heil.
Is that the same as a sneaker picture?
Yes, the
Okay.
creator of the video.
All right. So we'll know when Mr. Hiles testifying. That'll be the time for you to decide, you know what, I don't object to the lack of timeliness or basically when this was disclosed. Because I find that it's disclosed. They don't have to give you copies. They can show you what's in their folder. So you've seen it, you know it exists. And the state did get it to you, I find, as soon as they should have. They just didn't get it in a timely manner. And again, that shouldn't be your client's problem.
Understood.
Okay.
Understood.
Anything else, Ms. Mignot?
No, Your Honor.
All right. Can we bring juror 3 out, please? And you're not going to film any good.
Okay, so I don't know why we only have one juror. I wish the audio were a little better. The judge is overmodulated just a wee bit. Just a wee bit. This case is the Georgia via Pritchett and Robinson, charged with first-degree home invasion and armed robbery.
Sit right in that corner seat.
2 other defendants still.
Good morning, you're juror 3, and Deputy Gordon told me you wanted to talk to us before we got rolling.
Yes. So last night was like a hard night for us or whatever, because I was talking to my boyfriend about like everything that happened, and I felt like I could do this. I felt like I could be, I wanted to be able to see objectively and be able to like, give the defendant like a fair shot, because at the end of the day, like everybody deserves to have a fair, like, shot in court or whatever. But I know I said that I would try, but after the conversation we had last night, I know that I wouldn't be able to give him the fair shot that I genuinely feel like he deserves.
Tell me what you mean by that, because I know we had a very thoughtful discussion, you and I and the lawyers yesterday,
she just wants off the jury.
We tried to separate out the notion that you might reflect upon what happened to your boyfriend, which is natural, to be expected and not a problem, versus your boyfriend's situation of several years ago somehow interfering with your ability to focus and process what this case is about. And you didn't promise anything, because you can't promise because you don't know. But what I understood you to say in the end was that you appreciate that they're 2 different situations. And that while you might think of your boyfriend's situation, that wasn't going to cloud your judgment. You wouldn't use information you think you know about that and plug it in here, or bring in anger from that to say, you know what, because I'm upset about what happened to him, the state doesn't have to meet its burden. They just need to sort of wave their hands around, and I'm gonna find someone guilty because maybe someone else had happened to them what happened to my boyfriend. I left our conversation hearing you say, that's not me. This might be difficult because of what happened to my boyfriend, but I can appreciate the difference between the 2, and I will not import information from one into the other. So tell me what's changed. And maybe nothing's changed, it just was a difficult evening.
Well, I talked to my boyfriend.
I wanted to be that person because I am extremely level-headed and tend to be more on the logical side. And I can't operate with any emotions in my personal and in my professional life. And so I don't do that. But seeing as though this is more so like a personal thing, and this is something that has affected many things that did or didn't happen within us, in our relationship, in our lives. Like our lives drastically changed, although it was so sudden. Like it went from us just meeting each other to him having to come and like live with me because of this event, which I was not prepared for.
Right.
And I had to take care of him, and all the stuff that I wasn't accustomed to. And then so many things in our lives was affected by this. And then last night we just had like this moment in which like it was like it just happened. And I know that like I need to be honest, like being as though, like I said what I said, because I know, like, I am a very logical person, right? And because of that, I know, like, I would not be able to give him the unbiased, fair shot that I feel like we all deserve.
Everyone does. That's right. Both sides. It's not just one side. I mean, you need to be.
Yeah, for sure. I just feel like, I don't know, I just feel like it's not right, and I needed to be honest about that. I prayed about it, we talked about it. I don't see it happening, like, for me, like, I don't, especially not after last night.
Okay. Mr. Hiles, do you have any questions for Juror 3?
Did you talk to your boyfriend about the case?
Are you saying you don't see? You don't see you having the ability to only look at the facts as presented through witnesses? Are you going to look at the facts as they come out with an inference of guilt? Is that what you were saying?
Yeah, I think that if we're being honest, I could easily, I could say, like, oh, I'm going to look at the facts, but I think it's different when we have trauma. I think we can want to say we're going to look at the facts, but if I'm being, I took it seriously when I swore on an oath to tell the truth. So I feel like I know that's not the truth after last night. Like, I don't know what all this means from like what I'm saying, what's gonna come from this, but I just wanted to make sure that I'm telling being very honest, you know? Like, I just want to be honest about it.
Okay. Well, let me say this, and then I'll see if Ms. Mignot has any questions for you. What's going to come of this is nothing bad. You're not in any trouble. The honesty is essential. In fact, you took an oath yesterday to be truthful in your answers. And as you and your boyfriend processed things last night, you felt that maybe you needed to amend one of your answers, and here we are doing that. So there's not a bad outcome to this. It's important that you share this. Okay. Ms. Mignot, do you have any questions for Juror 3?
No, Your Honor, respectfully decline.
All right. If you will go back to the jury room, we're going to talk and we'll let you know what's going to happen. Thank you.
So 2 of the lacrosse players that helped plan or participate in this Airbnb robbery.
So
we're going to testify against the 2 on trial.
Your thoughts, Mr. Hiles, about Juror 3?
Well, I think my thoughts are that she point blank said that she lacks the ability to be impartial after discussing this. I don't know what she discussed with her boyfriend. I don't know if she discussed some of the facts of the case.
It sounds like they discussed his situation. Yeah. He was shot in an armed robbery. And so this caused them to revisit all that.
I do not want to, my thoughts are, I do not want to do this twice. I don't want to, that's what my thoughts are. My concern is that we are already down an alternate.
Right.
And if we go into this now, I mean, what's going to happen if we, I know you can continue with 11 jurors, but that requires because essentially a waiver by the defendant. That's not a call that I have the position to make. And like I said, I don't want to do this twice.
Right.
Have we heard anything at all from the alternate juror?
I don't think so. Ms. Nelson, can you shoot me a Teams text? Any update from Juror 39?
Are they missing an alternate juror? Oh my goodness.
I'm assuming that that's a dead end, given that the calls didn't work this morning and she didn't respond to the email. I'll deal with that separately.
I think,
but we have an alternate who now won't be an alternate if we excuse, thank you, Ms. Hansberry, if we excuse Juror 3.
Okay. My last question about is it juror number 39 that's not present? Last time we did the text, has she been texted? Because that was when we
go for it.
Okay.
Text away.
Could I approach to get her number?
Yes.
And the only thing I would suggest is we don't hold up and we do as we did last time. where
Right.
she becomes the second alternate. And if she misses openings, she misses both of our openings.
Right. Here you go. So Ms. Mignot, the trial we had a few weeks ago, we had a juror we couldn't reach through phone or email after jury selection. And then at about this time in the trial, Mr. Heil said, hey, why don't we try texting the person? And we texted this person and magically she called the chambers. That person was told, get yourself down here. She became the alternate. This person's already the alternate. And everyone involved agreed that
yes.
Everyone agreed that that person who became the alternate would be able to join and be a full-fledged part of the jury, remaining an alternate. She just skipped the opening. She arrived in the middle of, there were two defendants, one of the defendants' openings, but rather than allowing her to hear 1.5 openings and not the state's, the agreement of the parties was she would join in once evidence began. And she ended up as the alternate, didn't deliberate, but we had that pressure relief valve. Here, I think we need to excuse juror 3. That's the first thing we need to address when it's your turn. But we then need to figure out what do we do? Because if juror 3 is excused, we have no alternates. We have 12 jurors. And I'm leery of going forward with just 12 unless I know that everyone agrees that they would go with 11 if we lose one, because then in effect we have another alternate. Otherwise, I'm going to want to sit around and wait. Some, but not too much, like Mr. Hiles, and I'm sure like you, and even more so Mr. Robinson, who isn't going anywhere if there's a mistrial. We don't want to try this again because he will wait until we can get this back on your schedule and mine to try it again. So that's what I'm trying to balance. Share with me your thoughts first about juror 3 and then how to navigate what we do if juror 3 is excused.
Juror 3's statements this morning, Your Honor, is clear that she cannot be impartial. It would be ineffective assistance of counsel if I went forward and something happened as it pertains to her deliberation and it was exposed after the trial. So I agree with the court. I concur with opposing counsel, Mr. Hiles, that she has to be excused.
Okay. So if we do that, then we're down to 12 jurors because juror 43 would become our 12th juror. And so the question is, how would you want to proceed? We can proceed with no alternates, or we can dispatch deputies to go grab this woman who has declined to respond to emails, has her phone going into non-voicemail, and we'll see if she responds to the text. That's going to take some time. Or we could go forward with 12 with an understanding on the record that if we have to excuse one more, just one more, that we'd go with 11, and that's a sufficient number. So I need to get your perspective on that. And you can have a moment to huddle up on that. Okay, so, but I don't want to excuse
that's
3
not gonna work
until I know what our plan is going forward.
I agree. If we
Okay.
can just get some time to.
Sure.
All right, you've got a SovSit defendant on this case who is not going to agree to go in with 11. So either they have to split the trial.
Nate D.
Yep. Makes me rethink the let jurors go.
I was thinking about that.
It was working for a long time.
It's worked until I've tried your cases, if you must know.
The SovSit is not going to agree to 11 jurors. And the judge can't order that he has to agree.
Bring my surprises.
Because that's his right. So defense gets...
Your Honor, is it all right if I sit down and refill my water bottle?
As long as you've got a colleague in here.
Is it a legal assistant?
Lawyer.
Lawyer. Need somebody on the bar. Yeah, so I don't think they can proceed if they go to 11 jurors, at least not with both cases tied together like this. It's possible the defendant here, who has counsel, would accept 11. But man, it's a bad day when you haven't even reached opening statements and you're already down to 0 alternates left on the jury. We're going to try to catch up on this case. I think we're going to see if we can watch at 1.25 speed, if that's okay, because it's live right now on day 2. We'd love to be caught up on day 2, and we've got a lot of time between here and there. So 1.25 it is. I will say this about the judge. Sounds great, but puberty is a heck of a thing to go through, especially on a live stream. So I'm sorry, poor judge.
I guess another thing we could do is have jury services send us 4 potential jurors and just agree that we will be most expeditious in our approach with that, and then we could restock.
I'm not opposed to that.
I can do that in a heartbeat.
Okay, let me see if we can do that. Keep talking. Ms. Nelson, can you please check with jury services to see if they've got 4 spare jurors?
Do you have some extra jurors?
They need alternates too. It used to be that, I remember when I was in state court, there was no requesting jurors like the day before. It was like, if they're available, we'll send them. So here's
we have some volunteers, Judge.
Get a response from.
We'll send them right down.
From the juror that we texted, or potentially, if the jury services has 4 spare jurors, we might just water a few of them, and we need 1 alternate.
I know. Can I go get it? Would that be easier? Then to volunteer 4 more, which one is shorter? I don't know. I'm just
I've never
talking logistics. Like, which one will take longer? Go pick her up.
All right, I'm gonna fill my water bottle up.
Okay.
So just,
Can you hold? I need to use the restroom.
You can't get your water bottle because she has to pee.
I just need you in here. So he said we can.
Let me see where she lives, because it'll be, I mean, if she's in Johns Creek, it'll be easier for us just to do this if we can get some jurors real quickly.
So we might still have
Sandy
the
Springs.
sheriff's deputies just go pick up the missing juror. The poor attorney just wants some water. I just need to refill my bottle. And he has nobody. If you've got a legal
I don't have the
assistant,
address. Oh, would it be? No, I don't have addresses. She told me Sandy Springs. Maybe there's another list.
Costco jurors restock the juror pool, clean up in court 2.
The 2 I have, just there's phone numbers and email address. She's got the super duper one.
Oh, now I want to know what her email address is. If she has a super duper email. Okay, we already have a thumbnail in the works. Amazing artists at work right now building this. Let me see if I can show you what we have so far. And the way this works best, let's jump to right here. Let's see. The way this works best is if everyone who participates, if you're new to creating on these thumbnails, the best way to suggest is to go to page 2 and drag a picture in and suggest it there.
Yeah. This is the paper.
Where you could make a suggestion about an image that might show up. So like we have Wheel of Fortune, we have robbers, we have a judge, we have some shoes, beer pong looks like it's being played down here. All these suggestions work really well. So
okay. I mean, it's up to you guys whether you allow people to pass papers. If you do, you can have it.
Probably the sneaker theft trial.
Yeah, no, I appreciate that.
Sneaker theft trial might be the better name to go with, but we'll see how it goes. The other defendant was brought in. He will be checked with at the first break. He is a sovsit and is spewing sovsit rubbish. Victim received a fractured skull. There was a pistol whip.
No, just kind of waiting.
Okay.
Involved. Now you can go refill your water bottle, sir. Skip forward, see what happens here. Oh, he's back with his water bottle. Let's see.
4 jurors are on their way.
Cool. Do you have a Sharpie, or did they take that too? I don't care what color it is at this point.
4 jurors on the way. It's going to be a quick voir dire.
No, they'll watch you.
Well, no, I gave it to Milanes, and Milanes was having people sign it. I don't know where Milanes went.
Okay, don't take that one. That's the last one we got.
We're a day behind on this trial. So we're going to be catching up. It is live right now. So we're going to be catching up to this one, and we'll follow this while we wait for another big case to come along. This is a big trial. I mean, it's got like 20 charges in here. In this particular case, there are 2 defendants. There are 2 other defendants who have yet to stand trial, so I know there are at least 4. But 2 of the people involved are going to testify against their friends. So
come on, man. You gotta be on point. She's here?
She said you in the gym.
Could we do a head count in there? So who's missing? Dude, where's Sergeant Palmer?
Oh.
That's awkward. I just wrote a contempt order.
I called her. I can tell you how many times. And she's like, you keep calling me and I'm sitting in the jury room. I'm like, what jury room are you sitting in? Thinking she's on.
Okay, just can you guys both look? There should be 13 people. There should be 14 people in the room.
You didn't dismiss 3?
Not yet.
Oh,
So there should be 14 people in there.
She's not getting in this room since 5 till 9.
Oh, my order was.
You're excited.
Yeah.
What happened?
She's here. She's been here.
Oh,
no. No way.
They didn't know.
We're verifying. And someone's going back to counting school. We have 14 people back there? Okay. So let's go back on the record, please.
Wow.
I won't name any names once we're on the record. All right, we're back on the record in State versus Pritchett and Robinson. We have a more official head count now, and we have all 14 jurors in the jury room. My thought is that we excuse juror 3 based on the record that was made when she came out to share with us the developments of last night. Sounds like, Mr. Hiles, you agree that that's the appropriate, based on the answer she gave and the things she said, that's the appropriate outcome. And Ms. Mignot, I know you agree with that as well. Any change?
No change, reluctant, but yes, I don't think there was any rehabilitating, kind of like juror 27 yesterday. So.
Okay. All right, Ms. Mignot, anything else?
Nothing else, Judge.
Okay, then why don't you bring juror 3 out? And then in a moment, we'll bring everyone else out. And if we could, Ms. Nelson, please cancel the 4 jurors who are heading this way. Oh, great. Thank you.
Okay.
Excellent. And we need to give Deputy Gordon 2 more fingers.
Do you mind if I get 16 back whenever you get a chance?
Oh, sure. I thought that was for me.
Watch that contempt order still get served. That would be
Juror 3, I want to thank you for your candor. And I'm sorry that being involved in this process has dredged up some of the difficult feelings. Hopefully it was maybe a cathartic conversation that you and your boyfriend had. But your candor with us has helped all of us, the lawyers and myself, understand that while you would make an excellent juror in lots of cases, this isn't the right case. So I'm going to excuse you, okay? I told you before you're not in trouble. In fact, where you would have been in trouble would be if you covered all that up. And then we got to deliberations and you completely melted down and said, I can't do this anymore. Telling us up front is the time to do it and not 4 days in. Okay. No trouble at all. Appreciate you coming back. If you just grabbed your stuff, you should head on out. Okay. All right. Thank you.
Grab your eggs, hit the door. Juror 3 is gone.
That's why.
Right. Your Honor, could we run to the restroom really quickly with all the trauma? I think I need to.
Okay. I don't know what you've been doing in the last 20 minutes, but if you'll go quickly, you can do that. Mr. Robinson, are you good? Because my plan would be we do these openings and we've had our morning break because we haven't started yet. So why don't you go? And this back. Yes, all right.
Right, yeah, Jackson. And then Holden. We might bring up.
Okay, so I think we need a hall pass on the thumbnail. We may be able to see the judge later on. I'm not sure if they activate those cameras or not. It's still early in the trial. Whoa, Roro, somebody died in this case? I thought we just had like a pistol whip and possible concussion. Interesting. Okay. Defendant is all by himself, no bailiffs around. He could make a run for it right now, because I don't believe he's chained. Looks like he's just working on the Wordle for the day.
It's all set to give the whole voir dire speech again, to reprogram. I've never had that happen before. That's fun. That's a new first.
You were excited about that order.
Yep, now I got to get rid of it.
Karen Powers.
Is she like under the table? Or?
Thank you so much for being a lurker and a member of the, and a member for 8 months. 8 months. Thank you very much.
Sure, that's what it was. Mr. Miles, will you take this? I'm apparently not supposed to keep it.
I'm glad it wasn't my cheeks that was put on.
Right.
Yeah.
Oh, thank you.
Did she respond to your text?
No, but she must. I wonder if she got my text and like alerted you, like, "Hey, I'm here." I don't know how you figured it out. Did you do a recount?
Yeah, I recount it.
I think Ms. Hansberry went in there and either counted and realized there were enough, but that's when that juror said, "Hey, you keep calling me."
Yeah.
We do have a backwards clock.
Maybe if you answered.
The Zoom feed is mirror imaging.
There's blame to go around.
Exactly. They went that way.
It's a setting that they need to adjust, but they haven't.
Okay.
Sure, how do I put this up?
Council, are you plugged up through remote? Are you plugged up with your PowerPoint through remote?
What are you talking about?
Are you remote?
Am I remote? Oh, I got a clicker.
Okay.
Is that what you're asking?
No, I was asking if you were coming through Zoom.
Oh, I will be, but I don't want to do it until I start.
Okay, got it.
Yeah, I don't want to have everyone walk in and be looking at the.
Yeah, so we'll wait on you.
Screen share, whatever you're ready to open. So when it's your time, just maximize it. Click on. I left this big, so it's easy to see. Just screen share something. So I can put the screen share.
You are in control of this when I'm up there.
Oh, sure.
Yeah, sorry, I have this. It's a shot, but it's too.
Oh, you're back.
Yes, sir.
I was like, why are we just waiting around? Okay, let's try one more time with Mr. Pritchett, just so we're making a good record.
Oh no, here
Please.
we go. Here we go. Sorry, a little echo there. I fixed it. Mr. Pritchett's coming back in to give his soft sit spiel. Let's see if he starts over or if he continues where he left off.
I need to give you something to throw at me in case I'm not speaking loud enough. Yeah. Okay. Well, then we'll call her first.
Sure. Make it fun. Make it go. We don't move, but I think you're right.
The missing juror was actually there all along. The bailiff just didn't count them.
I think it's better. It's a good call.
We're back on the record in State versus Robinson and Pritchett. Mr. Pritchett has been brought back into court. Two things for you, Mr. Pritchett. There is an exhibit list from the state, and then some family member of yours brought a document that she said you wanted. So that's the second piece of paper. I want to make sure you add those to your collection. And I want to know, again, if you would like to join us and participate. And yes, you're on the record.
This is all discovered.
I've given you an exhibit list and a document that a family member of yours wanted you to have.
Mr. McBurney, before you were a judge, you were a lawyer. Before you officially became a lawyer, you signed a title of nobility. How can this court lawfully move forward if you're not even supposed to be on the bench and according to the Constitution, you are no longer a U.S. citizen?
That's an interesting question. I didn't know I had a title of nobility. Maybe because of that, I could retire early. But for now, I'm going to stick with the title of judge and ask you if you'd like to sit or if you'd like to go back to lockup again, and we'll check during the lunch break if you want to rejoin us.
I will say that actually, I just had to understand what jurisdiction is this court operating on.
The jurisdiction of the laws and the Constitution of Georgia and the United States. So what's going to happen should you choose to sit down is the jurors are going to come out. I am going to swear them in and give them some basic legal instructions. And then it will be time for folks to give opening statements. You will have an opportunity to give an opening statement if that's what you want to do. When it's your turn, I will address you. It would be real helpful if you would tell me the manner in which you would like me to address you so that I don't get you upset by using a title or a name that for purposes of this proceeding you seem not to like. Are you prepared to answer that for me?
Yes. Can this court first take judicial notice that I am not the legal name of the legal person, Max Pritchett?
I cannot take judicial notice of that, but I would love to know, I'm gonna write it down, how you would like me to address you when we've got the jury in here.
Why can't judicial notice be taken of that?
Because that's not the type of thing for which judicial notice can be taken. Judicial notice can be taken of records in the court's docket, of non-arguable things like today is Tuesday, or when the sun rises, the sun sets, things that are incontrovertible.
So that's an arguable claim that I am the legal name of the person, Max Pritchett?
That's not what you asked me to take judicial notice of. Why don't you repeat that?
You said that I couldn't take, that the court couldn't take judicial notice of it because basically it's an arguable thing, and it's not an incontrovertible thing. I'm asking,
I thought you asked me to take judicial notice of the fact that you don't go by the name Max Pritchett.
Yes, that I'm not the legal person, Max Pritchett.
Right, and that's not something I can take judicial notice of.
That's a fact. And that is, it is an incontrovertible thing. Why can't you just go to judicial notice?
Because it's not. And that's not what we're here for. We're not here to litigate by what name you want to go. I'm showing you the courtesy of asking the title or name by which you would like to be referred while the jury's in here. If you want to answer that, that's great. If you don't, I'm going to refer to you as Mr. Pritchett. That may get you spun up in front of the jury. That generally doesn't help you. But if you want to tell me now, great. If you don't want to tell me now and don't want to sit down, we're wasting the juror's time again to accommodate you making this record about who you are, who you aren't, jurisdiction, admiralty, and things that actually don't have a bearing on what we need to do today and the next day and the day after. So tell me by what name or title you'd like to be referred.
I have an answer for that. I just have to make sure this court recognizes and understands the fact that I am not the legal person and legal name before me.
I don't recognize that, but I'm willing to refer to you by whatever name or title you would like.
So you're forcing me to be that?
I'm not forcing you to be anything. I'm just not recognizing something you want me to recognize. I don't force you to do anything. I am not recognizing the thing you would like to be recognized. In the same way, Ms. Mignot may have an objection. I may overrule it. I'm not forcing her to do anything. I just have disagreed with her.
So why is this court recognizing me as legal name Max Pritchett? There has been no evidence to prove that I own that name or claim that name as personal identification or consent that they will recognize.
There is evidence of that. I don't know that it will necessarily be presented at trial, but we don't need to get through what the fingerprints show, your fingerprints are linked to, et cetera. But I'm pretty comfortable that Max XX Pritchett is a name that's associated with the guy standing in front of me with the red jumpsuit.
Please see evidence. That's a claim that you may not have the right to see.
Okay.
See the evidence.
That may be something that you want to argue. I don't present evidence or anything like that. The state does. So, all right. You've got 3 seconds to take a seat. If you choose not to take a seat, we're done this time of the merry-go-round, and we'll have you go back to lockup. You're going to take a seat?
Just before I take a seat, just to clarify, being that you are avoiding the claim and the evidence of why you're claiming to be that legal person, Max Pritchett. I'm going to clarify jurisdiction. You said it was jurisdiction of the state of Georgia. I just have to clarify something that the Constitution speaks of 3 jurisdictions. Again, yesterday, which are common law, equity, and morality. Which of these jurisdictions will operate?
We're done with that conversation. Do you want to give me a name or title you'd like me to use?
So this jurisdiction is not constitutional. Is that what you're saying?
Mr. Pritchett, take a seat, please, or I'm going to ask the deputy to send you back to lockup.
And goodbye.
Okay. If you take him back, please. Because you didn't give me a different name to use.
Well, because you're still recognizing me. If I give you a different name or not, this court is still recognizing me as something that I'm not.
This is a great opportunity to take a seat. Going once.
I'm still trying to understand the jurisdiction of this court.
Okay, well, I'm gonna give you an opportunity to think more about it back in lockup, and we'll check in with you at lunchtime.
So the court labeling is disruptive because I'm not taking claim to something that they're forcing me to.
No, I'm labeling you as disruptive because you won't sit, and you won't tell me by what name you'd like to go.
See ya.
So I am once again excusing Mr. Pritchett from these proceedings because despite my repeated entreaties, he declined to take a seat. And while he does go by the name Max Pritchett on all legal records with which I'm familiar, to include the indictment in this case, he declined to share with me by what name, title, or moniker he would like to go for purposes of these proceedings. I will note he indicated he was going to sit, which was a positive development. We'll see what happens when he next is brought out. Let's bring the jurors out, please.
We'll take that as a win. At least this time he said he was going to sit. He didn't, but he said he would. This defendant, who I assume was a friend or acquaintance of the Sovsit, I wonder what his take is on this. He's like, oh, man, you're just making it worse. You're making it worse for me. Would you just sit down? Bring in the jury. 12 jurors will deliberate. We have 14 jurors on the panel, or I guess we have 13 now because we dismissed number 3. I don't know. We burned through a few alternates for some reason. The two college lacrosse players that were arrested with them are going to testify against these two defendants. That should be fun. Happy birthday, Krista. Good to have you here. You're a really loud whisper, and the mic is right in front of you. Could be worse, Carrie. It could be bleach.
I guess it's only fitting they're making us wait now.
The matter this morning with Judge Cedric got resolved by the judge pushing the date out 1 week, and it will probably be dismissed. I want to hear the opening statements just to hear what the full charges are in this case. It seems like a violent home invasion robbery at an Airbnb, like a party.
You all can sit once you find a seat you want to sit in.
Good. We get a little bit of juror heads visible there. There are two defendants. One is a soft set. One has representation. We get to see side by side.
Thank you, Deputy Gordon. Everyone else can be seated. Good morning, ladies and gentlemen. Sorry I had to sit around for so long. We had a couple logistical mix-ups. We're giving Deputy Gordon numbers 1 through 14 to count to next time. We thought one of you was missing, and everyone was actually back there. And we had to work through something with one juror. But we are ready to go forward. I want to remind you that this is the case of the state of Georgia versus Tyrone Robinson and Max Pritchett. I chatted with Mr. Pritchett, and he continues to elect to not be present for these proceedings, but he is one of the named defendants. I'm going to give you some basic operating instructions, and then we will dive into the trial. First thing I want to talk about is notes. You are free to take notes. There's no requirement of note-taking. There's no quiz at the end. What there is at the end is deliberations, when you all will be back in that room and you'll be asked to decide whether the state met its burden of proving beyond a reasonable doubt one or more of the charges in this case. And the way you decide that is by discussing with each other your feelings about the evidence, lack of evidence, conflicts in the evidence, strength of the evidence. Helping you remember what was said could be your notes. You will have all the exhibits that were admitted. So if there's a picture that someone shows of the house where the home invasion supposedly occurred, that picture will be with you during your deliberations. But what you won't have is a transcript of what the witness has said. We don't record that. There's a transcript made by Ms. Rivers, but that official transcript takes weeks to prepare because Ms. Rivers has to line up with what she's taken down, with what was said, et cetera. So you will not have a transcript. That's why we give folks notepads. Don't try to write down everything that's said. You can't, unless you're a court reporter, and know how to use a funky machine that doesn't have letters on the buttons.
What do we count in this case?
But you'll also miss out on important things. One of your roles is the determiner of credibility, the believability of witnesses. If you're buried in your notepad trying to write down everything, you're going to miss tells. You may have a witness who, when responding to one lawyer's questions, looks at you and is engaging. And the moment the questions get tricky, maybe she turns away or starts to get sweaty or who knows what. And you'll miss that if you're buried in writing things down. So feel free to take notes. Don't try to write everything down. And please keep your notes private until you begin your deliberations. You can use them as memory aids and you can share them with your colleagues during deliberations, but not before then. All right, before I tell you more about the case and your role and my role and the lawyer's role, I need to administer a second oath. You guys are no longer potential jurors. You are about to be officially the jurors in the case of the state versus Pritchett and Robinson. So if you could all stand and raise your right hand. Do you swear or affirm that you shall well and truly try the issue that is formed by this bill of indictment between the state of Georgia and Max Pritchett and Tyrone Robinson, who are charged with home invasion, armed robbery, aggravated assault, aggravated battery, firearms offenses, and gang activity, and a true verdict give according to the evidence?
I guess we
Do
can
each
see
of
the
you so
jurors.
swear or affirm? Yes. Does anyone not so swear or affirm? Okay, hands down, it's official. You are jurors. Thank you.
The
So from
jurors
here on
consist
out, your
of
home away from
blonde
home is the
women.
jury room. When you report each day, please go straight to the jury room. Don't come into the courtroom, and never enter the courtroom unless it's all 13 of you being ushered in by Deputy Gordon or one of his colleagues. When we're holding court, it's important that all of you hear everything that's said, not half of you, or we keep 7 down the hallway and 6 in here. So we'll have you all in here whenever we're presenting evidence or anything you need to consider as jurors. We try to run from 9 to 5. We were close to starting at 9. I think a couple jurors came in a little bit late and then thought we were missing one. We will stop around 5. It's not a bell goes off and we all run out of the building because it's sort of contextual. If we're in the middle of a witness and that witness finishes at 4:50 and the next witness is a witness who's going to take an hour, we're not going to start that witness. So we may end a little bit early. If we've got a witness who might finish up at 5:05 and we believe the lawyer's time estimates, and you'll come to appreciate the believability of lawyers' time estimates as we go through this trial. But if we believe the lawyer's time estimate, we might go a little past 5 just to wrap that up. But it won't be, I say 5, but we really stop at 6. And we will take regular breaks. There's usually a morning break. You've kind of already had yours. It was an hour and a half long. We'll always break for lunch. That'll be about an hour, and we'll have an afternoon break. There will be other incidental breaks, either because you ask for them, because anytime one of you needs a timeout, you just need to let Deputy Gordon or me know, and we take a timeout. It could be a quick one. It might not be the full-blown 10 minutes, this or that, but just I need to stand up or I got to go grab a water. And those waters in the jury room are for you, and you can bring the water out here if you need it.
Ooh, free water.
But we'll at least have morning, lunch, and afternoon break. During the course of the trial, it's important that the only people you talk to about, hey, what's going on, where should I go next, will be my staff and not the lawyers. The lawyers are going to treat you a little bit like you're radioactive, or they're radioactive and you're not. And that's nothing personal, but you can imagine how it would seem to a lawyer for one side if she's walking down the hallway and there's one of the lawyers and 3 jurors and you guys are laughing and this and that. And it may just be one of you said, where's the restroom? And the lawyer said something, told a funny restroom joke, whatever that would be. But we need to avoid that because there's an appearance that jurors and one side are talking. And that's not supposed to happen. It's all the jurors with everyone present. So if you're lost in the hallway or trying to figure out where a vending machine is, and here comes one of the lawyers and they see you and their eyes get big and they turn around, they're nice people, but they need to not interact with you that way. If they're going to be talking with you, it'll be here with me around as well. So I need to talk to you a little bit about the law, just some bedrock principles, and a little bit about the process. The main thing I want you to understand is that most of you haven't served on a jury before, and jury trials are not like what you saw on TV, if you've ever seen a jury trial. It will not occur during this trial that there'll be a witness on the stand and those doors burst open and someone comes in and says, I did it. That's not going to happen. It's going to be witnesses testifying, exhibits coming in. Some of it will be real exciting. Some of it will be real dry and boring. That's the nature of trials, criminal or civil. We've talked about note-taking. I have told you that the defendants are charged with a number of offenses, that is violations of the laws of Georgia. I'm going to read you now the indictment. I'm required by law to do that. This is long, it is dry, it has legalese in it. Don't worry about writing everything down. The document I'm holding in my hands will go back with you during your deliberations. You get the indictment, meaning you will receive the indictment. Both defendants, Mr. Pritchett and Mr. Robinson, are charged with almost all of the same offenses in this indictment. Count 1 charges, I should add this because you're going to have the indictment. Most of the counts charge 4 people. We've got Robinson and Pritchett, and then we have Ms. Riley and Ms. Kalish. They are not on trial before you now. They are named defendants, and you may well hear from them during this trial, but they are not on trial for this jury. So count 1 charges all 4 defendants, Kalish, Pritchett, Riley, and Robinson, with the offense of home invasion. And the allegation is that here in Fulton County on November 8th, 2019, those 4 defendants did commit the offense of home invasion in the first degree when, without authority and with the intent to commit a forcible felony therein, that forcible felony being armed robbery, and while in possession of a deadly weapon that is likely to or actually does result in serious bodily injury, those 4 defendants entered the dwelling house of Christian Riggs while that dwelling house was occupied by Holden Carmody, Christian Hooper, Noah Walker, Rebecca Mears, Jackson Buckingham, Vikyat Gatani, and Christian Riggs. Count 2 charges the same 4 defendants with armed robbery, and the allegation is that here in Fulton on November 8th, 2019, the defendants did unlawfully, with the intent to commit theft, take a wallet, the property of Holden Carmody, from the person and presence of Holden Carmody by the use of a firearm, an offensive weapon. Count 3 is another charge of armed robbery. It alleges that all 4 defendants on that same date, November 8, 2019, in Fulton County, did unlawfully with the intent to commit theft, take a wallet, the property of Christian Hooper, from the person and presence of Christian Hooper by use of a firearm. Count 4 is another count of armed robbery. It charges that the same 4 defendants on that same day in Fulton County did unlawfully with the intent to commit theft, take a cellular telephone, the property of Noah Walker, from the person and immediate presence of Noah Walker by the use of a firearm. Count 5 charges the same 4 defendants with another count of armed robbery, same date, same location. The allegation is that the defendants did unlawfully with the intent to commit theft, take a cellular telephone, the property of Rebecca Mears, from the person and immediate presence of Ms. Mears by use of a firearm. Count 6 is another armed robbery allegation, same 4 defendants. And the allegation is that in the same place, on that same day, the defendants did unlawfully with the intent to commit theft, take shoes, the property of Jackson Buckingham, from the person and presence of Jackson Buckingham by use of a firearm. 7 is another count of armed robbery. The 4 defendants are alleged to have, on that same date, in that same place, unlawfully with the intent to commit theft, take the wallet and cellular telephone, property of Vikyat Gatani, from the person and immediate presence of Vikyat Gatani by use of a firearm. The final armed robbery count, which is count 8 of the indictment, alleges that the 4 defendants in Fulton on that same day did unlawfully with the intent to commit theft, take a laptop, keys, and wallet, the property of Christian Riggs, from the person and immediate presence of Mr. Riggs by use of a firearm. Count 9 is the first of several counts of aggravated assault. And the allegation is that all 4 defendants in Fulton County on November 8th, 2019, did unlawfully commit an assault upon Holden Carmody by pointing at, toward, and in the direction of Mr. Carmody a firearm, that firearm being a deadly weapon. Count 10 is another aggravated assault charge, same 4 defendants, same place, same date. The allegation is that those defendants committed an assault upon Noah Walker by pointing at, toward, and in the direction of Mr. Walker with a firearm. Count 11, another aggravated assault, same 4 defendants on that date, in that place, allegedly did unlawfully commit an assault upon Rebecca Mears by pointing at, toward, and in the direction of Ms. Mears a firearm. Count 12, another aggravated assault, same defendants, same place, same date. The allegation is that the defendants unlawfully committed an assault upon Jackson Buckingham by pointing at, toward, and in his direction a firearm. Count 13, another aggravated assault, same defendants, same place and date. The allegation is that they unlawfully committed an assault upon Vikyat Gatani by pointing at, toward, and in the direction of Vikyat Gatani a firearm. 2 more aggravated assault counts. Count 14, same 4 defendants, same date, same place. The allegation is that the defendants unlawfully committed an assault upon Christian Riggs by pointing at him or towards or in his direction a firearm. And finally, for aggravated assaults, count 15, the allegation is that the same 4 defendants committed an assault upon Christian Hooper by pointing at, toward, and in the direction of Mr. Hooper with a firearm. Count 16 alleges aggravated battery. And the allegation is that the 4 defendants in Fulton County on November 8th, 2019, did maliciously cause bodily harm to Vikyat Gatani by fracturing his skull, causing permanent scarring. This having been accomplished by pistol whipping him and stomping on his head. Count 17 alleges that these 4 defendants committed a second offense of aggravated battery. And the allegation is that on that same day, in the same place, the defendants did maliciously cause bodily harm to Christian Riggs by seriously disfiguring his nose, this having been accomplished by punching him in the face. Count 18 charges all 4 defendants with the offense of participation in criminal street gang activity. The allegation is that on November 8th, 2019, here in Fulton County, the defendants did unlawfully, while associated with a criminal street gang, participate in criminal gang activity through the commission of at least one of the named offenses, specifically armed robbery, aggravated assault, aggravated battery, and home invasion. Count 19 charges all 4 defendants with possession of a firearm during commission of a felony. And the allegation is that on November 8th, 2019, here in Fulton County, the 4 defendants did unlawfully have on and within arm's reach an assault-style pistol, which is a firearm, during the commission of at least one of the following felonies involving Christian Riggs, specifically home invasion, armed robbery, aggravated battery, and aggravated assault with a deadly weapon. And finally, count 20 charges Mr. Pritchett only with possession of a firearm by a first offender probationer. And the allegation is that on November 8th, 2019, here in Fulton County, Mr. Pritchett did knowingly and without lawful authority possess an assault-style pistol having been sentenced pursuant to the First Offender Act to a term of probation on December 10th, 2018, in indictment number 18 SC 158229. Now, ladies and gentlemen, I just read to you a whole bunch, and it is proof of nothing. It is evidence of nothing. It's the way in which charges were brought against these 4 defendants. It should not be considered by you as evidence or implication of guilt of any crime whatsoever. Mr. Robinson and Mr. Pritchett are before you with the presumption of innocence in their favor. And this presumption remains with them unless it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that these defendants are guilty of one or more of the crimes charged. A defendant should not be convicted of any crime unless each element of the crime is proven beyond a reasonable doubt. This burden of proof beyond a reasonable doubt, stays with the state throughout the trial. There's not a point where I hit a buzzer or blow a whistle and say, all right, we've heard enough from the state, now let's hear from the defense. The defense has no burden in this case. Mr. Robinson and Mr. Pritchett don't have to prove anything at all. They don't have to mount a defense. Ms. Mignot doesn't need to say anything during this trial. I bet she will, but that's only because she's choosing to be a zealous advocate for her client and that she thinks that zealous advocacy involves saying some things to you. But there's no burden on Mr. Robinson or Mr. Pritchett to prove or say or do anything during this trial. Proof beyond a reasonable doubt does not mean the state must prove a defendant's guilt beyond all doubt or to some mathematical certainty. Reasonable doubt means just what it says. It's a doubt based upon common sense and reason. It's not a vague, arbitrary, or speculative doubt. It's a doubt for which a reason can be given, and that's a reason that arises from your consideration of the evidence, lack of evidence, or conflicts in the evidence. If, after giving careful consideration to the evidence in this case, you find that your mind is wavering, unsettled, or unsatisfied, that is reasonable doubt, and you must acquit the defendant or defendants. But if no reasonable doubt exists in your mind about the defendant's guilt, you would be authorized to convict. Now, the basic structure of the trial is, in a moment, I will be quiet, and the parties will be given an opportunity to present what we call opening statements. These are a preview of what the lawyers think this case is about. It is not evidence. In fact, nothing the lawyers ever say in this trial is evidence. What witnesses say under oath is evidence, and exhibits that are admitted is evidence. That's it. Not what the lawyers say, not what I say. When the opening statements are done, the lawyers have shared with you what they think this case will show or will fail to show. Then I'll turn to Mr. Hiles and ask him to call his first witness. He'll call Jane Doe. She'll come up here. And once Jane Doe is sworn in and begins answering her first question, you'll begin receiving evidence. Evidence begins when that first witness starts talking under oath. That's when you start hearing the facts of the case. Evidence will also come to you in the form of numbered exhibits, like I mentioned, a picture or evidence that was collected. Anything that's admitted, given a number, is likely going to go back with you for your deliberations. At some point, when I ask Mr. Hiles or Ms. Green to call the next witness, one of them will say, Judge, the state rests. That will complete their case in chief. And I will turn to Ms. Mignot and ask her if she's going to call any witnesses. She may say, I've got none, I've got a bunch, but again, no burden on the defense. So the trial may be done for evidentiary purposes when the state rests. But a defendant has an absolute right to present evidence if he wants to do that. And Ms. Mignot will be given that opportunity to do so on behalf of her client. When the evidence is closed, when everyone has said, I rest, then we have what we call closing arguments or summations. And the lawyers will get back in front of you, and they'll be given an opportunity to persuade you to decide the case in their favor. They will argue to you, this is what the evidence showed or it failed to show, this witness isn't believable or is believable. You should feel free to be persuaded by the lawyers, but don't take what they say as evidence. You decide what the evidence is. If they're telling you, man, it was raining that night, and you don't think it was raining, then they didn't persuade you of that. But the fact that the lawyer said it doesn't make it so. When the lawyers are done with their closing arguments, I will give you more law that you must apply to the case. And that'll be when I tell you the elements of the crimes and things like that. Excuse me. After all that, you will retire to the jury room and begin your deliberations. Before then, you should not talk about the case with each other. And that may seem a little counterintuitive. Judge, we have a day's worth of evidence. Shouldn't we already be saying, how do you feel about this? Answer no, because you don't have all the evidence. And more importantly, you don't even know the law that you have to apply. What are the elements of home invasion? You don't know. So how do you know if the state has met its burden of proving home invasion beyond a reasonable doubt until I tell you the state has to prove A, B, C, and D? You've got that framework, and then you begin to drape the evidence over it to say, I'm convinced beyond a reasonable doubt that happened, or I'm not. Element 3, there was no evidence of that, or the evidence in conflict. So resist the temptation to talk about the case amongst yourselves before that point of beginning your deliberations at the end of the trial. During trial, the attorneys have a right to object to the evidence that is being presented. This you've seen on TV, someone, objection, hearsay. You'll hear things like that during the trial. I need to rule on those objections. I will sustain the objection, which means the question needs to be changed or withdrawn, or I'll overrule the objection, which means the lawyer can keep on going in the direction she was going. You should not consider my rulings as any type of commentary on good lawyers, good evidence, bad evidence, someone's doing a better job. I'm simply applying the rules of evidence as I understand them to the objections that are being raised. Every once in a while, an objection will be raised only after the witness has started to answer, because the question was a neutral question. Lawyer heard it and said, oh, that's a fair question. And then a witness strays into an area that might be legally objectionable. And so a lawyer could say, objection, judge, hearsay, whatever it is, move to strike. And that's a request to have me tell you to disregard what the witness said. That may seem like an unfair task. Judge, I heard what the guy said. You may even have written it down. If I tell you to disregard it, you should cross it out. And if for some reason during your deliberations, one of your group says, hey, remember that guy who talked about what color shirt that woman was wearing during the situation? And that was what I told you to disregard. I need you to police that and say, hey, we're not supposed to consider that. Now, I promise you, if it is something fundamental to your deliberations that sneaks out, I won't tell you to disregard that. That's when you're going to hear a lawyer say the dreaded words, Judge, I have a motion. What that means to you all is you get a bonus break, because a motion is usually something that we need to talk about outside your presence. I can handle the objections. Lawyer can say it's hearsay. Here's why it's hearsay. It's not hearsay. And you can listen to all that. But a motion usually involves a lawyer saying, I believe the witness just did X, and here's the problem. Or the witness is about to say these things that the jury shouldn't hear. They need to talk about that outside your presence. So this notion of you needing to unremember what you were told is actually a fairly bearable burden, because it's usually something that is almost a non sequitur to the trial. But if it was improperly admitted, it needs to be stricken. And so it could well be that the person said, oh, someone told me it was cold that night. Well, it's hearsay. Someone told you that, move to strike. It doesn't matter whether it was cold that night or not. And so you ignore that it was cold and never comes up again. I've talked about my role and the lawyer's role. I rule on their motions, and they make motions and objections. They ask the questions, et cetera. You've got an important role as well. You are the fact finders. You are deciding what happened in this case. And while I will instruct you on the laws that you have to apply to the facts, you'll be deciding what happened in this case and what the state has proven or failed to prove. And in doing that, you will necessarily be deciding the credibility or believability of the witnesses who appear before you. And in deciding credibility, you are free to consider all the facts and circumstances of the case, as well as the manner in which the witness testifies. That's you watching the witness as she's answering questions, and the witness's interest or lack of interest in the outcome of the case. Now, in fulfilling your role as the fact finder, you may have questions sometimes. Questions usually come from the lawyers, answers come from the witnesses, and the lawyers generally do a pretty good job of covering the landscape so that when a witness leaves the courtroom, like, okay, I understand what was going on there. It is perfectly natural and not at all uncommon for you to have a question that wasn't answered by the lawyer's questions. And the way we scratch that itch is by having you, and they're not out there right now, but there's going to be a big stack of note cards on the little shelf there. And you should feel free to write down any question you've got for each witness, and we'll do this for every witness. When the lawyers are done with their questions, I'll turn to you to ask you if you've got any questions. And if you do, you don't raise your hand and belt the question out, but you write it down, as many questions as you can fit legibly on one side of the card. Don't put your name on it. Doesn't matter whose question it is. It's a juror question. Deputy Gordon will collect those questions. I'll review them with the lawyers, because just like a lawyer can ask a question that's an objectionable question, jurors can as well. And all the legally proper questions I will pose to the witness. So you will get your question asked if it's a legally appropriate question. The lawyers will get a follow-up after that, because most times you guys ask a really interesting question that the lawyers didn't think about, or they would have asked it. And so they have some follow-up. But I encourage you to do that because that is your only outlet to getting questions answered. It is improper and will cause a mistrial and get the infractor into a whole lot of trouble if you do outside research. If it is really important for you to know what the weather was like the day of the incident, write it down on a card, and for the appropriate witness, that witness can say, I don't remember, or it was raining, or it was sunny, or whatever's going on. Do not go online and look up on the Farmer's Almanac what the weather was like in Atlanta on November 8th, 2019. That is outside research. That's information you are bringing into your deliberations that the lawyers didn't get a chance to object to, or rebut, or supplement. And I certainly didn't get to tell you that's not even admissible, that's irrelevant, or whatnot. So this has been the downfall of many a trial in America since the advent of cell phones and Google. People get online, hey, I'm gonna look this thing up. I didn't, the lawyer used this word, or this expert witness used a word, I don't know what it means, and no one explained it, so I need to figure it out. And you go back in the jury room and you tell everyone, I looked up the word sanction, and sanction means to prohibit. It sure does. It also means to authorize. And you've introduced the wrong meaning of the word for the purpose of this trial. And the jury just took a left turn when they should have taken a right turn. So if you've got questions, write them down. And if they're proper questions, they will be posed to the witness. You may, during the course of this trial, receive evidence that one or the other defendant, Robinson or Pritchett, has been involved in other acts that are not charged in this indictment. Should you receive that information, it will be for a very limited purpose, and it will be for that defendant only. And you'll be told before it happens. You don't need to be on the lookout for it, but I'll be giving you limiting instructions that the evidence you're about to hear, if you credit it, should be considered only as to Mr. Pritchett or Mr. Robinson and not the other. And I'll let you know the purposes to which that evidence must be limited. 99% of the evidence is to be used in whatever way you think is appropriate, but there may, during the course of this trial, be some evidence that is to be used only for limited purposes and or against only one of the two defendants. It is critical that you pay close attention during the trial. There's no rewind button. If you come in tomorrow saying, hey, that witness from yesterday, she was kind of hard to hear. Could you bring her back? No, can't do that. So if at any point you cannot see, you cannot hear, or you just need a break because we've been going on too long, stop us. You don't have to stand up and yell, stop, but just like make a gesture, get the deputy's attention, get mine. We'll have a witness speak up more, speak into the microphone, shift the microphones around, or give you the break if that's what you need, because you all need to receive this evidence. I don't, the lawyers don't, you do. So be comfortable, let us know if there's anything we can do to address it, any discomfort that you have. It is critical that you approach this process with an open mind and avoid the temptation to begin deciding the case, in particular as a group, that's prohibited, but even individually early on in the trial. You need to decide this case based only on the evidence presented here in court, no outside research, but you should make your decisions only after you've received all the evidence and not how that first witness was amazing. I know what this case is all about. You don't, you've heard from one witness, and there's much more to go. And again, you don't know the law that you must apply to the facts as you find them to be. There will be some media coverage of this case, as you may have noticed when you walked into the courtroom. So you need to remain vigilant as you're driving home. If you start to hear a story on the radio or you're at home and you're watching the news and they say, next up, trial of Max Pritchett or Tyrone Robinson or home invasion case, change the channel. Don't watch that news coverage because that is a reporter's synthesis of what he or she thinks the evidence was all about. And they're not a juror. Don't know that they even got it right. I've read some stories and I sometimes wonder, were you in the same courtroom I was in? You need to be on a little bit of a news blackout. That means that you need to be thoughtful about how you interact with people close to you in your life, because you may have a friend or a family member who said, hey, I just saw this story. Is that your trial? Don't tell me what you saw. I don't want to engage with you on that. You may want to engage with them, but you can't engage with them at that point, because they'll say, hey, I saw this story and I can't believe this happened. You actually know what happened because you were here in court. So it's a little trickier than our usual trials where there's zero coverage. There'll be a little bit here, and you need to isolate yourself from that. It is not to the level where I need to sequester you. I have had a trial where the jurors had to go to a hotel every night and stay in that hotel with no TVs and come back to court. That's not this by any stretch of the imagination, but just be aware. And when you are interacting with people outside of court and they ask you how it's going, say, it's great, full stop. How about those Braves? Or you watch the NFL draft or whatever it is you want to talk about. Don't talk about this and tell folks you can't really engage with them on it. When the trial is over, it's open season. You want to write a book about it, you want to do some pottery based on the trial, anything you want to do, you're free to do. The news blackout, you can look at all the stories you didn't get to watch, you can go online, but that's after you're done. Whatever verdict you reach or you don't reach a verdict, when I excuse you at the end of the trial, it's open season. Between now and then, you're going to be kind of boring amongst your friends when it comes to, hey, how's your trial going? Can't tell you about it. Judge is great, that's it. So that, my friends, constitutes my preliminary instructions to you all. I fear that our camera went out again, just as we're going to shift to, let me see if I can bring it back. We have a camera above your heads that captures what's going in the well so that folks can see the lawyers but not see you. And as I was talking with you, some of you noticed because you suddenly looked at the screen because what was on the screen shifted. And that camera, there's a computer, I think it's someone's feet down there, whatever it is, don't kick it if you see a computer, but there's some device that controls it that's in the jury box. And so IT can't fix it while you guys are there. I'm gonna see if I can reconnect it. And then either way, we're gonna go forward with the state's opening. Give me 1 second.
Judge is like, I can do this. I don't need IT. We do have a camera in the courtroom. Not sure if that's ABC 7. I'm curious to see what news outlet will be covering this and if they cover it gavel to gavel. That might be neat to have a second angle of some events as they take place. Yes, you may notice that they're changing positions.
Mr. Hiles.
This image is reversed. It's mirror image. The clock's backwards. Here we go. Opening statements. Lots of charges in this one. This one's serious. I'm not a big fan of PowerPoints, but it looks like that's what we get. Who chose the colors on this? Contrast is good. It's just,
This is the state of Georgia versus Max Pritchett, Tyrone Robinson, Lindsay Kalish, and Lauren Riley. It's the trial of Max Pritchett and Tyrone Robinson. But as you've heard, both Ms. Kalish and Ms. Riley are charged with the exact same offenses as their co-defendants. The reason they're not before you right now is because you were going to hear from them during this trial.
Technical issues?
Of course.
Of course. I got the jury camera back on.
This is a case about games, greed, guns, and lust. It's a collision of two worlds. You're going to see two privileged girls who grew up in North Fulton, who were obsessed with the studio life, the gang life, the YSL criminal street game. They're privileged girls lusting after a life that was not theirs, that they did not need to be a part of. And then you will see that this was also an opportunity of gang members to take, not advantage of these girls. These girls put themselves in the position they did, but to seize on an opportunity to rob some of their friends of drugs and of cash. Now, this took place on November 8th, 2019. Some of the planning started on the late hours of November 7th, going into the morning of November 8th. But Lauren Riley, Lindsay Kalish, Tyrone Robinson, and Max Pritchett together committed a home invasion at 1040 Wiley Street just after 2 a.m. Now, not all of them were robbed. Each one played a different role. But because this was a conspiracy, this was an agreement to commit a crime, an armed robbery, a home invasion, each of them is equally responsible for the actions of the others. And that's what the evidence will show. And that's what you will learn. Lauren and Lindsay, they first arrived at the house. Only one of them knows one of the victims, Christian Riggs, and Christian Hooper. And they go in, they scout the party, not knowing anyone else. But they take pictures of where the drugs are located and then send them back, that picture back to Pritchett and Robinson, who are waiting armed in the car. The girls leave, leaving the house unlocked, and then Pritchett and Robinson come in. Pritchett and Robinson were masked. They were wearing clothes, backpack, guns. There's not going to be a single victim that is going to point to the two individuals that are charged in that case and be able. Those are the two that robbed them. All of them were consistent when this incident happened, and are consistent now that they couldn't pick anybody out. They just know that they were robbed by two men wielding AR-style pistols, wearing what they describe as purge masks from the movie The Purge. 7 victims inside the Airbnb, which was rented by Christian Riggs, Jackson Heil, and Holden Carney. You will see on the indictment, Mr. Heil, he is charged as Jackson's Buckingham. He actually has four names, 2 middle names, and so Buckingham on his ID appeared to be his last name, and no one bothered to look at that second line. But these are the defendants in this case, is what this case is about, not the victims. The defendants made a decision to beat multiple victims as they stormed the house, masked and armed. Once all the evidence is presented, there's going to be no question as to the key facts. The defendants, Mr. Robinson, Mr. Pritchett, Ms. Riley, and Ms. Kalish, were all present at this home invasion. And all the evidence will agree with that. You'll hear it both in testimony, but you'll see it also corroborated in records, Instagram records, cell phone dumps, the conversations in between the execution of this home invasion and the individuals getting caught. They were discussing how they were going to get the proceeds from the robbery, how they were going to sell the drugs that were stolen, referring to each and every person by the names that they knew to find. And we'll talk about the names of these individuals in a shortly. But what you'll see of these defendants, they committed this as a member, Robinson and Pritchett, as members of the YSL, Young Slime Life, criminal street gang. And the particular set that they were a part of
They refer to themselves as one of one. You'll see the defendants planned this home invasion at the condo of young Vance, who is a gang member and a rapper who goes by the name of Boss Coleman, and then returned after the invasion back to that same residence where the proceeds were dumped out and discussed. Mr. Coleman actually is not charged. As this goes on, you will see that, yes, he was a co-conspirator. He was involved in the planning. But this case is about the four that are charged, not who isn't. Here's what I expect the evidence to show. So, Mayfair condominiums, that's where Boss Coleman, young Vance, that's where he lives. On November 7th of 2019, you will see conversations that he invites Lauren Riley over to the house, where he discusses Pritchett being at the house with him, and that he also is informed that Lindsay is with Lauren, and that Pritchett wishes for Lindsay to come over together. So the individuals leave from the Mayfair condominiums. They go to 1040 Wiley Street, which is in Fulton County, which is where the home invasion, the Airbnb rented by the individuals is located. Crimes are committed, and they go directly back to the Mayfair condominiums. All right. Riley and Kalish were the ones invited to the condominiums. When they arrive, they see Max Pritchett, who goes by the name of Rick Rare. That's his nickname, I guess it's his stage name, but it's how he is known amongst his peers. It's how he holds himself out on the internet. That's his Instagram name. Boss Coleman, young Vance, is there. But those are the only two individuals that Lindsay and Lauren know. There are other individuals present. I don't know who they were, and Lindsay and Lauren were not able to tell me or the police who they were. But while there, one of the girls receives a Snapchat, a message through the Snapchat application of a party that's going on at 1040 Wiley Street. They get a picture of drugs. I think they described it as what they thought was ketamine and what they knew to be large amounts of THC edibles. Instead of saying, Lindsay, let's go to this party, what Lauren says out loud is that let's get lit, let's commit a robbery. And at that point, the individuals that are there start conspiring, decide who's going to go along. It's decided that Pritchett is going to be one of the members that goes wielding a firearm, but they begin looking for another individual. That individual is Tyrone Robinson. But Tyrone Robinson is known only to the girls, Lindsay and Lauren, as Baby Slap. You will hear the significance of that name, Slap, standing for slime love all the time, which is a common greeting of the YSL criminal street game to one another. And you'll see the significance of Folds in his involvement inside that particular criminal street game. But Baby Slap is called. He arrives at the house and Mayfair condominiums, and then all four then go to commit this armed robbery. So Riley, she drives her Mercedes that her parents bought her, occupied by Lindsay and Bridget, as well as Robinson. Kalish, you'll see the video of the two girls entering through the front door. You will see the text messages that Riley actually sends to Lindsay's phone. And that's an important aspect of this case, because what you're going to hear about Pritchett is that Pritchett was involved in another home invasion style case very similar to this. And the way that he was caught, and the way that his co-defendants were caught, was through cell site location information. And so this time, Pritchett was insistent that his phone not go to the front scene of the crime evidence. When they get there, they leave the house, both Robinson's phone and both Pritchett's phone remain at the Wayfair condominiums. This is corroborated through cell site location information, because prior to the armed robbery, there is activity on the cell site closest to that condominium on Mr. Robinson's home. And the duration of the robbery, there's no activity on that phone. But around the time that it said that they returned to the house, you start seeing more activity on that phone, showing that it's still pinging in that same area close to the Wayfair condominiums. You'll see Riley fleeing, you'll see the individuals coming in, and you can even hear the screaming in the initial attack as the armed gunmen, Pritchett and Robinson, begin to hit the victims as they enter the house. They steal wallets, phones, and the edibles, the THC edibles that were at the party. And then it was at 2:20 a.m. the 911 call was received by dispatch. You're going to hear from the victims in their perspective what happened. You're going to hear from all 7 named victims. This was an Airbnb that was rented for a Halloween party. 2 of the individuals were coming in town, traveling through Atlanta on their way to Houston to go to a Travis Scott concert. When they got together with another friend and decided that on their stay over, or get together, pool their money, rent the Airbnb and host a party. Not everybody at this party was close friends with each other. Each person seemed to have a close friend there, but not everybody was close with each other. But everybody had the confidence that who all was there. They knew they were close to someone they trusted. So there was some sort of circle of trust for what was going on at this party. The party was all but over when Riley and Callis showed up. And that's ultimately what broke this case, is that everybody at the party got a sense of unease when Lauren and Callis came in looking for, they didn't say hello to anybody. They just went all around the house like they were scoping it out. They were scoping. They were scouting. Only one person there knew Riley and Callis, Christian Cooper. And he had introduced Christian Riggs to Callis. But all the people at the party found their behavior to be odd. You're going to hear that there was a heavy presence of drugs at the party. Not going to shy away from that. But I honestly and truly believe, and I think you will see, it was that presence of drugs that was the motive for this robbery. That is what was going to be taken. Not everybody was partaking. Some people were drinking. Some people were using drugs. Some people were partaking in it. You'll also hear that everyone was caught off guard. When the 2 gunmen entered, they were wearing masks, and the individuals thought that maybe this is just some sort of prank continuing on the Halloween party. And as soon as they came through, the first person was immediately struck in the head. And that's when the reality of the situation came about. Some of the victims tried to confront the assailants, and they were dealt with violence. But Vic, Mr. Gacani, the DJ, he was the one person that was not confronted. He was beat without mercy. He would hear from all of the people that Mr. Gacani was begging, pleading for the individuals, hitting them with their gun. He's the one that sustained the worst injuries of all. So most of the people who were there, they're not even going to be able to tell you the race of the individuals that attacked them, that robbed them. But you'll hear that when they realized that it was a robbery, they did everything they could to not make eye contact, to stay away, to make as little presence as possible. There are a few of the individuals who were able to identify the race. Now, most of those are people who actually physically engaged with the assailants. They were able to see the hands that they were hit with, and they were able to see the neck area that was left uncovered in between the hoodie and the masks. But other than that, that's the only clue as to the race or the identity that the members, the victims, are going to be able to tell you. Most of the folks that were there were able to see the firearms. Like I said, some people just went into a cocoon and did not want to be present. But all that saw the firearms described them as AR or AK style pistols that looked to be like some sort of military grade. So this occurred on November 8th, 2019. The lead investigator, Carlos Maldonado, was not assigned the case until November 10th, 2019. And that's really when the investigation took off. Maldonado immediately interviewed all the victims. And he centered in on Lauren and Lindsay as being the facilitators of this armed robbery, this home invasion. He was able to identify Lauren Riley through Christian Hooper, who had gone to high school with her. Once he identified who she was, he was also able to obtain her Instagram handle through Christian Hooper and saw that Lindsay Callis was consistently with her. I mean, just all they were inseparable at the time. But Callis was easily identifiable as the second girl to enter that house based off the ring footage that was provided to the officers. The big break in the case comes on November 16th, 2019. That is when Lindsay and Lauren are called to APD headquarters to actually give an interview. They voluntarily show up. Initially, they are not under arrest. And initially, they're not truthful. They do not give a full account of what happens. They act as if they are victims. They lie about their involvement in this case. They're not truthful at all. They try to distance themselves. But investigator Maldonado was armed with a search warrant for their cell phones when they showed up. he already had the probable cause to believe they were involved, but maybe not to arrest them. So he immediately gets their phones. They are able to get into them with passcodes, not having to wait for assistance from the cyber department. And it is quickly apparent that they were involved in the planning. They are discussing how they are going to, what they're going to tell police, how they will distance themselves from it. They're also discussing whether or not they should flee. Should they even go talk to police, or should they get an attorney? But it's very apparent based off the messages between them that they were involved. A lot of what they told about tonight is what I've described to you. They didn't know these individuals as Max Pritchett, as Haas Coleman, as Tyron Robinson. They knew them as young bands, Rick Rare, and Baby Slap. They said Baby Slap by name consistently. Now, when asking with help to identify Baby Slap, when the couch was like, well, if you give me Instagram, I think I can find him. I think she initially said something like his name is Baby Slime, or his Instagram handle is Baby Slime. I know him as Baby Slap, and she can't find it initially. It's not till Maldonado confers with Lauren Riley that he's able to actually confirm the Instagram handle of Baby Slap, which was at the time 1100 Baby Slap. 1100, again, being a reference to the 1100 block of Ira Street, which is the, I guess, home base of where that one-of-one set of YSL operates out. So, knowing that now Kalish and Riley have identified Pritchett and Robinson as the gunman, luckily he doesn't just go on what the girls told him. He follows this up and finds some corroborating information. He gets search warrants for all of the parties involved for their Instagram records, which shows not only pictures, but also communications through direct messaging. It showed video calls of who they were communicating with through the app, and really a footprint of who these individuals were about. You'll also see that Pritchett and Robinson have deleted most of their accounts. And you'll see that there was a conversation between Lindsay and Baby Slap, Tyron Robinson, that was had discussing the selling of the proceeds of the armed robbery, which both parties had deleted. However, it was Lindsay's cell phone that maintained that data and maintained that conversation through the unique identifying numbers of their Instagram accounts. She deleted it, they deleted it from Instagram. She did not delete it from her messaging app on the phone that she was using to communicate through Instagram. Phone searches for Kalish, Riley, and Robinson were done. Evidence of the gang membership was abundant on Robinson's phone number. It was really corroborating what his Instagram had, what was being posted on his Instagram, the little that was left. And the cell location records for Pritchett and Robinson were obtained as well. The records for Pritchett will show that he was using a voice over IP address to communicate with his cell phone. So whenever he communicated, it would not activate the cell site towers, which were his downfall in this other case with the obstruction. Now, there is no smoking gun saying, we did this, I did this is how the plan happened, but it's discussions of things that would only be known to the people that committed these robberies that contained in these conversations. They corroborate what Lindsay and Lauren told the police officers. But I think what's important is not necessarily what Lindsay and Lauren told police, but it's what's important is what they told each other between the robbery occurring and them getting caught. They were consistently talking to each other about, do you think Rick and Baby Slide are actually going to pay us? Hey, please call Baby Slide and tell them we're giving money. Lauren Riley is actually so persistent trying to get the money from young bands that he outright blocks her. And you see these conversations dwindle as the girls realize they're being ignored, that they're likely not going to get the proceeds from the robbery. The sale of the edibles is where they were hoping to get cash from. And you'll hear them tell you this, but you'll also see it and how they discussed it without any knowledge that police were looking at them or that they may have been in any sort of trouble. You see the Instagram conversation that I just talked to you about. Here's what I really want to talk to you about. You might not like the witnesses in this case. A lot of what Lauren and Lindsay said to each other, it's disgusting. It's gross. And in the message that I'm talking about, I put it, is that once the girls, I don't think the girls knew that Mr. Pritchett and Mr. Robinson would be pistol whipping people, but they found out later that the individuals would beat up. And the messages between each other was, why is it so hot that the boys were beating people up? The response was like, so sexy. Even to the point that she said, man, oh my great. And that is what is said between them and their thoughts on this robbery initially. So I want to prepare you for that. Both of them are facing the same criminal charges as the two men that are sitting trial right now. Neither of them have been made any offers to resolve their cases, nor have they been made promises of anything of resolving their cases for their choice to testify. I think you will hear from both of them that they are hoping for grace, that they are hoping for a life sentence to testify. But as they sit right now, they sit in the same position as their two co-defendants. Now, Lauren will hear that both of these individuals got a bond over my objection. They were granted a bond. Lauren, when she was out, she gets rearrested. She's going to tell you she started dating another YSL member, another young Slime Life member. She gets in trouble with him. That relationship fizzles out. And then she dates a second higher ranking YSL member, which gives her some inside knowledge of the workings of the criminal street game. Not a lot, but some. And she's ultimately rearrested. When you hear from Lauren, she will be in handcuffs. And she has been shown no favoritism. You're going to hear from a gang expert, JP Miller. I say expert in the sense that he is going to explain to you the knowledge, he share with you this knowledge of how the gangs operate in the state, what it means to be a hybrid gang, what it means to be a set of a particular gang, and how these gangs commit crimes to truly further their interests, whether that be in a flagrant manner, how it intertwines with the music industry, how they're part and parcel. And one of the things he's going to really talk to you about is the importance of colors to gangs. That's kind of faded for most traditional gangs, but YSL, they still cling tightly to their color coordination, or it's slime green. You'll hear about that and you'll see the interplay of that in this case as it is unfolded to you. Burden of proof, all on me, all on the state. Never shifts. It is on me to prove this case, each and every element, beyond a reasonable doubt. That's not some unsurmountable task. If it was, there would never be convictions. What it means, and the judge will tell you, literally the definition is beyond a reasonable doubt. A reasonable doubt is that doubt of a fair-minded and impartial juror honestly seeking the truth. That's what I'm asking you all to do as jurors. Honestly seek the truth. I do want to mention that regardless of whether Mr. Pritchett decides he wants to participate in this trial, that doesn't change the burden of proof on me. I still have to prove every element of every charge that he is charged with. He has a right not to participate. He does not have to say or do anything. So please keep that in mind as well. Hold me to my burden. I feel confident I will meet. All right, remember, the victim and the witnesses are not the ones on trial. You might not like all of them. They might come from a different place than you come from. So keep that in mind. This is about the actions of Tyron and Max Pritchett. There's no justification for robbing. There's certainly no justification for violence associated with physical violence. You already have the upper hand. And there's no excuse for the defendant's conduct. No excuse, no justification. This case is about unjustified home invasion, uncalled for violence, innocent victims, and a gang that conspires to commit violent crimes. The evidence will be clear about all. Proof I told you about. And I will also state that these crimes were committed by members of YSL, and that this was a conspiracy and part of YSL. As a conspiracy and part of YSL, each defendant is guilty of all the crimes, regardless of who hit who or who took what property. It doesn't matter if one of the gunmen was the only person beating the victims. Everybody as part of this conspiracy, including Lauren and Lindsay, are guilty of those same crimes. So there is no, oh, that was that person that took this cell phone, and I might have taken this cell phone. I don't know which one took whose cell phone. It doesn't matter. This was a conspiracy to commit these crimes as part of a gang, as part of a illegal enterprise. Once this evidence is done, it's presented, we'll have a closing arguments in which I will ask you to return to the jury room and give a verdict of guilty on all counts.
Thank you, Mr. Hiles. If you'll stop your screen share, which you did, Ms. Mignot, your opportunity, should you wish to give an opening on behalf of Mr. Robinson.
Thank you, Your Honor. Good morning, ladies and gentlemen of the jury. Once again, my name is Marcia Mignot. I am the attorney for Mr. Tyrone Robinson. I have the pleasure of representing him as he sits here innocent of the charges that he's facing. I've been practicing law now approximately 21 years, and I wear a mask not as a political statement or a fashion statement, but because I have a special needs type 1 diabetic. And what might be a common cold or a runny nose for me can be an ICU visit for him. Thank you all for your patience as I put it on and off so that you know that it's not part of a gimmick or a game. If I limit exposure as much as I can protect my son. This case is about more than just young people at a party being robbed. I submit to you that the evidence is going to show Lauren Riley and Lindsay Kalish went to an individual's condominium by the name of Young Vans. Now, Young Vans is a rapper that has signed a contract for music. So as we all know from our experience, rappers can make a lot of money. So Young Vans is making very good money, and his home is at a Buckhead high-rise. At that apartment, Lindsay and Lauren go in on November the 7th of 2019. And they're there hanging out because they know Young Vans very well. And somehow, someone sends a Snapchat to one of the girls saying, Chris is having a party. Chris is not having a regular party. This is not a bunch of teenagers that's going to sit down and play games, maybe drink some beer. And we all know what we were when we were teenagers. Maybe somebody might have some marijuana. This was a drug party. And this Airbnb has been an eyesore for the neighborhood for quite some time. Because what do they do there? They rent it and they have drug parties. These are not innocent, we just go to college students. These are drug dealers. These are the individuals that we worry about as parents at night because our child could end up at a party consuming ketamine, marijuana, pills, and we get that dreadful phone call from the morgue. Your child's not coming back home. That's who these 7 individuals that the state is going to present to you as choir boy victims are. Lauren and Lindsay came up with a plan. They concocted a plan because these girls are living a double life. In one of their lives, they're going to college, they have scholarships, they're playing lacrosse, and in their other lives, they're criminals. They're getting arrested. They're doing drugs. And what did they do? They said, Chris, who we know to be a drug dealer. That's what the evidence is going to show. They are telling the detective when they finally start telling the truth. Chris is a drug dealer. They know he's a drug dealer. But Chris is not so dangerous. We can rob Chris because we know Chris. We know someone that went to school with Chris. They're going to trust us. So we're going to rob what we believe to be an easy target. They show the Snapchat to Young Vans, somebody they refer to as Rick Rare. Lauren is there and Lindsay is there. And guess who was not there when the plan was concocted? That gentleman, Mr. Robinson. That's what they told the state. In fact, the evidence is going to show that Mr. Hiles is asking Lindsay in an interrogation room with a bunch of people in there. So was baby Slat there when the plan was being concocted? No, it wasn't there. That's not good for the state. Because the state knows there were 4 people involved, 2 girls and 2 other males. Unfortunately, they caught up with who they thought it was. They could only get one of them, Mr. Burchett, because he has a relationship with Lauren and Lindsay. He knows them very well. They don't know my client. And they've already told Mr. Hiles he wasn't present. The conversation doesn't stop there. Because Mr. Hiles then says, so how does baby Slat get into this? Oh, I see. Remember, we're talking about manipulative people who are living a double life. I get it. I know what they want me to say. Baby Slat, oh yeah, baby Slat was there too. Because they need a 4th guy. Because the community wants to know where is the 2nd guy that was there that night. You're going to see the evidence in this case that Lindsay and Riley also told Mr. Hiles, hey, guess what? This is not the first one. Lauren had talked about robbing somebody else by the name of Maddie. Another rap gang, whatever Maddie does, or sells drugs just like Chris. But I thought, oh, no, we're not gonna rob Maddie. Because guess what? That drug deal with Maddie is probably way more dangerous, and she doesn't know him like she knows Chris. Chris is an easy target. Chris is probably not gonna call the cops. Because what are you gonna do? Call the police to say, hey, guess what? I was giving underage minors alcohol. I was giving them a bunch of ketamine. I was giving them drugs. I was giving them all this stuff. So, hey, can you help me? Chris is not calling the police. But somehow things got out of hand that night. People got hurt. Well, let me tell you what. Watch the evidence. Clear as day, the statement was, Mr. Robinson, who's known as Baby Slat, was not present. Let me tell you who Mr. Robinson is. Young, same age group as the girls, grew up in poverty, went to school, they're struggling, and there's 3 ways that you get out of poverty. When you're young, like me, ball player, rapper, or jail through the police. He chose rap. I want to rap. That's a way that I can make some money and help my family, I can help myself, I can help my sister, and buy my mom a house. These are the things that these children will talk about doing if they ever have an opportunity to get access to funds. That's what Mr. Robinson was looking for. So we're not running from the name Baby Slat. That is the name he used to rap. The evidence is going to show that when rap videos are getting produced and they say, hey, we need people to come to rap videos and you're going to be in the video, you need to show up. There's flyers that go out to them. And the young individuals who are trying to make a name for themselves in the music industry will show up and play roles in the videos. No different from, I want to be a model. And they said there's going to be a photo shoot. And there might be some supermodel, producer there or somebody might sign me and I might get it. No different. That's what his hand Baby Slat is about. The evidence is also going to show that the location, 1040 Wiley Street, Lauren and Lindsay arrived. You're going to see that. You're going to see them getting in. You're going to see them go in. Because there's no video of what's going on the inside of the building. You can only see what's going on the outside. They enter. And when they enter, state's going to call them. They're going to tell you there was underage drinking, drugs, people passed out. They're lucky nobody died from the drug use that night. But the state is not concerned about that. And that's why the prosecutor told you in his opening statement, oh, this case is not about it. Oh, don't look over there. Look over here. Underage drinking, illegal. Crime. No charges against Chris or anybody at the party. Having drugs there, crime. No charges against Chris or anybody there. Passed out. People passed out from drug use. No arrest. No case against anybody there. And the evidence is going to show that the state can charge everybody at the party and everybody who they thought robbed the bank. And everyone would get liberty and justice. That should be the case. Let's talk about what else happened. You're gonna see footage of Lauren leaving the party. She walks out the door, and you're gonna see her go to the right on Wiley Street. And she's heading to the right because she's telling law enforcement, that's where my car was parked, because the cars are parked on the street. The street doesn't have a whole lot of garages, and you have to park on the street. So I parked on the street, somewhere on the street, and when you see me go out the building and go to the right, I'm going back to my car because I forgot my cell phone. My phone battery was dead, and I had to go get it. She comes out. Lindsay is still in the house. And according to Lindsay, she's in the bathroom when she hears this whole commotion. People screaming, and she's hearing yelling, and she stays in the bathroom. And she was so terrified that she thought about coming through the window when she saw how high it was. She didn't want to hurt herself. So she waited. And she waited until she heard somebody say, we got to get out of here. And that's when she came out of the bathroom. Chris is there. They're all there with the drugs. Nobody has any pictures or evidence of that. Lauren and Riley are outside because Lauren now gets in the car. She's waiting on Lindsay. And Lindsay's delayed for some reason. Because that's what they planned. They planned. And according to their testimony and their statements and the evidence, Mr. Robinson was not part of that. They added him later because they needed a fourth guy. And it's easier to solve the case if we let's just go on our phones and see if we can find who we can make the fourth guy. So she's using the word slime. And slime is used by not just one, but several of these groups. It's used by the rappers, it's used by some what the state believes are gang members, it's used by some of the people in the evidence, the slime. It's kind of like Nickelodeon green slime. Maybe that's where the name came from. They're talking about slime. They're telling the state, we don't really know the fourth guy. We have no idea what the fourth guy is. When you meet the fourth guy, I met him that day. So everybody knows everybody, except Mr. Robinson. Now see the video. We don't really know who's driving that Mercedes. So the evidence is going to show that Lauren's Mercedes is moving, but it's hard to see who's actually driving. So it could be her because she's outside. And you can't see who's in the vehicle. It's hard to even tell if anybody other than a driver is in the vehicle. No other person can be identified on the surveillance other than the two women, Lauren and Lindsay. So you have to ask yourself, when the evidence is closed, state told you it's open. Evidence is going to show you're going to hear from them. Ask yourself why. How would it be important that they go last? Two masked individuals are going to be seen in the state's evidence, leaving the house party after Lauren Riley and walking in the direction of where Lauren says she parked her Mercedes. No one can see in the surveillance who the two masked individuals are. In fact, the angle of the camera makes it difficult to determine even a height of the person. Lindsay and Riley, they were called out of these. This is November 16th, about a week later. Because the area is in a uproar. It's a popular area. Everybody wants to know, hey, are we going to catch these guys? Are we safe? What's going on? So law enforcement brings them in. And when they bring them in, they start questioning. And in questioning them, Riley is questioned first by Detective Maldonado. She's questioned for about 20 minutes. Then you'll see Officer Jean-Pierre come in, and he questions for about another 20 minutes. Finally, Detective Maldonado brings a supervisor because the girls are going, hey, we just went to the party, we were by ourselves, nobody's with us, we went in and just living there first. Finally, one of the sergeants that's in the video says, hey, we know more than you think you know. It's time to come home.
Not footage, just a video. They're showing the girls a little few clips to get them to believe that everybody knows. We already know, so just go ahead and confess. Lauren says, Lindsay, we went into the party and we went to Sandy's house. And then after we went to Sandy's house, we went to the party and they leave out the young man's piece. The question again, and you're gonna see that when they're questioned again, the story starts changing. You're gonna see Lindsay Kalish get questioned by a female officer. And she's assisting Detective Maldonado with the investigation. They're asking additional questions to the girls. They start learning. During the questioning, Lindsay says she only knows Rick. Say has a hurt. I don't know who Rick is. There's times in her questioning, she was like, and the other guy, I met him the same day. I think his name might have been Sly. Then she says, I really don't even know if Rick is Rick. But never forget, members of the jury, as you process this evidence, we need a fourth person. You're gonna see the evidence that Detective Maldonado starts going through these levels while he's questioning Lindsay. And Lindsay is saying, goes by slime, I think it's slime. The word baby slut never comes up. You're gonna see where Detective Maldonado gets to a place on his phone where he's searching and says to the sergeant, you'll see in the video, the sergeant looks, they look at each other and they head nod. And they cry and show to Lindsay. So now instead of Lindsay giving information to law enforcement that law enforcement is going to use to locate the real fourth guy, what you have as law enforcement is giving information to Lindsay. What does she say? Yeah, that's it. That's the ticket. And he says, well, so is that his name? She was like, oh, I guess it's Slat. I guess it's Slat because that's what that says. So now the name Slat comes into the case. Because we're doing phone searches as detectives to try to determine who the fourth guy is.
We're doing phone searches.
Approximately a month later, Lindsay realizes, oh my God, this is real. I have a problem. I'm still in custody. I'm not home. This is not just, oh, we got in some trouble and then we're back home. I'm not home. She's still in custody. So a month later, she's being questioned. Detective Maldonado's in the room. House is in the room. Our attorney's in the room. There's another male in the room. They're questioning. Now her story changes. Oh, it was me, Lauren, Baby Slat, and Rick. And we came up with a plan. And now the whole idea was really Lauren's idea. It wasn't really my idea. And I said before it was the boys, but it wasn't the boys. And I really don't know the fourth boy because I met him that same day. The story is all over the place. And the evidence is going to show that. That during the interview, she never ever said slat until Detective Maldonado brought up something on his phone and showed it to her. And she mentions, thank goodness, because if she didn't mention, we wouldn't know. I guess it's slat since it says that on the phone. Ladies and gentlemen, this case.
Oh, look at the quote she used at the bottom.
Is what I put together when I thought about what am I going to tell these jurors to use as a synopsis of this case, that they can filter all the evidence through it as the evidence comes in this case. And I remember when I was growing up, the things they used to say is, oh, what a tangled web we weave. When first we practice to deceive. These girls are deceptive. It's hard to tell what happened. But one thing you're going to be able to tell is that nobody, not one person, is going to be able to tell you of the 7 that the state is calling alleged victims, can tell you that they saw Mr. Robinson. And when you connect that with the statements of Lindsay and Lauren, it's gonna be consistent because they said Baby Sly was not there. Make the state prove this case beyond a reasonable doubt, because the burden is on them. They must prove Mr. Robinson guilty beyond a reasonable doubt. The state conceded that in their opening. Oh, nobody's gonna be able to tell you that, they look like this or they look like that. They've already conceded that every day. So if the state is telling you that, filter your evidence through it. Nobody can identify him. That's a reasonable doubt. They have to prove it beyond a reasonable doubt. They're not gonna be able to do it. And the two people that the state wants you to rely on to give them a guilty verdict against someone who their evidence says wasn't present when the corroboration of this plan was put in place is the two women who cannot be believed because of the many lies that you're going to see throughout the evidence. So we filter it, ladies and gentlemen, and filter it through that old wives' tale and render the only verdict that justice demands in this case, that is not guilty. Thank you.
We have a mystery on our hands, folks.
Thank you, Ms. Mignot.
Oh, man.
So, ladies and gentlemen, we're at our first potential crossroads. We could have the state call its first witness and get a little bit of witness testimony under our belt, or you could take your lunch break. You're getting a lunch break either way. It's not an either or. It's just a question of, do we want to do about a half hour, a little less of witness testimony, get your lunch from, call it 12:30 to 1:30, or do you all need your lunch break now? Any consensus? You good? How about this? Is everyone okay going a little bit longer? Saying mostly yes. Let's go a little bit longer. Mr. Hiles.
State's going to call Sharon Latners.
Okay.
First witness up, Sharon Latners. We are counting jury questions. We're hoping we have some. I have some issues on this case. I have some issues. First of all, we found ourselves right back in YSL after not covering the other YSL case after what happened in that court. And here we are again, back with YSL organized crime charges. They didn't let the pro se defendant do an opening. They didn't. Love the judge. He needs to stop clearing his throat into the microphone.
We're not off to a great start with having our witnesses ready. Is there a different witness we could bring in?
They're all in the same spot, but do you want me to?
Apparently Ms. Latners is not in that. Either the spot is very far away or Ms. Latners is not in that spot.
I think she's coming, Judge.
Okay.
The other defendant chose not to participate in this portion of the trial. They'll talk to him after lunch, I think.
We swear affirm that the testimony you will give us is the truth, the whole truth, nothing but truth and God.
I
will. Say your name for the record.
Sharon Latners, SHARON.
Ooh, we got a view.
LATNERS.
And Your Honor, before we move forward, go ahead.
I failed to invoke the rule, Your Honor, and I don't believe the court did before.
I didn't. So great point. If there's anyone in court who is planning to be a witness in this case, has reason to believe he or she will be a witness, you need to step outside. All right. And I'll rely on the lawyers to continue to enforce that. You're going to recognize witnesses more so than I will. Let's go.
Good morning, Ms. Latners. Can you give your occupation?
I am custodian of records for the city of Atlanta.
And how long have you been working in that position?
20-some years.
And what does that job entail?
I handle all 911 police audios. I handle all the CAD report incident numbers. I handle all the subpoena cases, and I handle all the court cases.
Does your job as a record custodian include the responsibility for maintaining 911 calls?
Yes.
And how do you pull a particular call?
By incident number.
Okay. And what is a CAD report?
CAD report is computer-aided dispatch. On that CAD report, you will have the date of the call, the incident number. You will have the location, the time the call came in, who requested the call if they provide their name and their phone number. You will have the call type, which is Signal Square Police Department. And you have the remarks from the caller. You'll have the remarks from the officer in the field.
And just to clarify, CAD report, CAD?
CADS.
CADS, and what was the acronym for?
Computer Aid Dispatch System.
And in the normal ordinary course of business, when is the information that is included in the CAD report generated?
It's generated as soon as the caller advise the operator that he or she would like the police department, fire department.
Okay. And does the information in the CAD report accurately reflect the information?
Yes.
Okay. After this report is generated, the CAD report is generated, how long is it kept with the department?
We go back to 2000 at this time.
And how long are 911 calls kept within the department?
With 911, Atlanta takes over 1,000 calls a year. State provides us, we have to keep 5 years, but with us taking so many calls, the system purged the calls out. So at this time, we would say we go back to 2019.
I'd say a day.
And during your time at the department, how many CAD reports and 911 calls have you maintained? Rough estimate.
I've been there 35 years, so.
Big number?
A big number.
Okay. Do you recall pulling calls as it relates to this case?
Yes, I do.
And Your Honor, am I free to approach?
You are.
One time, I remember the court's rule.
Thank you.
And Your Honor, may counsel show me before the witness?
Always a good idea.
This should be about a 4-day trial.
State is now the
State is the 911 call from the date of the incident.
And what is the assigned case number to I'm sorry, what have I just handed you, placed on the desk?
You handed me the CAD report, which is the incident number, and you handed me 2 911 calls.
Okay. And how do you recognize the 3 items that I put before you?
On the CAD report, you will see my name printed by S. Latner. On the 911 calls, I listened to the call and I put my initials on the tab.
Okay. And was the recording in that CAD report kept in the regular course of regularly conducted business?
Yes.
And the record is one that is routinely made and kept in the course of business?
Yes.
It's a usual practice?
Yes.
And was these calls that you pulled made at or near the time of the call when it came in?
Yes.
And was those calls made by a person with the knowledge and from the information transmitted by a person with knowledge, and who reported the knowledge in the regular course of business?
Yes.
Okay. Okay. Has there been any changes, alterations, deletions to that information that I just handed you?
No.
All right, Your Honor, at this time, the state moves to enter in State's Exhibit 1A, which is the CAD report of case number 193-120-264. The state moves to enter 1B, which is the 911 call associated with that same case number. And the state moves to enter 911 call associated with case number 153-422-982 as State's Exhibit 2.
All right, Ms. Mignot, any objection to the admission of states 1A, 1B, and 2?
No objection, Your Honor.
They're admitted.
Ms. Latner, let's go over the CAD report that you have in front of you briefly. Permission to publish, Your Honor?
Yes, ma'am.
We get to see witness or we get to see presentations.
According to this CAD report, can you see it on your screen? Oh, you have a paper in front of you, okay. According to the CAD report in front of you, can you tell me what time the call came in?
02:20:21 AM hours.
Okay. And can you tell from the CAD who made the 911 call?
It just shows E911 caller and gave a phone number from the cell tower.
Okay. As you flip through,
Is that, I'm sorry, so there's on our screen, we've got a 843 area code. That's the phone number that made the 911 call?
Yes, sir.
Okay.
Well, we have that. It's hard to hide that.
and
Don't look at it.
what, according to the CAD report, what is the location of the incident?
1040 Wiley Street, Southeast Atlanta.
And where is that located?
Zone 6.
In which county?
Fulton County.
What time, according to that CAD report, You can scroll down. What time was the officers dispatched to that call?
First officer was dispatched at 02:23:55 a.m. hours.
Wow, lots of police dispatched.
And can you tell, well, let me back up. What are the notes? What are the notes in the CAD report? Just generally, what are the notes? How are they inputted into the CAD report?
Operator, 911 operator types it in.
Okay. And so this writing that we're seeing, you might see on your screen so that we're following all along. Are those remarks, notes that I'm talking about?
Are we talking right here?
Yes.
Those are units that the dispatchers, operator and dispatchers are two different people.
Yes. Let me scroll down to the notes.
Page 3.
Okay. So the page we just passed through was the dispatching of officers, correct?
Yes.
Okay. Page 3, what we're looking at now, would this be the notes?
Those are the notes from the 911 operator.
Okay. And what, sorry.
What do you mean? Oh, you're good. That's it.
All right.
No.
All right, thank you, Ms. Latners.
Ms. Mignot, do you have any questions for Ms. Latners?
Just briefly,
Deputy Gordon, can you get the note cards? I don't know if there'll be any juror questions for Ms. Latners, but I promised they'd have note cards, and we're not obliging. Thank you.
Good afternoon, Ms. Latners.
Good afternoon.
As it pertains to States Exhibit 1A, 1B, and 2, you don't have any information as to who's responsible for anything associated with the incident, correct?
None whatsoever.
Thank you. Nothing further.
All right. Any redirect?
No redirect. No redirect matter.
Any questions from the jurors? Well, thank you, Ms. Latners. Appreciate your time.
First witness down, no questions. Juror counter remains at 0.
Who's your next witness?
Can you tell me how long you want to go so I can gauge which witness to call so I don't?
Sure. I mean, you should call any witness you want, and we'll interrupt that witness. But I figured we'd go another 10 or 15 minutes. I was thinking break for lunch around 12:30.
All right.
So if you've got a witness of this duration, i.e. Ms. Latners, that would be a perfect fit. If it's longer, we'll pause it.
We'll do that. It won't hurt anything. Can we call Ian Brady?
Okay.
I have concerns that this is a case involving organized crime, even though it's loosely organized or...
Mr. Hiles, if you come get up at the podium as evidence from the previous witness.
And that the jurors... The jurors were shown.
It's Ian Grady, IANGRADY.
Is that a mustache he's trying to grow there? Doesn't show up clearly. Yes, he does have a little bit of a stash going on, I think.
Are you going to be asking the witness any questions?
Yes, I am.
Okay.
Hi, Mr. Grady.
Judge, like sometime today would be nice.
So what was 1040 Wiley Street to you?
That was my Airbnb, Fort Fiesta. So I think the name on the listing was.
Fort Fiesta was the name on the listing? All right.
Sir.
Did you own the house?
I did not. It was a rental arbitrage. John Morrison was the name of my landlord.
Okay. Did you have permission to run it as an Airbnb?
Absolutely.
Okay. How often were you renting it out?
Pretty consistently, although this was the last booking.
Yes.
My Airbnb.
I understand. How many people would the house accommodate?
It was a big house. I think the listing had it 4 bedrooms, 4 bathrooms, 4 porches. I remember that being. And then we also had a separate basement apartment. And I had a buddy of mine from elementary school living in the basement, which it had its own access point and you could lock it. So that was like a separate unit. That was not rented out during this instance. So.
Okay. Were parties allowed at this particular?
They had been in the past, although a week prior they had been outlawed by Airbnb. There was another Airbnb party that had gotten out of hand, and so this one in particular, although in the past I would have authorized a party if they'd asked, as long as they follow basic rules. I don't believe that there was one asked about for this particular party.
Okay.
What are those basic
rules? Did you maintain ring footage of
friend.
the front entryway?
Yes, sir.
Okay. Did you provide ring footage from the early morning hours of November 8th, 2019 to investigators in this case?
Yes, I did. The morning after I woke up and all the missed calls, I pulled the footage and I was able to kind of see all, I guess what you're about to show me, but it all kind of came together pretty quickly. That morning, I kind of could see what had happened.
Okay. All right, I'm approaching with what has been labeled as State's Exhibit 22. It is a thumb drive. Do you recognize that thumb drive?
I do.
Okay, and have you been able to view the contents of that thumb drive?
I did. I watched it on a laptop outside.
Okay, and is that your signature on your thumb drive?
Yeah, I initialed my I and G on the thumb drive, so that's the same one.
And are those video clips, are those full and complete clips of the information that you turned over to police officers from your ring footage camera?
Yes, they get clipped by like the software itself, like it triggers when it turns on, turns off, but those are the full ones that I was able to download.
So the camera triggered by motion?
Yes, sir. Motion, and those were Arlo, so those were triggered by sound as well.
Your Honor, this time the state would move State's Exhibit 22 ring footage from the 1040 Wiley Street address on November 8th, 2019 into evidence.
Ms. Mignot, any objection to the admission of State's 22?
Your Honor, no objection, conditioned upon that being the exact same footage that we've actually seen.
Well, I'm admitting 22. If there are issues, I guess we can take them up later.
Yes, sir.
So, because there are sound issues in the sound will lag behind the video, I'm going to direct your attention to the television screen.
We get to see the back of your head. Oh no, this is
so. Where was this camera actually located?
I know, even though I can't really see from, I guess you haven't put it up yet, but it was located in like the corner of the front porch. So you had like some steps up to the front porch, which was kind of underneath the porch above it, so it was kind of boxed off. And then up in the corner, it was aimed at, so you could see the front yard, a little bit of it, like the path, the sidewalk leading up to the steps, and then them walking in and out of the home. So it was a good spot for. It wasn't actually like the doorbell ring camera. This was an aimed camera. It also would cover like, cars coming in and out of the driveway.
Help yourself to the free water, sir. Two people walk up to the door, knock, go in. What looks like a male and female.
Okay.
So we have some form of record. You just played something. I know it's part of Exhibit 22. What did we just see?
So I just played for you what was labeled in the exhibit as girls arrived to the party.
Okay.
So
two girls.
From what you saw from that clip, is that how long the normal duration of each clip? Is it only active so long as somebody is in the frame?
Yeah, it's triggering events in the frame. So if there was more commotion, and there's a limit to that. I would notice that even if there was someone in the front, like constantly moving, it would eventually clip it regardless.
Okay.
And pick back up. But yeah, that was very normal.
Okay. All right. That's all that I intend to publish through you. I don't know if.
Okay. Do you have any other questions for Mr. Grady?
Yes. Did you have any complaints that arose from your property being a quote unquote party house?
I did. I tried to implement measures to, I was young once, but I tried to implement measures to make them, I don't see any reason why a party can't not bother your neighbors. And so I had very strict rules about, I did it based on the chairs that are on the porches. So on the front porch, you'll notice there was only 2 chairs, which is, I guess, plenty for someone to wait for an Uber while their friend is with them or smoke a cigarette or something like that, right? And so that shouldn't bother the neighborhood, 2 people on the front porch. And then on the back porch, there was more chairs, rooftop porch and side porch, so it was kind of laid out proportionally, despite my best efforts. And then this is, like I mentioned earlier, this was kind of the final straw, and I was like, I'm shutting the Airbnb down. But despite my best efforts, there would still be issues. Now, I didn't always find that the issues were warranted. Sometimes I thought the neighbors were complaining just to complain, some of them in particular. But yeah, it definitely, for the couple of years I operated that Airbnb, it definitely this wasn't the only time that there was a complaint from the neighborhood.
Okay. And was that your primary source of income at the time?
I'm trying to think. At the time, yeah, I'd stopped practicing law for a little bit. My father had gotten sick, and so he had a heart attack in the summer 2017, a throat cancer diagnosis in the summer 18, and then a stroke in the summer 19. So.
And you're not, I would have checked to relevant.
Oh,
Okay,
anyway.
that's okay. You don't, let's just keep the witness focused on what we're doing right now.
Yeah. So anyways, at the time I'd stopped practicing. I don't remember exactly in that timeline. This was 2019. I guess I was practicing law again. So no, this wasn't my only source of income.
Okay. And throughout your, outside of what you provided us, the videos of the girls coming in, would you be able to identify anybody who was involved in this robbery just based on your involvement?
No. I recognized the, I remember, I didn't even like, they're too small to even tell like who these faces are. The only people I was in contact with in the aftermath of the robbery was I believe the young man that actually rented it, because I hit up everyone afterwards. I'm like, what's going on? So I think I communicated with him a little bit, and I had his profile picture. But other than that, I don't know, the people who are involved.
Okay. And did you have any other context within or contacts with officers in this investigation outside of providing the video?
I think following up on the video, but no, that's it basically.
Okay. In what county was this house located in?
This was Fulton County.
Okay. That is all the questions that I have for this particular witness.
Ms. Mignot, any questions for Mr. Grady?
Good afternoon, Mr. Grady.
Good afternoon.
Did you have knowledge, or in your investigation, were you aware that Chris, the person you said was renting, is that Christopher?
I don't recall, actually, off the top of my head. I hadn't got a chance to review anything at the time. They do have a name, like there's a user that rents it on Airbnb. I do recall that, especially after it happened, I went back and rechecked all his reviews, and there was only one negative review, is for getting a couch dirty. So he had nothing, like 12 stellar reviews at the time, and no mentions of parties or anything like that.
Okay, so the person we're talking about is Chris?
I don't know. Whoever, I'd have to go back. I could figure it out for you. I just didn't prepare that for today, but I could go back through and look and see who actually booked. I have, screenshots of the Airbnb transaction.
Okay. Did any of your investigation reveal to you that this was allegedly a drug party?
I don't think a drug party. I don't know. I'm sure there are kids with drugs, but I think eventually get details from the news and stuff that there was, I think.
Unobjective, what, hearsay?
Yeah. Okay.
Yeah,
Sustained.
I don't have any personal knowledge of that.
Okay. Thank you, sir.
Okay. Any redirect?
No redirect, Your Honor.
Any questions from the jurors for Mr. Grady? Seeing none. Mr. Grady, thank you for your time.
Thank you, Your Honor.
Mr. Grady, take your water
Ladies
bottle.
and gentlemen, we're going to take our lunch break. It's about 12:35. That clock is slow. My computer clock is fast, so I triangulate in between. If you could try to be back by 1:40, that's about an hour. That ought to give you enough time. There are not a ton of places to eat real close by, but there are some. I think we have a list on the table in the jury room of the nearest places. American Deli. There's a Thai restaurant up Mitchell Street. There's often food available down on the first floor here in the courthouse. Whatever you choose to do, and you can bring in your own food tomorrow. And you can take phone calls during the lunch break too, so you're off by a minute. Don't talk about the case with each other. No outside research. The way, if you had a question of Mr. Grady about did he own other Airbnbs, not sure why that would be relevant, you'd write it down, and then I'd ask him that question. He'd say, I arbitraged 2 other Airbnbs. That's how we would do it. During the break, otherwise be at ease. There are 2 things I forgot to mention. One, this back hallway is yours to patrol quietly. If you feel a little cooped up in the jury room, there's not a problem moving up and down the hallway. You can post up way down. There's some glass and you can see sunlight. Just don't make a ton of noise in the hallway because there are 2 other judges and I don't want to get the equivalent of the angry neighbor calls like, there's a party in 8D because I can't throw you guys out. But it's not a problem to just be on a phone call way down at the end of the hall. So feel free to circulate that way. Second, when you come back in, you don't have to sit in this order. In fact, I'm going to fuss a little bit if the same people are always at one end or the other. As you've now seen, some of you get a real close view of the witnesses and some of you it's pretty far away. So rotate. Don't always be in the back row. Don't always be in the corner. Move around. There's no assigned seating. Any logistical questions? 1:40. We're going to try to start back up. Thank you so much.
All right, so they took a lunch then, and yep, there they are. Oh. Lots of ladies on the jury. Court feed provided by the court. Thank you very much. No party in 8D. Yes, party in 8D.
Mr. Hiles, anything from the state before we break?
Do you plan to bring Mr. Pritchett out before the break, or is that after the break?
After the break, nothing to do right now. He'd just be sitting by himself. So I'll bring him out when we're done with the break to see if he wants to join us for the afternoon. And then we'll do the same during the afternoon break. Anything else?
No, Your Honor.
All right, Ms. Mignot, anything on behalf of Mr. Robinson?
Just briefly, there might be.
I just never thought of like YSL and SovSit running together.
I think the court's intentions was not to have the juror seen. Am I accurate?
Yes.
Not necessarily. I mean, they're not being filmed there. They may periodically, you may catch the leg of one. What is being shared on YouTube is whatever is zoomed in on the screen, and I switched to the juror camera, so in general they wouldn't, but every once in a while it remains the witness camera and people see them walk by. The public courtroom, all these members of the public are seeing the jurors.
Love this
What
judge.
won't happen is our friends from WSB won't be filming them, but we've got a good understanding on that.
Understood, Judge.
Okay.
I did see them and I didn't want to not bring it to the court's attention.
No, I appreciate that. And if you saw it on one of the little cameras, that's not what's being live streamed. What's being live streamed is the big one. Okay, not a problem at all. Mr. Robinson, was your ankle situation fixed yesterday? It's not occurring again today?
No.
Pardon?
Yeah, fixed. So, yeah.
Not a problem?
Not a problem.
Okay, excellent, good. Then we're gonna break for an hour. We'll be back and you'll have witnesses pretty close to that door, ready to go for the afternoon.
I told him not to use the.
All right, what you need is your investigator back, so you guys don't have to run out and do that. All right, that's it. Thank you, everyone. I'm gonna mute the podium microphone so you can speak freely.
All right, speak your piece. We're gonna skip it. Oh, what did they show here? They show lunch break with food suggestions. That's great. Little lasagna. You wanna? What is that? Looks like a Swiss mushroom burger. We've got ice cream, and I don't know what's on the far right. But hey, we've got options. Lots and lots of options for lunch. So don't blame us if you don't eat something. Okay, we are coming back from court here in just a moment. Boom, boom, boom. There we go. Looks like in the Karen retrial, looks like they have seated a jury. Mathis says, we could also count That's Not My Name or Slime. Speaking of which, can I be a posh slime? You can pick between Scary Ginger, Sporty. Deal? Maybe not.
Miss, can we bring Mr. Robinson out, please? Thank you.
Here we go. Buckle up. Knock, knock. Who's there? We're not sure.
Right originally? 7393? Excellent. Were you the first responding officer? And back then you were right. Okay.
What does SLAT stands for again? Slime love all the time? Was that what I heard?
That's how they're reported. So that's everything written below is
Mr. Robinson showing how it can be done there in a suit, looking presentable.
All right, we're going to get on the record. I was a little late, so you had lots of time to talk about whatever you were going to talk about. So we're going to dive into things if that's all right. This is 20 SC 176922, State versus Robinson and Pritchett. Mr. Robinson is in court with his lawyer. Our prosecutors are here. Our next witness is going to be Officer Weems. But before we bring the jury in, I'm going to ask the deputy to bring Mr. Pritchett out, and we can try again to see whether he wants to join us.
Deputy's like, I love my job. I love my job. I love my job. I love my job. Yes, the holding cell is just right next door. It's right next door.
Ms. Mignot, did you figure out if that cable, 1 reaches and 2 connects in the way you need it to connect?
Yes, Your Honor, I did everything. I was efficient and I'm ready to rock.
Excellent. Glad to hear that.
Here's your boy.
Good afternoon, sir. We are on the record, and I wanted to chat with you again to see if you have decided that you want to join the proceedings. Are you prepared to take a seat and let me know by what name you'd like me to refer to you when I introduce you to the jurors?
Sure, I'll sit down. No, at no point do I waive any of my rights.
Okay, I'm not asking you to waive anything at all. As you know, my default has been to refer to you as Mr. Pritchett. That's how you've been introduced to the jurors in terms of a name. Is there a different name or title you'd like me to use when I'm turning to you? For example, with this next witness, Officer Weems, when she's testifying, the state's going to ask her some questions. Ms. Mignot may ask some questions on behalf of Mr. Robinson, and then you'll be entitled to ask questions if you want to. You're waiving nothing, and you're obligated to do nothing at all. But at some point, I'll turn to you, and I need, for the record, to say Mr. and I plan to say Mr. Pritchett, but I don't want to say that in a way that causes you to become agitated or frustrated or feeling like somehow your rights are being compromised. So again, my default will be to refer to you as Mr. Pritchett unless you tell me now by which name or title you'd like to go.
You can refer to me as the accused.
Okay. I think I can make that work. If it becomes unwieldy, then I'm gonna ask you for a substitute, okay?
Can you let the jurors know that by default you made a mistake by referring to me as Mr. Pritchett?
Nope. When you are given an opportunity to address the jury, which you'd have in your closing argument, because you elected not to be here during opening statements, you can talk to the jury about your theories and views of names and identities and all that. But so you're not surprised or confused, I'm going to explain to the jury that Mr. Pritchett has decided to join us, and he has asked that I refer to him as the accused from here on out, and then that's what I'll do. Okay?
Can you just refer to me as the accused and leave the Mr. Pritchett part out? That is not something I ever went by.
Okay, and you'll be given an opportunity at the appropriate time to share with the jury your claim that you've never gone by the name of Max Pritchett. But I've told you how it's going to play out. I have to explain to the jury who this gentleman who is appearing in the middle of trial is, and then I'm going to explain that you've asked to be referred to as the accused, and from that point forward, that's exactly what I'll do.
You should let them know that I believe that there has been a mistake as far as the court referring to me as that legal name.
Nope.
I'll fashion something along those lines, okay?
Oh, man, he's bending over backwards.
Let's bring the jury in, please.
He's bending over backwards. I wonder how long the judge's patience can last.
That's up to you if you're comfortable with them not being on. But if you're going to take them off, let's do it before we bring the jury in. That is a security question, not a McBurney question.
Judge doesn't care. Chain, not chain, doesn't matter. The bailiff says, I'm fine, meaning they're good. I only see one bailiff over there. You've got two defendants and one bailiff. The odds are not good, but...
Is that he has a pen? That looks like a pen, and that's all right? Yes. Okay, great. Okay, let's bring the jurors in.
He's got something in his hands. What is it? It's a pen. It's good. It's good.
How are we doing with jury charges, State? We got jury charges from the defense, and yours were due soon, as in they're late.
Huh?
When are we going to get your jury charges?
Shortly. I just sent them over to Mr. Abadi to add a couple more.
Great.
But I thought you said your email. I will have them by close of business.
Is that what my email said?
Yes.
Then they're not late. Business hasn't closed. Here we are.
He doesn't stand for the jury. Apparently, we're going to get to know all the jurors here eventually. At least two guys. Possibly three there.
Thank you, Deputy Gordon. Everyone else can be seated. Ladies and gentlemen, welcome back from lunch. We are joined by the person who has been indicted as Max Pritchett. He has asked that I refer to him as the accused. So at the appropriate time when we are cycling through State asked questions, Ms. Mignot asked questions on behalf of Mr. Robinson, I will turn to, as requested, the accused to see if he's got any questions of the witnesses. He has got the very same right as Mr. Robinson to participate in the proceedings. As I told you when the accused wasn't with us, he also has no burden of proof whatsoever. And so it may be that the accused doesn't ask any questions of witnesses, and you should draw no inference from that because he has no burden to do anything, in the same way that Ms. Mignot, on behalf of her client, may choose not to ask questions of a particular witness. But I wanted to explain, we have a new member in the courtroom, and that's who we're talking about. So we got ready while we were working through some of those other things, and the state's next witness is seated at the witness stand. That witness is?
Excuse me, Officer R. Weems.
Great. Officer Williams, we got to swear you in, and if you'll spell your last name.
That is the right hand. Mirror image.
Name is Roxanne Weems.
Somebody kicked the cable again.
ROXANNEWEEMS.
All right.
Should we change to the accused
Good
counter?
afternoon. Thank you for being patient with me today. Where are you currently employed?
We're up to
Atlanta Police Department.
4 right now, right?
And what capacity?
5.
I am a patrol officer.
Okay. Are you post-certified?
Yes, I am.
And how long have you been post-certified?
About 4.5 years.
We're doing accused counter.
And what are your duties as a patrol officer?
My duties are to answer 911 calls.
Okay. And what? All right.
More in detail.
A little more detail.
So I would do preliminary investigation. So I would go to a scene, speak with victims, render aid, call for medic if I need one, get crime scene out there to take photos, collect evidence, and just gather the preliminary information that will be then passed over to the investigators.
Okay. So if you respond to an armed robbery, that doesn't mean that you are going to carry the case throughout the investigation?
No, sir.
Okay. So is it when you refer to an investigator, what do you mean by giving it to an investigator?
Well, I do the report. The report is then assigned to a detective who would then follow up with the case.
Okay. And is that just the structure of Atlanta Police Department and their policies?
Yes.
Okay. Where were you working on November 8th, 2019?
The Zone 6 precinct.
Okay. And what were you doing that night?
Answering 911 calls.
Okay. And did you respond to a 911 call at 1040 Wiley Street?
I did.
Okay. And what prompted you to respond to that location?
I was dispatched to that call.
What type of call was it?
It was a robbery at a residence, or what you would call a home invasion.
Okay. And when you got there, what did you encounter?
When I got there, I immediately was met by some of the victims. They were outside off the location. Some were injured, and they were very frantic. But
and what was the scene? I guess as you saw, you said very frantic. What was the scene that you came upon?
It was a little bit chaotic. Young kids just frantic, just nervous about everything that went down. They were saying that they had some people over and that 2 men came in, injured 2 of their friends. So it was just very chaotic.
Okay. And without stating what anybody told you specifically, were you able to do some initial interviews on this scene?
Yes.
Okay. Do you recall how many people roughly that you interviewed while on the scene?
Approximately 7.
Okay. And what did you do with the information that you collected from those 7 individuals?
I completed a report.
Okay. Who did you turn that report into?
So when we complete a report, it goes to our supervisors who then reviews it and signs off on it.
Okay. How does it get assigned to an investigator?
Once it's signed off by my supervisor, it goes to that unit supervisor, and then they assign it to a detective.
Okay. And on the night of November 8th, 2019, were you wearing a body camera?
I was.
Okay. And do you always wear a body camera?
I do.
Okay. How does a body camera work? What does do you have to activate a body camera?
Yes, you have to activate the body camera.
Okay. So is it always recording?
Yes, it records until you deactivate it.
Okay. And was your body camera activated the night of this incident?
Yes, it was.
Okay. And what did you do with what do you do with the footage after an incident is?
Once we're done with the caller at the end of the night, a number, which is a case number, is assigned to the body camera, and it's just uploaded to our system.
Okay. And I'm approaching you now with who's marked as States Exhibit 40. All right. And do you recognize the thumb drive on States Exhibit, labeled as States Exhibit 3?
Yes.
And how so? How do you recognize?
Because it has my initial.
Okay. And you reviewed the contents of it, your body camera from November 8th, 2019.
Yes.
Is this a true and complete recording of the events recorded by your body camera?
Yes, sir.
Your Honor, at this time, I would move State's Exhibit 3, Officer
Weems.
Weems' body camera into evidence, and note that at the time it was recorded, it was Officer Wright was their last name.
Same person, different name.
Yes.
Familiar with that concept. Ms. Mignot, do you have any objection to the admission
We just
of
went over that.
State's 3?
I have
the
not
accused.
seen 3, Your Honor. I'm assuming it's in discovery, and assuming there's no hearsay issues with it, then I would have no objection.
Okay. Was State's 3 included in discovery as best you understand, Mr. Hiles?
Confident it was turned over.
All right. And the accused, do you have any objection to the admission of State's Exhibit 3?
He's doing it.
I haven't seen it. That's sent to me. Don't believe it.
Okay, thank you. 3 is admitted. Remind me, we'll have during a break, we need to talk. It's a problem when I hear from Ms. Mignot. I haven't seen this before. And so I guess my request of maybe Ms. Blake would be to run down it's not a very long exhibit list and see if you can find stuff. Because if you can't, they need to find it for you. I know it's a billion things in discovery, but it just makes me a little wary when you say, I believe in good faith. I haven't seen it, but also in good faith. I'm not saying it wasn't in there, but we're going to press forward. 3's been admitted.
Thank you.
Share the evidence, folks. Makes things much more smooth. This court is a little loud, like that. I'll turn it down just a tiny bit for a bit. See if that helps. Let's see. Does this? Let's see if this looks good. Can we do the say my name counter? Say my name.
Now, at what point does sound turn on these videos?
It buffers for like 2 minutes.
2 minutes.
So what do you mean by buffers?
So it would capture 2 minutes before I actually activate it. Those 2 minutes would be captured, and that's like a buffering mode where there's no sound until 2 minutes after.
I'm not going to play very much of this. I'm just going to ask you one question.
Time marker on the record.
For the record, this is the 2 minute and 52 second mark. And I fast forwarded to 3 minutes and 25 seconds in the video. The timestamp is UTC time 7:28. Now, looking at the screen, is this the scene as you observed it when you pulled up to the incident?
Yes, sir.
Okay. And so were those your first introduction to the victims in this case?
Yes, sir.
Okay. Were all of the victims outside when you
No,
pulled up that scene?
not immediately, no.
Okay. Let's see. And what county is 1040 Wiley Street located in?
Fulton.
Okay. And
I'm sorry, that would be DeKalb. That's on the DeKalb side.
do you know? If you don't know,
I think
okay.
it's Fulton, actually. Sorry. Mm-hmm.
Okay.
It's sort of important that the crime happened here in the county. That's like subject matter jurisdiction level importance.
You said you interviewed 7 individuals?
Yes. Mm-hmm.
Anything else? No, I don't want to know with other witnesses. It's hearsay. All right. That's all I have for you at this time. I think.
Ms. Mignot, do you have any questions for Officer Weems?
Briefly, Your Honor.
Good afternoon, Officer Weems.
Good afternoon.
Did you ever enter the 1040 Wiley Street location after arrival?
I did not.
Okay, so your entire involvement was what we've witnessed on the body camera interactions with alleged victims outside?
Yes. So usually it's a collective effort. There were multiple officers on the scene, some of which went inside. I was mostly outside trying to speak with the victims, one of which was being transported. So my main focus was making sure I got all the information that I needed to be able to complete that report.
Okay, and your report is associated with the work you did with interviews of people who were outside?
With all the victims, because they came out. All of them came out initially when I arrived. I was met by 3 victims. The other victims came out eventually.
Do you recall which 3 were outside?
I can only speak to the female in terms of Rebecca because it's easier for me to identify that name because she's a female. But the other 2, I wouldn't be able to specifically say their names.
Okay. And as it pertains to this incident, you don't have any physical description, you don't have any evidence that the individual involved in this robbery is this gentleman sitting right here, correct?
No physical evidence, no.
Okay, thank you, nothing further.
And now to the accused. Sir, do you have any questions for Officer Weems?
And again, I never received any of this evidence, or knowing that I know that she was going to be a witness. I'm not able to prepare, so I don't have any.
Okay, no questions. Any questions from any redirect, Mr. Hiles?
I don't have any redirect, Your Honor.
Okay, any questions from the jurors? All right, you jot it down on a note card. SOP.
We have a question from a juror. The guy in orange is he punking us?
I labeled it Riley car footage because it's her car. So we don't even need to play it. We just need to admit it through him.
Yeah, I'm just making sure it's the right thing. His initial wasn't using some of it.
You give him too much time, going once, going twice. It's terrible. You'd be a good auctioneer, though. All right, counsel, I'm gonna let you look at these. There's not a question for me to ask this witness, but you should see what the jurors were asking about. You may. And the standard will be, we'll go back in the hallway and talk about them. We don't need to talk about these. Okay. Thank you. They wanted you to play the whole body cam, but that's not your role. Okay. Thank you for your time.
Okay.
You are free to go.
All right.
They're like, show us the evidence. Show us the evidence.
Next witness.
The state calls Jonathan Vergras.
Okay, whoever's running the Zoom, if it's a court clerk or the judge or something, you got to be on it. We need court views when nobody's on the stand, witness views when they're on the stand.
Well, you sit there right now. This is affirm the testimony you'll give in truth, whole truth. State, spell your name for the record.
Jonathan Vigras, Johnathon, Vigrass.
And Mr. Vigras, you're soft-spoken, which is fine. Just make sure that you talk into that microphone so the jurors can hear you.
Gotcha.
Don't
Thank you.
Like the judge.
Good afternoon, Mr. Vigras. What is your occupation?
I am a sales engineer.
Okay. And what area do you stay in generally?
Currently, I live in Canton, Georgia.
Okay. And were you at one point a homeowner?
I was.
Okay. And what was the address of that home?
1016 Wiley Street.
He's the one that complained.
And was that, did you live at this address November 8th, 2019?
Yes, I did.
Okay. And what, if any, type of security did you have on the home?
I had multiple security cameras on the exterior of the home.
Okay. Describe how the cameras work. How are they operated?
Sure. So they record locally to a hard drive that I had in the house.
Okay. And what happens to those recordings?
So those recordings are stored for 5 days and then they're deleted automatically off of the server.
Okay. And what, if anything, triggers your devices to record?
Any type of motion.
Okay. So they're activated with motion?
Correct.
And then it's saved to the hard drive?
Correct.
For 5 days?
Correct.
Who operates this hard drive that's inside your home?
I do.
Okay. And how do you access the videos that you want to view on the hard drive?
Sure, via computer.
Okay. So you have a computer attached to the hard drive?
Correct.
Okay. Do you recall being contacted by law enforcement regarding an incident that took place on November the 8th, 2019?
Yes, I do.
Okay. And do you recall providing video footage to law enforcement?
Yes, I did.
How did you know what video footage to pull?
Sure. So the, excuse me, the police knocked on my door and they asked me if my video cameras worked, and I told them yes. And I told them that they could see video in the house from the previous night. So they came in the house. We watched the videos. They identified some videos from the time in question. They asked for a copy of those videos, and I provided a copy of those videos.
Okay. And have you seen that footage since you provided it to the office?
Yes, I saw that video this morning.
Okay, you're pointing at me. So are you talking about this?
Well, I don't know what's in that envelope. I can't see what's in that envelope.
Permission to approach the defense?
Yep. So all the lawyers, the parties have permission to approach witnesses.
Yes, Judge. Thank you.
Including the defense, including the accused can approach the witness? That means he has to be unshackled.
Let the record reflect on the approaching witness.
You have to say that.
Okay, and what did I just hand you?
An envelope.
He doesn't.
With the flash drive of the videos that I watched in the lobby, and I initialed it.
Okay. Let the record reflect the state just presented the witness with State's Exhibit 21. When you reviewed that footage, was a full, complete copy of the footage that you provided to law enforcement?
As I remember it, yes.
Okay. And the same footage that was extracted and provided to law enforcement?
Yes.
Okay. At this time, the state moves to tender State's Exhibit 21 as evidence.
Ms. Mignot, any objection to States 21?
No.
And the accused, any objection to States 21?
Same thing before. That's something I never seen before. So I have no objection.
Okay. And ladies and gentlemen of the jury, I should make clear to you, the accused has elected to represent himself. That was a decision made fairly recently. His counsel was provided all the discovery in this case. It is complicated for things like a DVD or a thumb drive or whatnot to be viewed where the accused is spending his time. So you should process what he's sharing with you consistent with what I've just shared with you. State's Exhibit 21 is admitted.
Thank you, Your Honor. At this time, the state will not publish it.
Okay.
Later. So the state will be
You're done with Mr. Vigrass?
done with Mr. Vigrass. No further questions.
Ms. Mignot, do you have any questions for Mr. Vigrass?
Mr. Vigrass, good afternoon. My name is Marcia Mignot.
Good afternoon.
I represent Mr. Robinson sitting here at council table with me, and I have just one question for you. You don't have any information as to whether or not Mr. Robinson is involved in any incident that occurred at 1040 Wiley Street, correct?
No, ma'am, I do not.
Thank you, sir, for your time. No further questions, Judge.
All right. And turning to the accused, sir, do you have any questions for Mr. Vigrass?
No, I would just speak on the fact that, again, when I did have the attorneys that were assigned to me and discovered that they did have, I did not see all of the evidence that was presented to them or being presented here today. And when I did relieve them of their duties, I thought I would have my full right of discovery.
Okay, well, we discussed that outside the presence of the jury, and I'm happy to take that up with you again outside the presence of the jury. Right now, I just needed to know if you had questions for Mr. Vigrass. It sounds like you have no questions for Mr. Vigrass. Is that correct? Okay. Any questions from the jurors? Seeing none, Mr. Vigrass, thank you for your time.
Thank you.
The jurors are
Back to
like,
Kim.
we have questions for the accused.
All right, next witness.
The state calls Jackson Heil.
Thank you.
Did you want me to show?
I think he's out of his league.
Anything you're going to show to a witness, you should show to Ms. Mignot as well as to the accused.
Will do.
Thank you.
We've shown Ms. Mignot all of the exhibits. We need to show the accused.
As long as both sides have seen it, both defendants need an opportunity to see what you're going to share with the witness.
What is it? Raise your right hand. You swear affirm that testimony you will give the truth, the whole truth, and nothing but the truth, so help you God. Sir. Can you state this your name for the record?
Jackson Heil, JACKSON HILE.
Good afternoon, Mr. Heil. Can I get you to give us your full legal correct name?
Jackson Beckett Buckingham Heil. You want to spell the whole thing too?
No, we're good with the first and the last, but what I do need you to do is sidle up a little closer to the microphone. It doesn't move, so you'll need to move, and the chair doesn't have wheels, but it moves. If you give it a heave-ho, you'll get closer. Thank you.
Is that better?
Much.
Cool.
Mr. Heil, would you let me call you Jackson?
That's fine.
Okay. Jackson, how old are you?
I'm 23 years old.
Okay. Are you at school, working?
I'm full-time in sales at Hudson Nissan of Charleston,
Okay. Charleston.
South Carolina.
So you live in South Carolina?
Yes, ma'am. Born and raised.
Okay. How old were you in November 2019?
I was 19 at the time. Or, yeah, 19 at the time. Yes, ma'am. Yeah.
Is that ink Chinese writing?
At that time, were you working?
I was working in Los Angeles. Yes, ma'am.
Okay. So born and raised in South Carolina,
Mhm.
right? Then tell the jury about how you ended up in Los Angeles.
So after high school, I moved out to Los Angeles to pursue a modeling career with my buddy, and ended up getting into the cannabis industry. And we were working with legal cannabis, and it was a whole type of like a new career for me. It was a new experience, and it's something that I loved. I loved being in sales. I loved working with the community and with people. And during my job, it was kind of like, not only did I get to help out different communities through the homeless community with selling marijuana to different dispensaries, but some of the profits that we took from those charitable events were given back to the community as well. And that was something that was a big drive for me.
Okay. Are you still in sales or no?
I'm in car sales.
Okay.
Yes, ma'am.
So still a salesman?
Yeah, I love sales.
Okay. Would you call yourself a people person?
Yes, ma'am.
Okay. Now you said at the time you were working in Los Angeles under a company?
Yeah, per se. It wasn't like an established LLC, but it was like a branded company, I guess. I don't know how the laws work with like.
Well, I'm not going to ask you the legal jargon. Did they employ you? Were
Yes.
you an employer?
Yes.
Employee?
Yes.
And did you get paid?
Yes.
And how did you get paid?
Through cash and through checks.
Okay.
Cashier checks.
Were you paid hourly? Were you paid about?
It was commission based.
Commission based. Okay. And you sold to dispensaries.
Yep.
So you got paid selling to other dispensaries.
I was like a middleman sales broker is what my title was essentially. Yeah.
Okay. And at this time, based on your knowledge, was the sale of marijuana legal in the state of California?
Yes, ma'am.
Okay. So what brought you back to this area around November 2019?
So I newly met Chris in the summer of 2019, and we became good friends. And I ended up making a good amount of money out there, and I wanted to bring some party supplies and drugs essentially back to Atlanta for us to have some fun. And I hosted a party at an Airbnb, and I invited Chris.
So I was just trying to get a very specific thing, and that's my apology. I should have made it more mirror.
Hold on one sec. We gotta make sure those devices aren't making unhappy noises.
Where's your? Okay, Your Honor, I apologize. My type 1 diabetic alerts when there's something going on.
Then we should let that alert happen. If that's what it is, as opposed to your fan base texting you, okay, then by all means. And if you ever need to step outside and we need to pause, let me know.
She's gonna step up on just.
Okay, thank you. Next time, let me know that you might have an important beep, because I usually assume it's, hey, buy this new Nissan, whatever he's selling. There you go.
Usually he's over.
Okay.
Okay, Jackson.
You just
so
admitted to a crime.
We're talking about how you met Chris. Yeah, we got to clarify who Chris is. Do you know Chris's full name?
Christian Riggs.
Christian Riggs?
Yes.
Okay. So would you feel comfortable calling him Riggs?
Yeah, Riggs, yeah.
Chris is, okay. Okay, so we're going to refer to him as Riggs.
Mhm.
Okay. You met Riggs. Where did you meet Riggs?
On social media, on Instagram.
Okay.
Yeah, so he reached out to me because I was out there. I was doing a little bit of modeling. He wanted to get into modeling. He's still doing a little bit of modeling. I'm out of that career path.
Okay. You met him where?
On social media.
Okay, and where was he living when you met him in social media?
Atlanta, I'm pretty sure.
Okay.
Yeah, he was here. And then
You were in California.
yes.
And you met him on social media and he was in Atlanta.
Yes.
So that's your connection to Atlanta?
Mhm.
Okay, understood. And just to clarify, how did you said something about modeling?
Yeah, so I invited him out there to a modeling event that we were going, that was, I got invited to, and he had the modeling look. So I flew him out there, and we became best friends essentially upon arrival. So we created like a flourish of friendship. And then he wanted to bring me back here.
So you flew him out to Los Angeles,
Mhm.
y'all participated in some modeling,
Mhm.
and then he wanted you to come to Atlanta.
Mhm.
So that's how you ended
Stop.
up. Did you get a verbal response? Sorry.
Yes, ma'am.
Great, and I caught that a little bit earlier, but Mr. Howe, when you're answering, it needs to be a yes or no, or whatever the words are. It don't have to be yes or no, but the court reporter says inaudible or unintelligible, and we know we can hear you, so make sure you use the words.
Yes,
Thank you.
the previous questions.
Yes. To
Do
the
you
previous
recall the
questions.
incident that occurred November 8th, 2019 when you were in Atlanta?
To my best ability, yes.
Okay. And how did you arrive to Atlanta?
Me and Holden drove. Yes.
So you were in Los Angeles.
A car full of
Yes.
weed and
Yes. Sorry.
edibles?
Yes.
How? Give us a step by step.
So me and Holden flew from LA to Charleston, and then I met Holden's father, and then we drove up to Atlanta.
Okay, so let's back up. And you just introduced us to a person named Holden. Who is Holden?
He was a good high school friend of mine.
Okay, give us his full name.
Holden Carmody.
Holden Carmody.
Yes, ma'am.
Okay. Holden, you've known him since when?
High school.
Okay.
Yep.
So by the time 2019 is happening, how long have you known him?
Say 2 to 3, maybe 4 years.
Okay.
Yeah. I don't know the exact timeline,
okay.
But sometime during high school.
And where is he from?
Charleston as well. Yes, ma'am. Yes, ma'am.
Okay. He flew to Los Angeles.
Mm-hmm. I flew him out there.
Say yes or no?
Yes.
Okay. And then you guys flew back to
Charleston
together.
Mm-hmm.
Okay. And then you said you drove from Charleston to Atlanta.
Mm-hmm.
Okay.
So we're going to be here forever if you have him repeat everything he said, because you break it down into little bite-sized pieces. So we'll let him. It's okay if he says 5 sentences. We'll process all 5. We don't then need to go back. And your first sentence was you flew to Charleston, and then otherwise we're going to get stuck.
I love this judge.
He's introducing us to new characters.
The characters I get. The characters I get. I'm sorry. I just feel like we've now gone to Charleston about 8 times, and it was only 1 time.
Okay. Thank you.
You're welcome. Thank you.
Oh, this is good.
So you drove to Atlanta. What was the plan when you drove to Atlanta?
So I meet up with Chris. I had a Airbnb set up, hosted with Ian, the owner, and it was a party Airbnb. So I was like, perfect. Let's have a little get together.
I apologize, Your Honor. Is his mic on? Because I am struggling with
It's on. He's soft-spoken, so if you just make sure you talk right into it. I don't know if models have loud voices. Do models have quiet voices?
Yes, sir.
Then use your non-modeling voice, okay? You're saying like, I'd like you to buy a Nissan. Yes.
There you go.
Sell us a car, but instead testify.
All righty. So maybe you repeat the question for me?
Sure. What was the plan when you came to Atlanta?
So essentially it was like a welcoming party for Chris to introduce me and Holden to his friend group. And I hosted the party through Ian's Airbnb, his party Fiesta, Fort Fiesta is what he called it. So from there on, that's where the party started.
Did you know Ian prior to this incident?
No.
How did you locate the Airbnb?
Through the Airbnb app.
Okay. Based on the name of it, the Fiesta?
The Fort, yeah, it was literally called Fort Fiesta, like party household.
Okay.
Yeah.
So the plan was to throw a party?
Yeah, not really a party. It was like a group of like 10 people. So I guess a get together. We were never going to throw like a rager because we're trying to be respectful of the neighborhood.
When you arrived at the Airbnb, can you describe the location? Was it a business, house, something else?
It was in a house. On the listing, it looked like a nice area. And when we got there, we realized it wasn't that much of a nice area. So from the get-go, we kind of had our guard up.
Okay.
Yeah.
And what, if anything, did you do to keep your guard up while you were in the house?
Making sure the doors were locked at all times.
Okay.
Yeah.
And who was at the party?
Christian Riggs, Holden Carmody, Becca, Victor, the DJ, and those are the names that I can currently recall.
Okay.
Yes.
Were there more people?
There were more people, yes. Yes.
Do you recall around what time you got there?
I'd say it was dark, so I'd say around maybe anywhere between 8 to 10 p.m. I'm sure Ian has the check-in login.
We're just going off of your memory.
Okay.
And when you arrived at the location, what was happening?
Currently nothing. We were the first ones there, so we were setting up the party.
Okay.
Yeah.
And what did you do to set up the party?
Just put out the bottles of Coke and just like beverages, solo cups, stuff like that. Because we were underage, so we couldn't buy the alcohol. So we had to have other people go buy the alcohol for us.
So when you said bottles of Coke, I just want to clarify for the record. Do you mean like a soda product?
Yes. Yeah, like the Dr. Pepper and Coca-Cola.
We might need a lawyer for the witness.
And around what time, if you can remember, did people start arriving?
I'd say around 11.
Okay.
Yeah.
And you said overtime of 10 altogether?
Approximately, yes.
And what were you doing?
I was just trying to have fun. I was making sure everybody was having a good time. We had this cool spin wheel where we would expo marker in different actions, like take a shot or take off a layer or whatever it is, and you would spin the wheel, and whatever would land on is what you would do, like take 2 shots or like flip a card, and if the card says this, you do this. Just like cool stuff like that. We were just trying to make the party fun. We had a DJ there, just like a welcoming party to Atlanta for the first time ever being here. And
Did you meet the friends that you were that?
Yep, that I was anticipating on meeting. We're still friends to this day, and then everything happened.
We're gonna get to that.
Yeah.
Do you recall any substance any substances that you took, like you took it?
So I did drink alcohol. I smoked marijuana, a little bit of marijuana. And then for the first time, I got introduced to a substance called ketamine. And I took a very, very low dose of ketamine. And within probably 20 minutes is when the robbery occurred.
Yeah. When you take ketamine, how do you put that in your body?
It was insufflation, snorted it. Yeah.
And getting there, after you took the ketamine, am I saying it correctly?
Yes, ma'am.
Did you feel any effects?
It did. I wasn't noticeable probably for around 10 minutes, and it was a very minor effect. It was more of like a laughing gas when you go to the dentist type of feel. So I was still like cognitive. I was still there, but it just made me feel goofy and just loopy a little bit.
You said it was your first time. Where did you get it from?
Whoever had it, I don't know.
Okay, so you didn't.
No.
10 minutes in, you're feeling the effects.
Mm-hmm.
You said like laughing gas.
Mm-hmm.
Okay, and what happened next?
About 10 to 15 minutes after that is when me and Chris started noticing some sketchy things with the females.
Okay, and when you say Chris, who are
Riggs.
Okay.
Riggs.
You and Riggs started noticing sketchy
activity. They were going up and down the stairs, doing weird things, and I was like, "Can we get them out of here, please?" I personally did not know them, and I only wanted people that I relatively knew, and that everyone else knew in the party there. So we kicked them out essentially, and within 2 minutes, the robbery ensued. Yeah.
Now let's back up. The two females you
Mm-hmm.
said, is that what you call them?
Mm-hmm.
Okay. Were they a part of the group that was invited?
No.
Okay, so let's go back to that moment. When did you notice that two young ladies were there that wasn't a part of the group?
I randomly just noticed two girls there that I had never seen before, and I was like, "Who are they?"
Okay.
Weren't most people there people you hadn't seen before because you were being introduced to Riggs's crew?
Yes, sir. But I was introduced to them. These girls were never introduced to anybody.
Got it. They appeared and no one took the step to say, "Hey, Jackson, this is X."
They were sneaking around. Okay. So they're being very sneaky and just sketchy, I guess. You know.
We're gonna get into that.
Yeah.
Were there any other young ladies at the party?
Becca, and there might have been another young lady. I don't recall, but Becca is a good friend of mine who was the only one I remember being there.
Okay.
Yeah.
When you said that their behavior was sketchy,
mm-hmm.
Explain.
So they were keeping to themselves. They were very conjoined. They were not talking to anybody else. If we would ask them questions, they were very dodgy. They ran upstairs, and when they ran upstairs, Holden noticed, so he followed them up there, and they quickly scurried down the stairs. And that's when we were like, "Okay, what's going on?" And we got them out of the house. One of them left. One of them stayed inside the house. 2 minutes after one of them leaves, the robbery ensues, and this is.
You said one of them ran upstairs,
mm-hmm.
and someone followed. Who was that person?
Holden.
Okay. What, if any reason, would anybody be concerned about upstairs?
Because that's where the product was, essentially. That's where the party supplies were.
I'm sorry, I couldn't hear the answer.
That is where the party supplies were stored.
That's where they kept all the Mountain Dew
stored.
Okay. And we didn't go into what these party supplies
mm-hmm.
were. How did these party supplies get to the house?
So I brought them with me from Los Angeles.
Okay.
Yes.
On the plane?
And how did you obtain them in Los Angeles?
Through my company, or through the people I was working with. Yeah.
Okay.
Yeah. So it was legal out there. Yeah. And I understand it's illegal here, but I was young and dumb, and I didn't really, it was a mistake, and I take full accountability for it.
Well, let's talk about what those products were.
Okay.
What products did you bring here?
I had marijuana edibles and marijuana cartridges, and I think that's about it. I didn't think I bought any actual marijuana. It was just the edibles and the cartridges.
Okay.
Yeah.
And how were they? Can you describe them?
Gummies, and vaporizers.
Okay.
Yeah, it's like CBD, THC vaporizers, stuff like that.
Something you can smoke. Okay.
Yeah. Like you can get them at the gas stations now. Those type of.
Was there anything else upstairs of concern?
Cash. There was cash upstairs. Yes, ma'am.
And why was there cash upstairs?
For a transaction for some of that product.
Okay.
Yeah. Who? For Riggs.
Okay.
Yes.
So someone was going to buy those items
from me. Yes, ma'am.
Okay. And that was Riggs.
Yes.
Okay. And how much cash was there?
It was around 15,000.
Okay.
Yeah.
And why that amount?
Just because that was what I was charging. And that was what I was sold to by my company from LA.
Say that last part again. I didn't hear you.
That's what I got sold to by a certain price from LA and was told to sell it for this certain price here.
Okay.
Yeah.
15,000 worth
Okay, so,
for 10 people.
Let's go back. The girl got the girls out. Did you notice anything? I know you said from the moment you were there, your guards were up. Did you notice anything about the door once you got the girls out?
I think it was either Holden or Chris noticed that the door was unlocked, and
Did you notice that?
I didn't, because I was laying down on the couch.
Okay.
And then, do you have anything more to say?
I just want you to talk about what you know. So we're going to skip past anything else. Okay.
Okay.
You were laying on the couch. What do you recall happening next?
I remember the door being busted open, kicked open, and these two males screaming with guns. And I got up to try and stop them because I was under the influence. I didn't know exactly what was going on. I saw a monkey mask and I thought it was.
I'm sorry, I can't hear you.
I saw a monkey mask and I thought it was a party. I thought it was just, I don't know. And they had, as soon as I saw the gun, I was like, "That's a gun. Can you get it on my face?" And he hit me with it over the head, and I fell to the ground and I was bleeding. And I lay on the couch and I was incoherent for probably 30 seconds. And I woke up to the DJ getting his head stomped and eaten by the butt of a rifle. And to this day, I'm still traumatized by the thought of going through this whole process again. And it's very hard for me to relive all of this. And I just want this to be over.
I'm going to take you back to the moment where you interacted with the two males. First, how do you know they were males?
Their voices.
Okay.
Very deep, Southern voices.
Okay.
Yeah.
Anything about their build?
One was skinny in a gray hoodie, and one was big in a black hoodie. Like big burly, probably very tall, 6'2", 6'3", maybe. Big, yeah.
And how close do you recall initially interacting with the gunman?
He was within inches of my face.
The gray hoodie or the black hoodie?
Gray hoodie with the monkey mask was within 6 inches of my face. I specifically remember what the gun looked like because it was so close to my face.
What was the other mask?
Some type of purge mask.
Okay, so one monkey mask, one purge mask.
Yes.
Monkey mask is gray. The gray hoodie. The mask may have been purple, but gray hoodie.
Yes.
Okay.
Yes.
And you said something to that person.
Yes, I said.
What did you say?
Get that gun out of my face.
Okay. Did you think it was real?
At the point, no. Because I thought it was a prank. I was under the influence and I thought it was a prank. I'd never been through a situation like this before. It was just terrifying to me. I was in so much shock that I just thought someone was playing a prank on us. I mean, who could do this to a group of kids? You know.
And it became reality
After I got hit in the head.
Okay.
And I realized that my whole face was covered in blood. And then especially when I completely sobered up when I woke up on the couch to Victor getting his head stomped. And that's when he was.
So let me pause there. You said you woke up on the sofa. Did you go out, in and out?
So I like stumbled over to the couch, just laid down, and I was just going in and out of consciousness. But when I finally came to, I was completely aware, completely sober. Like I don't know, my fight or flight instincts kicked in, and just seeing him, seeing everyone else huddled up on the couch, it was just a terrifying experience.
So let's describe that for the jury, the interaction that you saw with Victor. Victor was the DJ?
Yes, he was the DJ. So Victor is the DJ. He was the only one who was begging for mercy. He said, "I don't have anything. I have no money. I came here to make money." He was begging for his life. And that is the only reason that this masked gunman grabbed him by his shirt, threw him on the ground, and started stomping on him. That's why he started beating him by the head, because I feel like this masked gunman had so much hate in his heart that he just wanted to hurt somebody begging for their life.
So was it one?
Yes. It was the gray sweatshirt guy.
The gray sweatshirt?
Yes.
Do you recall where the other person went?
Upstairs with Holden.
Did he
try
refer to
grab the
himself
cash.
as the accused?
To obtain the edibles. Holden. Yes. But I think he only obtained the edibles. Yeah.
All right. And the gray hoodie was stomping on Victor. Where was he stomping on Victor?
In the middle of the living room.
I should be more clear. Where was he stomping on Victor's body?
His right here. Because I got
describe for the record what part he
the right temple, because he was laying, I guess left temple, because he was laying down looking at me as I was looking at him, and his head was getting beaten right here. So his left temple. It was.
What happened after the attack on Victor?
I'm pretty sure they came over to me. They took my shoes off, and I tried to fight back. I kicked the assailant in the face, and I was screaming, "They're not real, they're not real!" But he still ended up taking them anyways. I think he got a wallet, and then they ended up leaving. And immediately from there, I got up and I tried to make sure everybody was okay. I first checked on Vic, made sure he was okay. Checked on Becca, went upstairs to check on Chris and Holden, made sure everybody was okay. And then I realized that Holden was on the phone with the police, and I was like, Holden, you got to get off the phone, because
We're gonna get there. You said they took your shoes.
Yes.
And they took a wallet.
Yes.
Your wallet?
No, not my wallet.
Okay. What, if any, interactions or words exchanged when they took your shoes? Did they say anything to you?
They said, if you don't give me your shoes, I'm gonna kill you.
And what type of shoes did you have on?
They were Nike Air Force Ones, the off-white editions. So they were like $1,500 shoes. They obviously knew they had some value to them, or else they wouldn't have taken them.
Was it a nude color, a bright color?
It was a bright lime green highlighter yellow color.
How long have you had those shoes?
6 hours.
Okay. How did you obtain those shoes?
We went to Heat Atlanta, which is like a shoe store down here. And we got those shoes and then another pair of shoes. And within 6 hours, they were stolen from me.
So you were talking about how someone was making a 911 call.
Mm-hmm.
Checked on everyone. Who was making the 911 call?
Holden.
Okay. And what did you say to Holden?
I said, please hang up the phone.
Okay.
Yeah.
Why would you say that?
Because at that time, in my mindset, I was more worried about getting the product out of the house. I was more worried about getting anyone going to jail rather than realizing that we just got burglarized and attacked. And my logic at the time, being a 19-year-old kid, was just trying to save us from going to jail for drug charges.
Were you aware that you were seriously injured?
No, at the time, no.
Do you know if Holden hung up the call?
I'm pretty sure he did. I think so.
But you're not positive?
I'm not positive, no.
And did you wait for the police to arrive?
Yes. Yes.
Did you provide a statement to law enforcement?
Yes, ma'am.
Okay. What, if any, items were recovered of yours?
Mm-hmm.
Were there any items recovered of yours?
No.
And did you stay at the house after the incident occurred?
Nope. We had a flight to catch at 7 a.m. and I did not want anything to do with Atlanta anymore. So I got on that flight and I left.
Was that flight that was already pre-scheduled?
It was pre-scheduled, yes. Yeah, but we had the option to cancel it and go to the hospital and stay in Atlanta. And I was in so much shock. I just wanted to get out.
When I asked earlier, what was the plan?
Mm-hmm.
Was the plan to come to Atlanta, then go to
Houston?
Okay.
Yep.
And why were you going to Houston?
For a Travis Scott concert.
Okay. Do you recall what you were wearing that night?
A Travis Scott hoodie.
Okay.
That got ruined.
Wow. You guys, this was not my childhood experience. This was not my teenage
This
year
time,
experience at all.
reflect that I am showing pictures, pre-marked states, exhibit 14 through 16. You've already seen it.
So the exhibit list, it starts with 12. It's 12 through 15. We're not, for some reason, we're using a subset of that. You can use whatever you want. It just makes the exhibit list a little confusing.
Yes, I'm only using the one team recognizes.
Okay, so 14 through 16?
Yes.
Okay.
Your Honor, 16 is the only one that.
Okay, and we've discussed that outside the presence of the jury. You made a number of objections about 16, which are preserved. If you showed the accused, 14 through 16 as well?
4 through 16.
Oh, 4 through 16. Yes. Oh, that's what I misheard. 4 through 16. So it all matches together. Okay, I thought you said 14.
I might have.
Okay, 4 through 16. Much better. That tracks your exhibit list. Great.
What happened at the Travis Scott concert? Was it in Houston, they said? That was the Astroworld one?
All right. Any objections from the accused to exhibits 4 through 16 that you've had a chance to look at? Okay, they're admitted.
Oh, man.
16 is admitted subject to the objection, Ms. Mignot, you raised earlier today.
Thank you, Your Honor.
You're welcome.
Approaching the witness. What did I just hand you?
The picture of the Airbnb.
Well, let's not go through, just generally, just shuffle through them.
Okay.
And let me know generally what did I hand you. Don't go into specifics of each picture.
Well, I may have gotten ahead of things because I just asked the lawyer for Mr. Robinson, I asked the accused if they had any objections. They have no objections because they're familiar with him, but I guess you may still want to establish a foundation through Mr. High. I didn't mean to get ahead of things. Once I had been told you'd already shared them with counsel, that made me think they understood the foundation. But why don't you press forward with that, and I may renew my ruling that they're admitted based on his answers. Yes, sir.
That is the only objection you have. I was not familiar with those.
Your objection is you're not familiar with them. Okay, thank you.
Okay, so if you could just briefly just give me a general description of what you're looking at.
This first photo?
No, just in a collection. Are those photos from the night?
Is that a dog collar he's wearing? Like a choke
And
chain?
how do you recognize them? Are you in them?
My blood is.
Oh, keep going. See if you're in them as well.
I recognize that blood. My blood is that color.
Yep.
Okay. Is the Airbnb in the photos?
Yes, ma'am.
Okay. So is that how you're familiar with them? Because they're from that night?
Yes, ma'am.
It's loud.
And the picture on the top, can you just go to 16?
16. These are the shoes that were taken off of my feet.
So don't show them to anyone yet. Do you want to ask him any more questions, or are you now tendering 4 through 16?
Tendering 4 through 16.
Okay. I don't think anything's changed, Ms. Mignot, but do you have any, other than the objections you made this morning, any objections to 4 through 16?
Just foundation, Your Honor.
Okay.
Are they a full, is the court, has the photos already been admitted, Your Honor, or am I still going through foundation?
There's an objection to foundation. If you think you have laid a sufficient foundation, tell me that. Otherwise, ask the standard question you'd ask about photographs.
Okay.
Did you say
Are
relevation?
the photographs an accurate depiction of that night's incident?
Yes, ma'am. These photos are a very accurate description of the
Have there
event.
been any changes to the?
No, ma'am.
All right, Ms. Mignot, other than your earlier objection to 16, now that we've heard a little bit more, any objection to these exhibits?
Your Honor, is this the witness that took the photo?
I don't know. You can ask him that. He doesn't need to be the one, as long as he testifies that they're fair and accurate depictions of the scene when he was there, which he has testified to.
We'll follow up on cross if the court's already.
Got it. And to the accused, you've indicated you object because you're not familiar with them. You've preserved that objection. Do you have any other objection to the admission of those photos? Okay, you've preserved that. They're in. You can publish what you want to publish.
The state publishes State's Exhibit 16.
Okay, content warning. We may see images that are somewhat graphic. Those are the shoes?
This is so you hit stay mute, and then that'll go away, and you should be able to see what we see. All right.
He paid $1,500 for those?
Okay, on State's Exhibit 16, I'm just going to ask you a few more questions on this picture.
Yes, ma'am.
Who took this picture?
Me.
And whose shoes are those?
Mine.
Whose legs are in the picture?
Mine.
Okay, so you're wearing the shoes in these pictures?
Yes, ma'am.
This picture? Are these shoes that you say were taken from you?
Yes, ma'am.
It looks like almost like a zip tie or something sticking out between your feet. Is that on your pants or the shoes or the ground?
That was Virgil Abloh's special tag that he threw on his Off-White edition Air Force Ones before he passed.
The state is now publishing a State's Exhibit 12. 12.
Mm-hmm.
And who was in this picture?
That is me.
Is that the Travis Scott?
Yes, ma'am.
You said you were wearing?
Yep. Yes, ma'am.
State's Exhibit 13.
Content warning.
Who was that?
His eyes are
That
so
is me.
dilated.
Okay. You look a little different today.
Wow.
Bleach blonde hair.
Yeah.
Change.
Yeah.
Any other? Would you say you're a little bit smaller there?
I'm a lot smaller there. I was around 140 pounds.
Okay. 2019, right?
Yes.
State's Exhibit 14. What are we looking at in this picture?
That is right where the gun hit me in the side of the head.
Okay. And what, if any, injuries did you sustain from that? The obvious laceration.
A concussion that lasted 3 to 4 days.
Okay. Is that your first concussion?
But he flew with the concussion?
Through sports, but
Concussions through sports? Yeah. So you know how concussion feels?
and I knew exactly how it felt.
Can you describe that?
It's foggy memory, kind of minor to moderate headaches, and memory loss.
Okay. And you're saying that didn't happen immediately?
Not immediately, no.
Okay. So when did that occur in relation to the incident date?
Probably 24 hours after the incident.
While you were using?
Mm-hmm.
Yes?
Yes, sorry.
While he was at the concert?
Exhibit 15.
Wow. Okay, we're zooming in.
A picture of 14.
Yes, ma'am.
Was there any actual physical, I know you had a concussion, was there any physical injuries to your scalp or head?
Yeah, there was about a 1 to 1.5 inch contusion on the side of my head. Yeah.
So now we're going to move on to the photos of the incident location. States Exhibit 4.
Contusion.
What is that?
That is the front of the Airbnb, where you can see the camera pointed at the front door on the left side of the porch.
What kind of tree is that?
Help us out, actually. Can you get up and point to
No, why don't you stay seated, and you have a touch screen, and it's easier for you to stay put. Tap the screen once, in the lower left-hand corner, there's a pencil. Now your finger can draw.
That's the camera that was pointed at the front door that was viewing this area.
Okay. Space Exhibit 5.
And you can erase those with the, you did it, wow. Is that from modeling or from selling cars?
Tech savvy.
Tech savvy.
Yes, sir.
What are we looking at here?
1040 Wiley Street.
Okay. And Space Exhibit 6.
The front door.
Is this the front door you were speaking that the camera points at?
Yes.
Yes, ma'am.
States Exhibit 7.
This is right where the incident occurred, where the beating took place. Right here.
Where's the wheel?
Do you recall where you were?
Yes, right. So say the photographer is the gunman. I'm standing right in front of that wine glass right down.
So use that tool like
Yeah, so I would be standing right here. And the gunman was essentially where the cameraman was taking a picture of. So say I was like this close to the gunman and the other one was like right here.
So there's something that looks like blood on the ground, not saying it is, but would that be from you or from Victor?
So if we go to the next picture,
I'm going to use that in the next picture.
I'll show you whose blood is whose.
Okay.
We'll skip, due to that question, we'll just skip over to 9.
Okay.
Who needs tests?
Okay, so we go back to draw. This is Victor's. This is mine. Could you hear that?
Yes. So the small circle.
That's Victor's. His head was getting stomped. So that's the pool of blood from his skull fracture. And that was from me pulling myself away from getting hit to where eventually I landed over here on the couch. It looks like a little bit of blood right there as well. And then I was laying on the couch watching him getting his head stomped.
Wow.
States Exhibit 10. For the record, that is up close of the blood stains that are in States Exhibit 9. And States Exhibit 11. That is an even closer footage of the smaller circle.
We're about to go microscopic.
Circled as Victor's blood.
Yes, yes.
Yes?
Yes.
Okay. And Jackson, I know it's a lot, I'm asking a lot. Just remember to say yes or no.
Yes, ma'am.
And let me know if you need a minute, okay?
Yes, ma'am.
States Exhibit 8. Do you know what angle we're looking at?
So this is from behind the couch looking towards the kitchen. I'll use my marker. The DJ stand was right behind this wall. And up the stairs was up here, going up like that around the wall. The first assailant followed Chris up there, while the other one in the gray was pointing guns at Becca. Noah over here. Vic was over here begging for his life while the gunman grabbed him and pulled him over here while I was on the couch, incapacitated.
It's a lot of drawing.
I'm just going to back up to, you say this is not your first concussion, you had it from sports, right? Did you go to the doctor?
No, I never really took care of myself as a young adult and up until recently. So I really never treated any of my injuries. But I've had enough brain contusions and knockouts to the point where I know what it feels like.
Has there been any other effects from this incident that you had?
Traumatic effects, PTSD.
Okay. Would you want to share that with the jury?
This is live.
What's the relevance of how things are now versus?
It is an aggravated assault. He was a victim of a crime.
All these are true.
And it is relevant what long-term effects he's had. It goes to his credibility, and I mean, it's evidence of his assault. This is Tate's last question.
Ms. Mignot,
Your Honor, I don't believe that's a credibility question. Also, this witness is not a medical provider, and I think it borders on medical diagnosis.
Okay, I concur. So if you want to ask it differently, if you want to explore with this witness his ability to recall what happened back then, you can. I'm not sure why you're exploring that rather than Ms. Mignot, but you're free to do that. But rather than have this witness talk about what doctors or other care providers have, that's what you're doing indirectly if he's going to give a diagnosis, because that would come from a medical provider.
Yes, and Your Honor, I did not gauge that he would actually say PTSD.
Okay.
The long-term mental effects that he has experienced after the incident is what I'm asking about.
Okay, so
directly to him.
So we'll just strike that testimony.
I'm not going to strike it, but I'm going to have you ask a question in a different way, and we'll see if Mr. Heil answers it. And it sounds like you're about done with the witness otherwise. Okay.
So any cognitive issues you've had since this time?
Cognitive issues, from like fogginess, not being able to think before I act. I would say memory loss for sure. I feel like I can go into what you were asking earlier. I can.
You can't give any medical diagnosis.
Not medical diagnoses. I mean, I know what we've spoken about, if that's okay with. So after the incident, I fell heavily into drug abuse, and I admitted myself into a rehab facility after realizing that using substances to subdue the pain and trauma from an event like this is obviously not the right way to go. So I spent 2 years of battling addiction just from some small event that shouldn't have never happened. And I've taken 180-degree turn since then. It's been 2 years. I've been clean for 2 years. And I'm the best person I am today. I'm the best person I can be. And every day I'm doing everything I can to better myself and my life and my family and everyone around me.
And
possibly why he's so honest on the stand as well, going through that process.
I understand that you said you could tell they were males, back to the description.
Yes, ma'am.
You could tell they were males by their voice.
Yes, ma'am.
Were you able to tell anything else about them?
I could tell that they're African-American males.
How could you do that?
They had gloves on, but I could see the skin past the gloves. Yeah, and their voice, the tone of voice, and then I think either one of the other witnesses stated they saw.
Well, you can only talk about what you saw.
Okay,
right?
so then just above the hands.
Okay, all right. And as far as height, do you recall?
One was very tall and one was about my height.
Thank you.
Ms. Mignot, do you have questions for Mr. Heil?
Good afternoon, Mr. Heil.
Good afternoon.
I'm attorney Marcia Mignot, and I represent Mr. Robinson, who has the pleasure to sit next to me at council table. I'm going to be asking you some questions following up on the questions that the prosecution just asked you. We do have a court reporter taking down what both of us are going to say.
Yes, ma'am.
So if you would allow me to finish my question before you begin your answer, and I will be respectful to do the same. Because as human beings, we normally speak over each other. That is difficult for court reporters because their job in a courtroom is to make sure that everything that each person said is properly recorded. Okay?
Yes, ma'am.
I know it's difficult for lay witnesses to remember to say yes or no and not uh-huh and uh-uh.
Yes, ma'am.
So if you would pay close attention to that for me, please, I will be very expeditious in my questions.
Yes, ma'am.
So let's start with questions opposing counsel asked you on direct examination were regarding the drugs that you had that night. You testified that you had smoked marijuana and drank alcohol, correct?
Yes.
You also testified that you had a feeling of loopiness or goofiness, correct?
Yes.
And isn't that the same feeling that you have been describing as it pertains to the effects you've had from this incident?
Can you rephrase that question?
Okay. So you testified that you have some collateral effects of this incident that you experienced on November the 8th of 2019. Do you recall that testimony?
Collateral?
Okay, so I'll use a different word. You had some medical effects. I think you testified PTSD?
Yeah.
The defense struck that testimony.
Well, I didn't strike it. She moved to have it stricken, and I said, we're not going to strike it. It didn't rise to the level that we needed to do that. It's out there. Came in through his testimony on direct. So if we're going to go over his testimony on direct, that's an area to which he testified.
Permission to proceed?
Yes.
Thank you. So you testified about having or battling addiction after this incident.
Yes.
You had an addiction before this incident, didn't you, sir?
I wouldn't say that, no.
You use drugs regularly?
I dabbled in marijuana. I smoked marijuana, but I did not have any hard drug addictions, no.
So you had a marijuana addiction, fair to say?
I wouldn't say addiction, no.
Okay. Do you recall testifying that you spent 2 years battling addiction?
Yes, ma'am, after the fact.
Okay. And is it your testimony that the addiction that you started battling was after the November 8th incident?
Can you repeat that?
You testified that you spent 2 years battling addiction.
Yes.
Is it your testimony that your addiction began on November the 8th of 2019 because of the incident that happened at the Wiley Street location?
Can you rephrase that?
Did you start using drugs because of the robbery, the alleged robbery at Wiley Street?
Objection, Your Honor, that's a different question.
It has to be a different question. He's asked her to rephrase it. And so she's getting more and more concise and blunt with the question, which you may need to do.
I would say yes. I would started using them heavily afterwards to suppress the trauma that was ensued, yes.
Okay, what did you start using afterwards?
Percocets, Xanax, anything to numb the pain.
Okay, and you were using ketamine before the November 8th?
No, so that was the first time I told my counsel. I was introduced to ketamine that night, first time ever doing it. And 20 minutes after doing it for the first time is when the robbery ensued.
So let me ask my question again. You started using or tried ketamine before the robbery incident, correct?
Yes, ma'am.
So you started drugs before this incident occurred?
But it did not start the addiction, no.
Okay. So you were using, but you were not addicted?
Yes.
Okay. How young were you when you started using drugs?
I'd say 16, started smoking marijuana.
So between the age of 16 and you testified the age of 19 on November the 8th of 2019, correct?
Yes, ma'am.
All right, that's quite a few years that you were using drugs, isn't it, sir?
Not on a daily basis, no.
Now, you testified that the females were not invited to the party. Do you recall that testimony?
I testified that I did not invite them.
Isn't it true that Riggs, and that's Christopher Riggs, who we're going to refer to as Riggs so that the record is clear regarding which Christopher, isn't it true that Riggs sent out a Snapchat notice about the party?
Objection, Your Honor. That was not in his testimony, and that is eliciting hearsay, a message between someone else.
So two things. Yes to the hearsay, but it's not your role to tell the jury what his testimony was or wasn't. That's his role. So if Ms. Mignot asks him a question and Mr. Heil thinks that's not what I said, he should say, that's not what I said. But don't make that objection again. That's not what he said before. On redirect, you can clear that up because the lawyer shouldn't get into an argument with the witness on the stand about what they think he said or didn't say. But the hearsay part, I do sustain. Let's not ask about the contents of communications from other folks.
Rephrase the question, Your Honor.
Sure.
Riggs invited the two young ladies, Lauren and Riley, to the party, correct?
Yes, ma'am.
You testified that what is depicted in State's Exhibit 16, a picture of, I think you called them Air Force Ones?
Yes.
Were taken from you that evening?
Yes, ma'am.
Now, those, I believe you testified, were $1,500 sneakers?
Yes, ma'am.
And isn't it true that there's a sneaker community that places value on sneakers?
Yes, ma'am, I'm aware.
You're aware of that?
Yes.
And anyone who is a fan of sneakers or has knowledge of the value of those sneakers, if they're going to rob you, would be interested in those sneakers, correct?
Yes, ma'am.
Now, you testified that you brought drugs from California to sell because it was legal to sell in California. You remember that testimony?
Yes, ma'am.
And you brought with you, I believe you said, marijuana, gummies.
Yes.
And you said you also brought vapors.
Yes.
Marijuana vapors.
Yes.
And did you bring any pills with you?
No.
Okay. So all the drugs you had that evening were marijuana-based drugs?
Yes, ma'am. That were legally sold in California.
Okay. You are aware that those drugs were not legal in Georgia, correct?
Yes, ma'am.
As it pertains to your testimony, you also testified that you asked Holden to hang up from calling 911?
Yes, ma'am.
And you asked him to hang up because you were scared if the cops came, they would see the drugs and you all would be arrested, right?
That is true.
Now, let's talk about the exhibits 4 through, and I'm going to say 15 because we've already talked about 16. As it pertains to the photographs that we saw, isn't it true, as you sit here, you cannot say that this gentleman, Mr. Robinson, was one of the 2 individuals that you testified invaded the home on November the 8th, 2019?
I don't know how to answer that question.
You cannot say you saw this gentleman, correct?
I did not see his face.
Correct. So you don't know if it was this person, right?
To my account, no.
Okay. You also cannot say that Mr. Robinson pointed a weapon or hit anyone with a weapon that night, correct?
I stated that the man in the gray jacket was the one doing that.
And the man in the gray jacket, as you sit here today, you don't know if that person is Mr. Robinson, correct?
I do not know.
Now, you also testified that I believe 7 a.m. the next morning you took a flight.
Yes, ma'am.
So you're interacting with law enforcement at around 2 a.m. on November the 8th?
Yes, ma'am.
And a few hours later, you jumped on a flight and left to California?
No, to Houston.
To Houston?
Yes.
You still attended the concert that you were planning on attending?
Somewhat. When the concussion started to ensue, I decided to leave the concert and go back to the hotel because it was I was in a lot of pain.
Well, let's back up a little bit.
Yeah.
Let's talk about arriving at the concert. You actually went, correct?
Yeah. I had tickets. I bought my tickets. I was going to go. Yeah.
And you never sought any medical treatment from a hospital or urgent care facility prior to leaving, correct?
Nope. I was young and I thought I was invincible. That's all I can say.
You're not a doctor, correct?
No.
And you don't have any special medical training as it pertains to diagnosing injuries?
No, I do not.
As it pertains to any of the conduct associated with the 2 masked men that entered the Airbnb that evening, you cannot under oath say that either of those men was Mr. Tyrone Robinson. Isn't that correct, sir?
They were masked.
You could not say that it was Mr. Robinson, correct?
Yeah.
Thank you. Nothing further, Judge.
I'm going to turn now to the accused. Sir, do you have any questions for this witness?
No, just being that I didn't have, full service, I couldn't talk to the trainer. The only thing I was like saying on record that since I am being accused of what is being said, I do believe it's been a mistake. And this is definitely not something a servant of Christ, a child of God would do. And I deny the allegations.
Okay, thank you. Is there any redirect?
No, Your Honor.
All right, any questions from the jurors for Mr. Heil? All right, take your time to write them down, and Deputy Gordon will collect them.
If the juror's going to be like, hey, how was the concert or something like that, I don't know. I think we have some jurors that are probably the same age range of this as this witness. We're in Fulton County, Georgia. I think this is a very credible witness. He's testified many times to things that are not complimentary.
How do you want to do this? The accused needs to be part of the conversation. Can he come back with us? No? Okay, I'll let him look at these. Ms. Mignot and Ms. Green, this way, please.
The judge is starting to discover some of the difficulties that come from having a pro se defendant. This witness mentioned that he has his own counsel and indicated that. So I think his lawyer is present. I think he's being honest. I think in hearing about the crimes he committed and admitted to, I think that goes to his credibility, but also in him going through treatment and working towards sobriety to get out of the addiction hole he was in. I think that also is why he may have that honesty level, because that level of honesty is part of the addiction recovery program. Interesting that he says he was not addicted to marijuana. That surprised me. Peter, you think he's evasive? He's admitting to felonies. he has not yet, to my knowledge, been charged with. This is stuff that could come back and bite him. Like as he gets off the stand, he could get arrested.
We'll talk about it during break. Come on. Can you share these with the accused? Sir, you're about to see questions that the jurors have, and I plan on asking those of this witness. But if you have any objections to any of those questions, you need to let me know. I'll let you know that Ms. Mignot had no objections and Mr. Hiles had no objection. Sir, do you have any objection to any of these questions? Okay. Mr. Heil, first, how tall are you?
I'm 6 foot. Sometimes I'd like to say 6'1", but
But if you're being honest and we mush your hair down, 6 feet?
6 feet.
6 feet. All right. What sports did you play in the past in which you received concussions?
I ran track and then I tried football, and that is kind of what led to the concussions. And then from there, I started fighting in high school. I was a bad kid around that time of like from 14 to 16. And first concussion was through sports, and the second one was through fighting. And then the third one is where the gun came in. So yeah.
One through football, not track. Yeah. One through, we'll call it boxing. It just wasn't sanctioned boxing.
Yeah, boxing. UFC. Sure. Yeah, we'll do that. UFC,
okay.
Yeah.
All right.
Not boxing.
Question about how you testified about being able to see skin on the two assailants between gloves and sleeves, but you also testified there was a gray hoodie and a black hoodie.
Yeah.
So help the jurors understand how and where you saw skin on the arms.
So when I remember specifically when he was trying to take my shoes off, like I was fighting, kicking back, and like when he's pulling on my shoes, his sleeves started to pull back, so you could see the skin color, and I kicked him. And then at some point, I just figured out that he was an African American male, and that's how I came to the conclusion. Obviously, seeing the skin color. Becca also saw the skin color.
Okay,
sorry, I didn't mean to.
Okay, that's okay. Don't talk about what Becca said.
Yep.
All right. Did you see any other part of either of the assailants' uncovered bodies?
Not to my recollection. No.
Okay. You testified that there was cash upstairs. If you orient us, there was the room with the blood on the floor. Upstairs means upstairs from the room with the blood?
It's like literally directly above the.
Okay. And how much cash was upstairs?
Probably between the three people, like 12 to 15 grand. I'd say 15 max.
Whose money was it?
It was me, Chris, and another person who was not involved in this, named Victor.
Not Victor,
not the DJ.
DJ, different Victor.
Different Victor.
Okay. Did you submit to any type of blood alcohol content or drug content testing that night after the police arrived?
Whatever the EMS asked me to do, I was in full compliance with them. I just wasn't going to the hospital because I knew that I had to fight a catch.
Okay.
So whatever I was in and out through the shock. When I was in the ambulance is when the shock really set in. So whatever they did in the ambulance is what they got. So
they treated you in the back of the ambulance, but did not transport you to an emergency room?
No.
Okay, so you were never in an emergency room hospital where they would draw blood?
Yes. Okay. So my main focus was, again, just trying to get out of Georgia.
Get out of Georgia. Okay. Ms. Green, do you have any questions for Mr. Heil based on the exchange he and I just had? Ms. Mignot?
Did EMS provide any medication to you?
No. I think they gave me Advil. Yeah, I requested Advil or Tylenol, something for the headache.
Where did you put the drugs that was upstairs and the $15,000 once the police arrived?
It was still up there. I'm pretty sure the assailants took most of what we had. The cash was hidden. I don't recall exactly what happened to it, honestly, after that.
Okay.
Yeah.
So you never got your $15,000 back?
No, we got it back. I just don't recall exactly what happened to it after the incident.
Okay.
I don't know where one of the three put it somewhere.
Got his money back.
Isn't it true that on the date of the incident, you were wearing black and white tennis shoes?
No, I was wearing my Airsoft ones. I had black and white Air Jordan ones, and then for the party, I changed into my different outfit, my party outfit, and which was the yellow off-white Air Force ones.
So if there's
my Travis Scott hoodie.
I apologize, go ahead.
And my Travis Scott hoodie.
So if you're in your Travis Scott hoodie with black and white Air Force Ones on, you would have had those on at the time of the incident?
No, I had the Air Force Ones on at the time of the incident. I remember changing out of that outfit probably around 9 to 10 p.m.
Were you arrested for anything?
No.
Were you granted immunity in this case?
I've never been charged for this case.
No, my question is, were you granted immunity from the criminal conduct you just admitted in this courtroom today?
Yes.
When were you granted immunity, sir?
I'm not sure. Can you rephrase that?
Okay. When did the state say to you, you have immunity?
I don't know.
It was before now, correct?
Yeah.
And after the incident, correct?
I guess so.
Thank you, sir. Nothing further.
So Ms. Mignot, in the future, there wasn't an objection, but I'm going to tell you, your follow-up with juror questions is limited to the space that the jurors explored. No sneakers, no immunity, no arrests. So the answers are evidence, but we need to cabin the follow-up to what was brought up by the jurors.
So Judge, may I, because of those?
Yes, you may, because we went into an area not covered by the jurors.
Okay.
Yeah, I'm confused.
Thank you, Your Honor.
Oh, man.
Jackson, do you know what immunity is?
I'm so confused.
Okay. Did I or the state promise?
Yes.
So remember what Ms. Mignot told you, which is don't answer the question until it's obvious. Not Jeopardy. You cannot buzz in early, because she might have gone on to say, "Are you lying?" in all your answers. You just belted out yes. Wait till she finishes her question.
Okay. Yes, sir.
So you were just asked maybe 3 or 4 questions about something called immunity. You say you're confused?
Yes.
Do you know what immunity is?
That's where you're granted, I guess, free of charge. I guess, maybe.
Do you know? Is that?
That's my guess. I don't know the definition now.
I talked to you about that?
I think me and Reeves talked about it.
Okay. And what was that conversation to you?
Anything that I brought up with the drugs in court would not be used against me.
He's like, right? That was the deal, right?
Do you recall in that same conversation discussing statute of limitations?
Yes or no?
Yes.
Okay. And that you would not be charged due to the statute of limitations?
Yes.
And the state asked you to be truthful in your testimony?
Yes.
Okay. And do you remember when that conversation occurred?
What was it? Wednesday of last week? Wednesday? Yeah.
Wednesday of last week.
Yeah.
So it's your testimony that that conversation happened Wednesday of last week. Okay, thank you.
So for the accused, do you have any follow-up questions for this witness? We've got a little more bit of an exchange, and I make sure if there's something you want to ask, you get a chance to do that.
Not necessarily a follow-up question. I just want to clarify where the shoes green or yellow. I heard yellow and I heard green. I'm not sure what that.
Virgil Abloh, I guess, has a color combination of lime green and highlighter yellow. I can pull up a picture for you if you want to see them.
Well, you actually can't pull up any pictures, but State's Exhibit 16 is in evidence. It sounds like the question was, how would you describe it? So what words would you use to describe the color of the shoes?
A mix between lime green and highlighter yellow. In the picture on Exhibit 16. Can
we put up 16, please?
Yeah. So there's a blue light in the background, which makes the color of the shoes appear a little bit more lime green than their highlighter yellow. So
it's going to be on the screen in front of you. You don't have to crane your neck.
Yeah, so they're, I guess, more of like a lime green right now, but without the blue light, they're more of like a highlighter yellow.
Deputy Gordon, can you rotate the screen at the podium so that it faces the accused so he can see? Thank you. Are you able to see that a little better than whatever you were trying to look at?
That zip tie is a fashion statement.
All right. That is it. Mr. Heil, thank you for your time.
Thank you.
You are free to go.
Cool.
Cool.
Ladies and gentlemen, we're going to take our afternoon break. Give me 1 second. Can you take the picture down, please? All right. We're going to take our afternoon break. Please don't discuss the case. Do any outside research. Enjoy the jury room. If you're running low on any of the snacks in the big white basket, let Deputy Gordon know, and we will replenish as available. And we'll get you back out here for a little more testimony before we wrap up the day. You have an event. We go until 5. We'll stop as close to 5 as we can. Tomorrow is Wednesday. In the morning, I have drug court. I will be having a bunch of folks who are participating in an accountability court. That takes up the morning. We're going to start at 12:30 tomorrow. So you should show up if you're a lunch eater with food in your tummy. Don't expect to get a lunch break because we'll hit the ground running at 12:30 with witness testimony. It would be great if we could go to 5:30 or 6 tomorrow, but it's Passover. And so I'm going to ask you all to talk amongst yourselves during this break so that you can let me know how late we can go tomorrow because of the late start. The late start is not a surprise to the lawyers. When I was giving you the estimate of how long we thought the trial would go, they knew that Thursday was a little more than a half day because of my drug court obligations. We didn't know we'd get the late start that we did today, but we're going to keep pressing on. So do talk amongst yourselves to see how late tomorrow you could go. Today, we'll stop real close to 5, maybe a little before, a little after. As I said, it depends on where we are with the witness. Any logistical questions? Nope. Enjoy your break.
Let's get to know our jurors a little bit better here. They have stickers on indicating that they are members of the jury. I'm getting a little bit anxious about those cords and the fact that they don't have cable runners over the top of them that are just stretched across the well like that, looping up, ready to trip someone.
Mr. Hiles or Ms. Green, anything from the state before we break?
There you go.
Ms. Mignot, anything on behalf of Mr. Robinson?
No, Your Honor, nothing for Mr. Robinson.
All right, and last but not least, the accused. Anything we need to talk about before we take a break?
No.
Okay, my plan is to bring you right back out, just like I'm going to bring Mr. Robinson out when we're done with the break. Are you good coming back in each time, or do we need to have a discussion each time when you come back?
We may have a discussion, but I'm good.
Okay, we'll bring you back. Thank you. Let's all be back here on the clock on the wall, and you can coordinate it with your phones at 4:05.
It says 3:28 right now.
So do the math on your phones, but 4:05 on that special clock.
The accused is like,
let's be back here.
Can I have a phone?
Be back now.
Up to 23. All right. So we're going to skip ahead right here and catch the last bit of this of yesterday's occurrences. Oh, there we go.
To get you a copy of the witness list, I don't think we got.
Just 1 second. I skipped ahead too much. There we go. Boom. Here we go. You just came in, just sat down.
All right, Ms. Rivers, are you ready? Let's get back on the record. Mr. Hiles or Ms. Green, anything from the state before we bring the jurors back in?
Yes, I would like to address this with you on the record. Mr. Pritchett, the accused, I think he's entitled to be part of our conversation since he's representing himself. I know it's a production to take the jurors out every time we have to go over questions and have a discussion, but I don't want him, since he's representing himself and now electing to participate, to be left out of those discussions and cause something that, even though it's a production to send the jurors out, it might be a bigger production doing this again. I don't want to create any reversible error by leaving him out of those bench conferences, so to say.
If he is given the same opportunity to review the questions, tell me what you understand the harm to be, just that he's not participating in that particular exchange.
Well, I think it's more of an abundance of caution, but the conversation about what questions that you will and will not ask, and if there's a reason you're not going to ask them, that's the one the conversation piece that I'm referring to.
Okay, and in the one instance, since we've been reunited, that we went back there actually wasn't such a discussion, but your point is there could be, and if there is, we all ought to participate in it. Okay, you're probably right. What we had to do in another trial I had, where there just were too many lawyers to have it make sense, and one of the lawyers for the defendant insisted that his client be a part of it, is that we made the jury step out. So that's probably what we'll do. All right, Ms. Mignot, anything on behalf of Mr. Robinson?
Nothing further, Judge.
All right, and on behalf of the accused, anything we need to talk about before the jurors come back in? You have a pen, correct?
Yeah, I have.
Okay. Well, if it's not working, I'll get you one that works.
Please.
Okay.
Just really just discovery issues on the thing that I haven't seen, and the witnesses that I haven't been aware of. Can you prohibit the state from entering that in? Because it's like I said, I have no
awareness of some of the things that are going on. You know, of course, like I said, I still don't understand the nature and quality of the jurisdiction of the court. I have sat down, to at least stop disruption. But like I said, just the things that I'm not aware of as far as discovery that wasn't presented to me. Can you period state the entering that? Because like I said, I don't. Some a lot of the things I haven't never seen and never even heard. What he said.
Okay, what I will do is ask Mr. Hiles to get you a copy of the witness list. I don't think we got you that because I had that thought originally, but then you were choosing not to be out here. But now you're out here. We'll make sure you get a copy of the witness list. Here it comes. Thank you, Mr. Hiles. I'm not going to require the state to exclude. I'm not going to exclude anything from the state's case that was part of discovery that was properly provided to any one of your previous counsel. If there is something in particular, not videos or anything like that, that you'd like to see or get a copy of, I could make sure we get a copy of a police report or something like that. I don't know what's in, you have, the record should be clear. You got about 3 inches worth of paper with you. I don't know what's in there, if it's your legal research or if it is some of the paper part of the discovery or what.
If you want to see Facebook,
I don't in particular. It's your belongings.
Nothing what previously attorneys gave me. They gave me very, very minimal. Like I said, most of it was warrants and mainly warrants.
Hold on 1 second. Can you stop the clicky thing? Just he's hard to hear. When it's a louder person, you can do your little whiteout tape. Thank you.
So like I said, I just received the bare minimum, of what I thought I was entitled to see.
Okay. Mr. Hiles, is there any part of the paper discovery that is fairly central to what you and Ms. Green will be covering with witnesses? Or it's lots of witnesses, so it's lots of reports?
Well, I think the lead, no, I'm not introducing necessarily paper discovery.
No, that wasn't, I didn't ask the question well. I wouldn't expect you to try to introduce Maldonado's report, for example. My question was, is there a report or a series of reports that would be pretty easy either for you to email and my staff could print them out, where then Mr. Pritchett, the accused, would have sort of the core of discovery? And I don't know if such a thing exists, or look, each witness gave a statement, there's a recording, and I can't get him recordings. That's not how this works. And he and I discussed that before.
I don't know what he already has in those stacked papers. It would be the reports, probably sans like I'm comfortable with names and addresses going back to the jail. That would be.
So you have to engage in some redaction anyway.
Yes.
Okay.
Nothing of the reports, only names and addresses that are listed.
Right.
I don't have any problem.
Well, it's just not your job right now in the middle of trial. So I just wasn't sure if there was something in particular. All right, I'll think about that some more. Let's bring the jurors out, please.
So Daybell's going to be going over motions here in about, I think, 20 minutes or so. They're starting at 11 tomorrow. Late start. No court on Tuesday for them. Any court on Monday? The clicky thing. It's funny. Jury is doing their best to shuffle positions.
I'll do as president accounted for.
Thank you, Deputy Gordon. Ladies and gentlemen, we are set to resume. Mr. Hiles, if you'll call your next witness, please.
I'm calling Mr. Ayden Carly.
Lenova, the judge said the jury gets to be seen. So public courtroom, jury can be seen. The pool camera is not supposed to film them intentionally, but the jury can be seen.
Before you sit, can you turn around and raise your right hand? You swear affirm that testimony you will be able to the truth, the whole truth, and nothing but the truth of God.
Oh, man.
Can you state your spelling name for the record?
Holden Michael Carmody.
All right, Holden. How old are you, Holden?
23 years old.
Where are you currently living?
Charleston, South Carolina.
Is that where you're from?
Yes, Your Honor. Yes, sir.
So, where were you living? What were you doing in November 2019?
I was currently living in Charleston, still working at PF Chang's, and then I went out to LA to go see a friend of mine, Jackson.
Okay. Was that a visit or did you move to LA?
It was a visit at the moment.
Okay. And when was this? What time of year?
When I visited?
Yes.
Around about maybe a week before I went to Atlanta, maybe about a week, 5 days, around there.
Okay. So the end of October, beginning of November?
Yeah, about.
Okay. All right. Well, you just brought it out. Why did you come to Atlanta in November of 2019?
I came to Atlanta with Jackson because our flight was out of here to go to Houston for the Travis Scott concert.
Okay. And do you remember what date that was?
That I got here?
Yeah.
I think the 18th.
Okay. So that's fine. What did you say when you came to Atlanta?
I don't think this is
At an
the other
Airbnb.
model.
Okay. And who obtained that Airbnb? Who all was part of hosting that Airbnb?
Hosting it or renting?
Renting it. Who paid for it?
Jackson and Chris.
Okay. And what's Chris's last name?
Chris Riggs.
Okay. And what was your reasoning for coming to Atlanta?
As far as I knew, I was traveling with Jackson he had a couple of friends up here that he wanted to see, and we had already planned to get our flights out of Atlanta as it was just cheaper, and it's about a 3.5 hour drive for me. So made that decision with him. We were like, we'll stay for a day and then get out of here, go straight to Houston. And yeah, that was pretty much my reasoning for coming.
And while you were here in Atlanta, how much time did you actually spend in Atlanta?
I want to say probably about 28 hours total.
And do you remember looking at pictures of that particular Airbnb? Did we have a conversation prior to your testimony?
Yes.
Okay. And do you remember going over pictures of that particular Airbnb?
Yes.
Okay. So let's talk about our conversation and explain to the jury what stands out to you about what happened at that Airbnb.
Can you repeat the question? What do you mean by what stands out? Like what?
So
there's a lot.
What's the events that happened? Okay, I'm going to direct your attention to November 8th of 2019, early morning hours. What was going on at that Airbnb?
Well, we were having a party at first.
Okay. How many people were at the party?
Max, I'd say it was probably around maybe 18 to 20 people at most at one point. I wouldn't even really call it a party. I'd say it was more of like a get together, a kickback. It was probably at one point that I could remember totally about 11 of us just all hanging out, drinking, having fun, just playing games. There was never a moment where there was a lot of people in the house and it was a bunch of unrecognizable faces throughout everyone. I didn't really know that many people besides Chris and Jackson. Most of the people that were there knew Chris or Jackson. So
when you say Chris, which Chris?
Chris Riggs.
Okay. So you met, how close were you with Riggs?
I had just met him. That was it. It's the only time I'd ever met him, only time I'd ever seen him. Hadn't have known him prior.
How close were you with Jackson?
Jackson, we had went to high school together, and we were known. We both knew each other, and we were never really close friends then. And then later in 2019, we were able to get closer, and we became closer friends right then. And then we decided to make the plan. I came out to LA. We got closer then, and then we came back down here, and that's how we kind of were a lot closer friends because we were spending more time with each other. I just talked more. And so by that time, I'd say we were pretty good friends. So probably knew each other for about a year at that point, like of actual friendship and discussing with each other, constant keeping up.
So did you feel comfortable in the house with the people that Riggs and Jackson had introduced you to?
At the moment, before things went down and I knew things were wrong, 100% yes. Never would have broken a sweat or turned an eye.
Okay. When did things seem weird for you?
The moment the two girls walked in.
The moment the two girls walked in. Okay. Now, these two girls that arrived, did you know them?
Nope. I'd known that they were coming.
Okay. How did you know that they were coming?
Because Chris had told us that these two girls he had known were coming over.
Okay. Now, again, I'm going to ask you.
Sorry, Chris Riggs.
Okay. So if you're referring excuse me. If you're referring to Chris Riggs, would you please refer to him as Riggs?
Yes, Riggs.
All right. And at what point did these girls come over?
It was like, that was when basically the only people left there were the people that pretty much who Chris was, I would say, closely good friends with. All people that Chris and Jackson knew on a personal scale to have at the house and maybe even sleep there because we were pretty much winding down and calling it a night. I think they came in at about 1 a.m. maybe. 1 a.m. they came in. I couldn't really call as it was so long ago.
Yes.
I would say yes. I knew it was late at night. I could not tell you the exact time. It was so long ago and it was late at night. I was tired. And yeah, I just know it was late.
5 years ago.
What was odd about those girls when they came in?
Everything from their body language to how they walked, how they chose to not talk to a lot of us. Their eyes kept moving all over the places as if they were looking for exit points or things that stood out. It just didn't make sense to me. I had introduced myself. They completely disregarded me, kept moving about their way. So right there, that definitely said something to me like, huh, that's odd. You're not going to say some hello to the person who's letting you in the house.
How long were the girls present?
How long were they present? 10, 15 minutes, maybe, probably less. I would probably say 7, 8 minutes total, realistically. It was quick.
How long ago was this?
5 years.
Okay. Are these time frames you're giving estimates?
A lot, yeah. As like I said, it was 5 years ago, so I'm not going to be able to perfectly remember the exact time.
What happened after the girls arrived?
Basically, they were just like going through the house, downstairs first. Then they walked upstairs. I can't recall why they went upstairs, probably to smoke or something. But I just remember when I followed them upstairs, one of them out of the blue said she needed backwoods, which was just very odd to me, as I remembered someone was already smoking. And so
what are backwoods?
Backwoods are basically a wrap you use their tobacco. You just roll it out, get all the tobacco out, and then you fill it with weed or whatever you choose. But most times marijuana. And right off rip, when she said that, it didn't sit right with me, as she probably would have came in already with those. Someone probably here has them. And just the quick advancement of leaving the room of when she said she needed that stood out to me already, from how they were just looking around the room everywhere at everything. Just nothing about them seemed calm or like they were here to stay.
All right. Who arrived after the girls? Who were the next people to come in the house?
2 masked men with guns.
Okay.
Large guns.
Had you ever met these men before?
I don't think so. Not to my memory. As again, like I said, they were wearing masks. So no.
Okay. What kind of guns did you do? Did you get a statement to police?
I think I did, yeah, because I did talk to the police. I don't know if I recall telling them the gun, as I was very shell shocked in the moment, and I just had a gun waved in my face and hit with it. So.
Did you speak with me about the incident, types of guns?
Yes.
How did you describe the guns to me?
I described the guns to you as being a large assault rifle that looked very similar to what an AK-47 would look like, but it was not large as an AK-47. So I think it was either what's called a Draco or a modded AK.
Did you ever describe them to me as an AR style pistol?
I don't think I used the AR style pistol to you, but I definitely recall saying it was somewhat of an assault rifle. Maybe not AR pistol, but definitely assault rifle.
Wow.
I'm going to show you what has been marked and admitted as State's Exhibit 7.
Hey, Katrina, welcome. It's a crazy case.
It's like I have something on my screen. Should I say unmute?
No, say
stay muted.
Stay muted. Yep. Thank you.
We're watching a lawyer attempt to operate PowerPoint and fail miserably. Here we go.
All right.
Nope. False alarm. I'm going to try that again.
Do you recognize this picture?
Absolutely.
Okay. And what is this picture to you?
That's where I was sitting actually when they walked in.
Okay. Who was they?
The intruders.
Okay. Masked men?
Yes, the masked men that had the weapons that committed
anything
the
said during when they made entry?
Say it again?
Was anything said by the masked men when they made entry?
As soon as they entered, one of them said, "Get the fuck down."
Okay.
And then after that, I I don't remember much because like right as he said that, he was already about gun out through the door. Jackson's already stood up to try to be like, what the fuck's, I mean, he was just confused saying what's going on. And that's when I'm pretty sure it just triggered, get the fuck down, or because just it's a robbery. He's telling us to get down. But as soon as he walked in, he says, get the fuck down. Immediately, I'm just, what the fuck's going on? Sorry, excuse my French. What's going on? And I had no idea if this is real or not. They had masks. So I immediately hit the floor as there's a gun waving in my face. And from there, it kind of just all hell broke loose. Everyone's like yelling and screaming for a second. One of them immediately runs upstairs while the other one was downstairs, thus trying to keep us just held tight and not going anywhere, I guess.
Okay. Was anybody attacked physically?
In the first moments, yes. Jackson was whacked over the side of the head. I saw that before I hit the floor because he literally shot up right as the door opened. It was almost like a fight or flight reaction. And they immediately whacked him over the top of the head. So he hit the floor too. After that, you kind of just could hear a lot of rambling because at that point I'm looking at the ground and one of them's already probably running up the stairs. Like the stairs was a weird stairway. It kind of like turned really sharp and then goes up. So as soon as that happened, I just hear him running up the stairs and the other one's downstairs, shit's getting broken. I hear people's bodies moving. I'm still just kind of trying to focus on the ground as I feel as if I look up, I might get shot in the head. So I had no idea what to do or who's even getting hurt at that point. And that all felt like it just felt like it was going by so fast, but I couldn't really tell how much time that I was down on the ground for, so I don't know how many people were getting hurt in that exact moment once I hit the floor, because there was a few of us down there.
Did you have any property taken from you?
Yes, my wallet and my Invisalign. Yes, which
like they took it out of your mouth?
Well, one of them first asked what was in my mouth or if it was in my mouth because he opened my book bag and he said, "What the fuck is this?" And it was they basically give you, I'm pretty sure
they thought it was a grill.
Weekly, and you change them out each week. And he was like, "What's this?" And it was just full of the retainers. And I go, "What does it look like?" It's pretty self-explanatory. And as soon as I said that, it was clear he didn't like the condescending tone I gave him. So he kicked me in the face. And that sent me back for a moment. I thought my nose was broken. So after that, he took the Invisalign and my wallet. Because then once I was on my back, he started grabbing my pockets and being like, "What else do you have?" And I was like, nothing, just obviously lying. And he took my phone and my wallet and then just threw the phone on the ground and then left with the wallet and the Invisalign and left the book bag too.
He actually took your Invisalign?
Yeah, I have no idea why, but he took them, oddly enough.
He thought it was a grill.
What about your wallet? So, were you ever able to recover that wallet?
Yes, actually I was.
Okay. And how did you recover that wallet?
I recovered the wallet because someone who lived, I'm almost certain it was the street behind or over, I don't recall. It was placed in his yard. He called me about 8 to 12 hours after the incident. Once I was in Houston, I'd just gotten off the flight to let me know that he had found my wallet because thankfully I had my ID in there. So he was able to trace it back to my number, give me a call and let me know, "Hey man, your wallet was in my yard." And so I retrieved it when I came back from Houston to Atlanta airport.
Okay. If you didn't have your wallet, how were you able to board the flight?
I had to go through a screening with the TSA agents that required me to verify where my father and my mother lived, what their maiden names were, birthday, just questions about my life and their life that would prove I was who I was representing, which would be Holden Carmody.
And so you got the wallet back. Did you meet this individual? Where did you meet this individual?
I met him at the airport. He actually met me right outside of the entrance to the airport.
So if you look at your screen, if you look at the bottom corner, there's a little tool, or tap it once.
Okay.
To the left. You'll see that stylus, if you tap that.
Yeah.
So you'll be able to draw, and then you'll see on there's also a eraser mode.
Let's see his drawing skills here.
Would you please tell the jury, by circling where you were sitting when the armed assailants came in?
Yeah. I would say it was about right here.
Kimar says, "Not sure we can fund all the swears, but with previous, this catches up."
Describe what they were wearing.
So if you've ever seen the movie The Purge, the first thing that I took to was that it looked like one of the masks that's worn in that movie. And it's like this creepy Halloween mask, it looks very sinister. And then another mask I saw, it looked exactly like this monkey that's specifically from a video game called Grand Theft Auto. That immediately stood out to me as well, because I'm like, I've seen that in the video game. Like, why does that look so familiar? And it was this one weird looking monkey mask with almost like ears on the top of it, but I couldn't see the ears. That's just what I remembered it as. And because it so closely resembled a mask that I had been used to seeing so much in a video game. And I was like, wow, I cannot forget that. That's a very creepy monkey mask. And then the other mask almost looked like a clown face, but wasn't a clown, just a creepy smile on it.
Okay. Demonetization fund from Sinbad. That's my favorite cursey word.
For the face part, yes. Yeah, for the face, yeah, 100% was covered.
Were you able to determine anybody's race?
100%, yeah, I could see it in their hands.
Okay. Do you recall if they were wearing gloves?
I'm almost certain they weren't wearing gloves, as I could see, as soon as I saw the gun, I could see his fingers. And especially because I saw it on the trigger. So that's what immediately triggered my thought to thinking, I'm going to get shot. Maybe let's not try to get up or do anything crazy.
Who else was present in this particular room when these armed invaders came in?
If I recalled correctly, it would be me, Jackson, Rebecca. Chris was asleep on the couch. Not Riggs, sorry. Not Riggs, the other Chris. I forget his last name. I think it's Hooper. He was asleep on the couch. Jackson, Rebecca, and then Noah, I'm pretty sure, was also downstairs as well.
Do you recall where they were sitting or just that they were present?
I do not recall where they were sitting. No, I don't. I just remember that they were present. I'm almost certain Noah was next to me on the couch as Chase was on that couch sleeping.
We've talked in preparation to your testimony, correct?
Yes.
We discussed the presence of drugs at this party.
Yes.
Okay. What sort of drugs were present at the party?
So I know Jackson was doing some ketamine. As far as I knew prior to that, there was weed. There was a decent amount of weed there. There was a lot of smoking, alcohol. Aside from that, I didn't recall seeing any other drugs.
Okay. What form was the marijuana in?
Mostly edibles. It was, I'd say, just a large abundance of edibles.
Okay. Was that the target of the invasion?
Objection, Your Honor, leading.
Do you know what was targeted as far as property, what was demanded from the armed assailants?
I figured a bit of that out once one of them was using me as the ploy to go find it and basically as like a hostage. He asked me where the money was, and I immediately go, I don't know what you're talking about. And then from there, while searching all over he takes me upstairs with a gun to my head to the second floor, doesn't find anything in any of the rooms, leads me to the third room, which is upstairs, and then he finds the edibles. And so then he starts just grabbing away and still was wondering, he's like, where's the money? Throwing shit around, telling me like, give me the money. I have no idea what he's talking about. I knew nothing about any money being there. I didn't see any money, so I couldn't help him. He was just grabbing all the edibles out of the bag that was placed basically directly in front of me when we went upstairs. It was like at the edge of the bed. And he just starts grabbing away with his back turned to me.
Your attention now to what's previously been admitted as State's Exhibit 22, which is identified as doorbell footage in front of the house. Do you recognize the front of this house?
Yes.
I'm sorry, because of I'm playing video with sound, you're gonna have to turn. All right. And is that the Airbnb that you were staying in on that night?
Yes, don't forget it.
This is at the 6-second mark of the video of State's Exhibit 22 of armed suspects entering the house. Do you recognize what the first individual to walk on the porch pulls out of his bag? Did you recognize what's pulled out of the bag?
Yes.
Okay, and what did you recognize that to be?
An assault rifle or an assault rifle-like pistol, maybe. Like I was saying, like you said earlier, an assault pistol.
Okay. Did it have a full stock on the back end of it?
it looked like it had it didn't look like it had a bump on it. It just looked like it had a handle and then a big drum on it. Like 30 rounds, I'd say. Looked like it was enough to hold a decent amount of ammo.
And what were your thoughts when you initially saw that firearm?
I'm gonna die. I'm gonna get shot in the head tonight.
Okay. Did you have any actual, outside of what the comments with the Invisalign, did you have any other dialogue with these individuals?
Aside from when he had the gun to my head to be like, let's go, and basically walk me around the house and to try to find the money and I guess to find the other stuff that he was looking for, just being like, no, I don't know where it is. Like, I just kept saying, I don't know where it is. I don't know what you're talking about. I don't know what you're looking for. That's really all the dialogue that went down between us. And then the dialogue that when they were basically going through my book bag and he said, what is this? And I further told him what it was. That was about it.
Play some more of these videos.
This case is crazy.
What's this one called?
Sorry. This is still State's Exhibit 22. It is labeled in the discovery that was turned over as Girls Arrived to Party.
So it sounds like the girls were supposed to get paid for their part in this, and they never did. Is that what I heard?
Did you, or whoever let the girls in, were they unlocking the door to let them in?
As you can see in that video, that's actually me unlocking the door and opening it up for them.
Okay. Did you make a point to keep the door locked throughout the night as people were coming and going?
Yes.
Okay, why?
Because we knew we were in a dangerous neighborhood and I've always been taught to lock the door behind me, especially considering that we were young and we had the edibles in there and that we were in an Airbnb throwing a slight party. So probably just didn't want any random associates walking into that house.
And
those girls will be testifying
you
against
mentioned girls looking for backwoods. I want you to pay attention. This is the still State's Exhibit 22, labeled as LR Leaves Party inside the exhibit.
Your Honor, I just want to be clear for the record.
Pause.
Yeah.
Yes, ma'am.
So 22 was tendered as if it were one clip, but it appears that 22 is several clips. If we could label it just for purposes of reference, each video as 22A, B, C, so it's clear because it looks like there's more than one different clip.
Okay, so two things. One, my recollection is that when Mr. Grady testified, he said it's a bunch of clips from the Ring camera at 1040 Wiley, his arbitrage, Fort Fiesta. But two, it would be helpful if we did that. We're not gonna do it right now, but you're gonna agree with Ms. Mignot and the accused with some kind of nomenclature because the record is already gonna be a little spotty. You are occasionally remembering to give the name of the clip, and the name of the clip is something like girls walk into building. So let's give them letter designation. So 22A, 22B. Don't do that right now. Keep going right now, okay?
Yeah. Go forward.
Yes, sir. Well, like after today. Yes, thank you.
For the record, as it is labeled now, it is labeled LR Leaves Party.
Okay.
Yeah. I don't think I have them. Oh, yeah, I do.
Was that the exchange that you were referring to earlier?
That was the exchange when she was claiming she was going to get the backwoods.
I'm thinking this guy's got immunity as well.
This is the last video I'm going to play with you. It's labeled for the record, State's Exhibit 22. It is labeled as Armed Suspects Leave Party. I am going to move now to what is labeled State's Exhibit 1A. It is the audio of the 911 call, previously admitted through Latner's.
Never seen somebody sort of take possession of the witness chair quite like he has. Make yourself comfortable, my friend.
Okay, 1040 Raleigh. Yes, 1040 Raleigh Street. Do African American. We're going to come straight, please help us. Okay. Let me start all of them. Anything else for 7 minutes, you need your help now. Please, okay, sir. And just a household parking. I we need your DVR. Okay, did anybody get shot? No, he's just leaving. He's just leaving a lot on the top tech. That's not in the base. I need your now. I'm not. Okay, my help. Yes, sir. Hey, this is 1040 Wire Street, Taylor, sir? Yeah, 1040 Wire Street. Okay, is that house in there, sir? No, that's just for the house. Hang on. What's the phone number you're talking about? It was your and your name? Only comment. We come on one everything. So tell me exactly what happened. No. This was found at gunpoint, already, and one person got hurt. Okay, thanks. No, they said they're not, he's gone. I need to help now. What do you mean he's dying? What happened? He fell to the floor now, and he's breathing from his head. He fell? Okay. Yeah, he's up now. Okay, Mom? Sorry, how many people are injured? 3 or 4. I mean, are you with them now? Yeah, I'm with them. Okay, then how many people are injured? 3 or 4. 4 people are injured now. Just send it back up right now. Is everyone awake? Yeah, everyone's awake. Is everyone breathing? Yeah. Are they male or female? Male and 1 female. Hurry, please come. Start with this. The ambulance is on the way. I need you to focus on answering my questions right now, because you talking to me is not slowing anything down. Okay? All right. Is everyone breathing? Yes, ma'am. Everyone's breathing. Okay. Is the assailant still nearby? Is the what still nearby? Assailant. Is the people with the attackers? Yes. No, I don't know. Okay. And they have done any other weapons? Yes, 2 weapons. What were the other weapons? 2 AR. Okay, and you said someone bleeding from the head. Is there serious bleeding? Yes, seriously. Okay. Is everyone completely alert? Yes, everyone is very, very close to me. All right. Okay, your friend is bleeding from the head. I know that. Sir, listen, calm down for me. I understand you want to wait. I'm going to give you some instructions. I need you to listen carefully to make sure we do it right. I need you to get a clean, dry, cloth towel and place it right on the room. Press down calmly and don't lift it up to look. Wait there. Okay, I need to. Let me do it, right? I told you I'm going to do it. So, it's not happening. Hello? I'm not sure. We can get the holiday. Okay, I need a description. Right. Okay. Sir? Yeah, no, I'm not. No, sir. We need a description of the assailant for the police. Okay, they're wearing all black. They don't be wearing all black? One guy was black and they're black. Yeah. They're calling you okay, one man was black, he had a mask on, and what color clothes was he wearing? Okay, no. Okay, is that bleeding? Yes. Okay, good. All right. What about the second assailant? We make black women, you know? There's no black. But okay, we got it. It's almost done. So you have a camera, just can you plug it in and you can stay on the phone with me? Is there another phone in the house? Oh, no. No one else has a cell phone that you can give me the number? Sir, this is so, if they need my cell, we're in a vehicle. I think we know that. Okay. All right, thanks, Brady. We will definitely be safe. Yeah. Thank you. All right. Start fire also for the multiple victims. We got to start fire. Okay.
Very hard to hear.
Do you recall making that 911 call?
Yeah.
All right. What was going through your mind at the time of making that call?
You know, as much as I want to say it was focused on the robbery, I was more so thinking that someone's about to die in my eyesight because of how much blood I saw coming from his head and the fact that he stood up and then he fell down because he didn't even have enough, what I'm assuming is blood or energy to be even able to walk. Because he tried standing up, and as soon as that happened, you can hear on the call, I say he's up, and then nope, he's back on the floor. So honestly, I was thinking that I'm actually about to witness someone die. So making that call, I was just very scared and still so confused because I'd just gotten robbed, and now not even a minute later, I'm focused on hoping that this ambulance can get here in time because this guy that's literally in my hands is about to bleed out all over me.
This guy that you keep referring to, who would that be?
The guy would be the DJ.
Did you know him before this incident took place?
No, I did not.
That night, or the early morning hours of November 8th, would have been the first
That was the first time I've ever met him.
So what did you do? You said you were kicked in the face.
Mm-hmm.
Did you say you were kicked or did you say you were kicked?
Both.
Were you given the opportunity to seek medical attention?
Prior to the ambulance getting there?
Well, once the ambulance arrived, were you given the opportunity to seek medical attention?
Of course, yes.
Okay. Did you go to the hospital or did you go anywhere to seek medical attention?
Seeing that I was not bleeding anywhere and my head wasn't raging with a headache, so I assumed I didn't have a concussion. No, I did not. Besides just like the eye light, but no like actual go see a doctor, go to a hospital. I just had the EMS, the guy in there, he like, waved a flashlight in my eyes, said, does anything hurt? How does this look? Can you follow my eyes? Kind of see if anything in my brain got messed up, which I passed and I did fine.
When was your flight out of Atlanta?
I think 7 a.m.
Well, this occurred around 2:30. Why did you decide to go ahead and make the flight?
You know, seeing as it was, as I had just gone through such a traumatic experience and it just hit me, I was like, I'm already here. I refuse to just get back in my car now and go all the way back home and have to think about what just happened. So honestly, it was also the fact that I just put so much money into going to Houston. I was like, I'm still going to go to this and go have a good time. And hopefully that will help maybe make this experience not as bad as it was and ideally help get over it.
Okay. All right. And you went with, who did you go to Houston?
Jackson, Ohio.
Did you make it to your final destination where you were going?
Yes.
What was that?
Houston.
Well, what was your reason for going to Houston?
To go to the Travis Scott's festival that was called Astro World.
Did you make it to Astro World?
Yes.
Okay. Did you attend?
Yes.
All of it?
Mm-hmm.
Was there anything else that was taken or that you told police that you don't recall me asking you about as it regards to this home invasion and home robbery?
No, I don't think we missed anything.
And did you ever hold yourself out as being able to identify the individuals, the two males that robbed you at gunpoint? Did you ever hold yourself out that you would be able to identify them?
I think I would be able to, in the moment, identify body structure, and maybe I knew that they were black as I had seen their skin color and I saw their hands. So I knew their race. But facial, no, I do not think I would have been able to identify or still could be able to do that with face because I did not know.
Okay. That's all the questions I have.
All right. Ms. Mignot, we are close to the time where we need to call it for a day. Do you have a bunch of questions for Mr. Carmody or a few? You should take as much time as you want. If you know you only have, sometimes you stand up and say, I'm going to be brief. Sometimes you don't say that. Is this a brief or not a brief?
Not a brief, Judge.
Okay. Are you able to come back tomorrow or are you driving back to Charleston?
We are driving back, but I think I can definitely stay another day if I have to.
You have to. I apologize. The goal was to fit you in today, but I've committed to the jurors that we'll stop close to 5, and we're actually a little bit past 5. So I apologize for that. We need you back here 12:30 tomorrow. So you can sleep in. 12:30 tomorrow, you'll be our first witness. It's important that you not talk about your testimony with anyone because you're partway through that process. So talk about anything else, but we need you back here a little before 12:30. We'll get you on the stand, see if there's any cross-examination from Ms. Mignot, from the other party, and then if there are any questions from the jurors, okay?
Okay.
All right. Mr. Hiles, anything else for Mr. Carmody before he goes?
No, Your Honor.
Okay, you can step down, sir. Thank you.
The counter we have up there on the screen.
And ladies and gentlemen of the jury, we are.
Let's let the jury go.
Shift the camera angle. We're going to stop for the day. Again, tomorrow, Wednesday, we're going to start up at 12:30. I don't know that the shuttles run quite as often in the middle of the day. They may around lunchtime, every 30 minutes. So you really want to catch the noon shuttle because you roll, if you're one of the folks who parks in the lots that have color names, and you roll in at maybe there's a 12:30. You'll be late anyway, though, so don't try to catch the 12:30 shuttle. Try to catch the noon shuttle. If you don't park down there, just be here by 12:30. Please have had your lunch because I'm going to view the lunch break as ending at 12:30. It's all morning. It can be a brunch break. Any logistical questions for any of you? Your notepads, take them with you and leave them in the jury room. Yes, ma'am.
We did speak about running later tomorrow.
Oh, right. Yes. Thank you for reminding me. What is the collective will?
To run late tomorrow.
Okay. Then let's assume that we'll go till 6. And 6 will be like today's 5. If it's 5:50 and we finish the witness and the next witness is an hour-long witness, we won't start that witness. But otherwise, we'll go till 6. And if we go to 6:02, because that lets us wrap up a witness, I'll know that that's not stressing any of you out. Okay? So thank you for consulting and reminding me. 12:30 tomorrow. We'll see you then. No outside research. Don't talk about the case with other folks. Thank you so much. Let's let juror 19 get out of here.
All right. Juror 19 smiling. He's like, yeah, it's me. There are jurors. Yes, they do get shown on the camera. The judge has acknowledged that he knows that. And it's a public court case, and anyone can come in and see the jurors if he wants. It's fine. We're okay with that.
All right, you all can be seated. Couple things. One, now that I have heard more of the defense presentation in form of openings, and I'm speaking specifically to the Robinson presentation because I'm right now thinking about Ms. Mignot's motion to reconsider my ruling about the 2 music videos. I'm going to maintain my ruling, assuming there has been a redaction of all the parts of Guns Up that showed little kids.
Yes, so I haven't seen it. They're working on it. I will absolutely make it available before I even attempt to play it. So in the intro, there are kids, but it is not the part where, they're just in the neighborhood, but it is the end of the video where they're actually sitting down and instructing them as to how to commit a crime, the rules of the gang. It is very difficult to get the kids out of the complete frame of the video. They're like walking in the street.
You're talking about at the beginning?
At the beginning.
I'm less worried about that. A streetscape could have a little old lady walking down the street as well. What was particularly alarming was when the performers were interacting with the kids to say, basically, someday you're going to be like me, or you should want to be like me. That's out, and that's easy to remove. It doesn't require any cropping. It is removed. And so if it gets too tricky, just end it before that starts. I just don't know if there are things after the kids are gone that you want to use.
There are, but I think it makes it might just be easier, or it's just a hard cutoff. I think they got a point.
I think that that's a wiser move, but that's your call. My direction was to remove the segment that involved the tutelage of the young children. So once that's done, please make it available to all the parties on the other side so they can review it and share any concerns they might have. Okay?
Do you have scheduling matter I'd like to discuss with everyone, maybe off the record? I think I told you about the appointment.
Yep, we'll do that in a minute. So thank you for flagging that. We'll just, you let them leave. Are we not starting at 12:30? Well, we could start and Ms. Green will take care of things.
It's as a Thursday, so
okay, so let's pause on that. I'll circle back. Anything else from the state?
No, nothing else.
About tomorrow?
Nothing about tomorrow.
All right, Mr. Carmody will be available 12:30 and then we'll fill the rest of the day.
Yes, and I had originally asked Miss Nelson has done a production order for Ms. Riley. I'm not sure that we will get to her, but I'd like to have her brought
in case we do, because I don't want, if we're going, especially if we're going until 6.
So it's 5 o'clock now. If you haven't told Ms. Nelson you want her here tomorrow, that's a little problematic.
Oh, she's already, I just wanted to make sure she still comes. She already, the order's in.
Good, then she's still coming. She has no reason not to be here. And if we don't reach her, understand, because tomorrow's a half day, and then we'll just need to give in. Yep, she's coming, I'm told. If we don't get to her, then we'll renew the production order. She's at the city jail, so it's not a particularly complicated one. It's just better to be a day ahead of things. And I'd ask, unless it really throws your case upside down, if we're bringing her over tomorrow, let's try to get her on the stand tomorrow. But we'll see. All right. Anything else from the state?
There you are.
Okay. Sir. Anything from you before we wrap for the day? And so the record's clear, I'm referring to the accused. You're good? Okay. That pen that you have, you should leave here. I promise you can have it back tomorrow, but I don't want to get you in trouble because you're bringing that back. Great.
Steal the court.
Ms. Mignot, anything on behalf of Mr. Robinson?
Yes, Your Honor, we are still concerned. We understood the court's ruling as to the video that the children were going to be removed. Now, today is the first time we're realizing that the state is having difficulty removing the children from the video. It is still our position that even associated with the testimony that this court has received, that there's been no allegation of any gang. There's nobody who's testified that they seem to be gang members or we saw them as gang members. So we're still objecting and renewing our objection regarding the guns up and the play nasty video. But I am concerned that if we're going to show these jurors videos of guns that we think are dangerous and that we're trying to make a connection to this case at any child. If it were an adult or a grandmother, they'd be like, she's old, she's seen the world.
Right.
But it's still impressionable and it's still making sense, some of the jurors, to see a child.
I don't disagree with you. And so here's where we are. Mr. Hiles is going to share with you and with me and with the accused what he's come up with the edits. And if it's not sufficient, he can either fix it in the available time or not use it. The second video doesn't have that problem. And you're not waiving any objections by saying, oh, okay, the kids are out now. I'm understanding that you maintain your original objections. And so the record's clear. These are videos that are being introduced only as to Mr. Robinson, not as to also the accused. So that's why you and I are having this discussion. But let's see what they put together. And if I need to say, look, I told you no kids and they're still kids, they could always rush and say, oh, we're going to cut out the first 30 seconds where there's the street shot and their kids playing in the street. I may look at it and say, I view that as harmless because that's just footage of walking down the street. It also has trees in it. And that's not an issue that there are trees in it. So I am open to your concern. I need to see it. It sounds like Mr. Hiles has focused on the area that I know I directly referred to, which was that footage of the performers interacting with, blowing smoke on, having guns with the little kids. That needs to be out. And it sounds like that's coming out. Let's see what's left. And we'll address it then.
Thank you, Your Honor.
Sure. Anything else?
That's the only matter.
Okay. All right. Accused. Your family at one point was providing street clothes for you to wear. Are you interested in that? Because they'll be back tomorrow and we can have you dress out if you want to. That's your call. I don't force it on you in any way. I'm just simply offering it up because there's been a little change and you've been with us for part of the proceedings. So if you want to wear clothes more like what Mr. Robinson is wearing, we can make that happen. But it is not a requirement. I'm not ordering you to do it. You're going to take care of it. You don't want any assistance from me. Okay. All right. When that changes, let me know. Okay. All right. That's it. Thank you so much.
Thank you, Your Honor. Enjoy your evening.
Enjoy your evening. All right. So the counter, say my name, is the accused. We are counting how many times we hear the name the accused mentioned, either by the judge or by the counsel. The judge has agreed to call the Sovsit defendant what he wants to be called. And the defendant said, can you refer to me as the accused? Judge says, sure, we'll do that. And to his credit, he is. He's bending over backwards. I will say he's actually got a good rapport with the accused. It's dumb. It's stupid, but look at what he's accomplishing. Okay. They could fight over the name every time they interact. That's not my name. We would have Daryl Brooks over again. Instead, he met him halfway. He said, "Look, I'm not gonna say that you are not Mr. Was it Pritchett? What was the name? I can't remember what his actual name is. Let me double check here. Turn that off. Oops. Let's see. Pritchett. I think his name's Pritchett. I'm not going to say it's not Mr. Pritchett, that you are not the person that we've indicted for this. But I will call you by the name that you want to be known by, because it will save all the SovSit battle. As you know, I have not given you authority for you to use this commercial name, which I have not acknowledged that I've ever had ownership of. He's got this whole spiel he goes through, right? It's huge. It's time consuming, and the judge found a way around it. And he's like, I'll call you the accused. And the guy's like, I'm winning. He's losing, but he's winning. And now he's starting to realize, I think today as he sat through court, that he has no idea what he's doing. And as he watches his buddy, his gang member buddy, allegedly, sit there with lawyers who are fighting and doing a pretty good job of defending him. So far, they've been able to get all the victims to be able to say, we don't know if that was him. We have no way of saying that guy was there. That helps. And now he's like, I don't know what I'm doing. I don't have the evidence. I don't know. Yeah. Maybe he'll come around. He might come around. He's had several lawyers before, but he's doing it on his own now. Max Pritchett, sovereign citizen. That's him. So anyway, anytime the judge says the accused, we have that say my name counter go up by 1, and we are up to 31 times so far. So that was day 1. That was yesterday. We have a half day to catch up tomorrow. We're going to start early in the morning. I say early. That's like 8:30, right? Is that early? Is that early enough? We'll start at 8:30 in the morning tomorrow with the half day so that we can catch up the day after. I got the hiccups again. Sorry. This trial, just as a brief synopsis, this is a home invasion robbery that was committed by 2 individuals that may have had accomplices with the 2 males who had AR-style pistols. May have had accomplices with these 2 females who scouted the place out first, sent Snapchat pictures or information back to them saying, hey, here's what they have here. They've got the drugs. They got the money. Here's where it is. Then the males come in, kick down the door, knock some heads, take some names, steal some shoes, steal some wallets, steal an Invisalign braces. It's a clear braces thing. It's sort of expensive. It's sort of cool. Technology's come a long way since kids were getting braces. They can do some pretty cool things. But steals that. Phones, wallets, shoes, very expensive shoes. Lots of edibles, lots of gummies. And I don't think they got the money. The $15K, they never found it. It was well hidden. Which is funny that the police gave it back to the defendant, or not the defendants, but the witnesses, because you'd think it would be confiscated as ill-gotten gains before this criminal enterprise with the bringing the drugs across state lines. It was not legal in Georgia at the time. It was legal in California. They ended up giving back the $15K apparently. So anyway, that's where we're at. So we have 2 defendants that are being tried together. There are 2 more defendants who will be tried separately. I believe those are the 2 girls. The one defendant who is a SovSit, who is the one in orange, who's a little problematic for the court. He was convicted, or at least involved in another case, a similar case where there was a fatality. And for some reason, I'm not sure if he was out on bond or if he was out for one reason or another there when he committed this second one. So he's potentially a repeat offender on there. So that's where we are. Any other questions that I can clear up for you? Airbnb, major party. There were only 10 or so people there. It went south. But still, all the victims made it to their concert, I guess, except for maybe the DJ. He seemed to take the worst of the beating, and he was the only one who was hired to be there. He was like working, a legitimate job working there. And yeah. Are we done for the day? We are done for the day. We're finished. We're going to continue to follow this case. Let me show you what the thumbnail looks like so far. It's a sovereign citizen trial. We're looking for a better name. I was going to say the sneaker theft trial. I don't know. You guys are more creative than me. So now that you've seen one day of court, what do we call this one? But here's our refuse. What does that say? Refuse, recuse, and retrial. This happened back in 2019 too. Oh, we've got the Wheel of Fortune on there, the spinny wheel, which had take off a layer of clothing or take a shot. We've got the food up there from the court, as we had the image that need. We've got the hall pass, because people needed the hall pass to use the bathroom. The judge let the jury go out. We've got the plane they had to catch. The for rent, it wasn't Airbnb. This is a empty water bottle. We've got the green or off the lime shoes. We've got the masked individual. Yeah, we're starting to put together the thumbnail for this one. So it's the Say My Name trial. The Say My Name. What's my name? Yeah, okay. Yeah, there's a bunch of references we could do there, but we won't. Airbnb Gone Wild. Oh, that is good. Airbnb Gone Wild. Can we change it to that? I'm going to change it right now. Airbnb Gone Wild. Yeah, sort of incredible that these individuals that left, I like party crashers, the individuals that got victimized here in Georgia then flew to Houston and went to the Travis Scott concert, which had a tragic ending for some other individuals who were present. That was terrible. You don't want to Google that. Airbnb Gone Wild it is. Well, look, they're already updated. Airbnb Gone Wild. Francesca, thank you very much. I think the Chad Daybell trial is still going on. They're probably just finishing up a couple motions. Just looking over there, they're just wrapping stuff up over there. Then RA can use it for the name of his Airbnb. I've already got a name for our Airbnb, which I think we've got somebody coming for 3 days over the weekend. Now I'm worried they're going to throw a party. But actually, we got a lead for renting out the Airbnb because Mr. Beast, you know who Mr. Beast is the YouTuber. He's bringing in some production crews from California for a shoot for a video, and the company says we're going to put up all our guys that we're bringing in for this in their own Airbnb, in their own house, in their own location. So they want to know where we were at, how fast the internet was, and everything. I'm like, I've got 2 gig. How fast? You can't get much faster than that without being a company, as far as like being on a corporate, a business location. So we might have some Mr. Beast video editors or production crew staying at our place. We'll see. If they do, they can't tell us anything. They've all got NDAs. Anyway, so that would be fun. Because I'll tell you, I know several people that work for Mr. Beast, and he works them to the bone. It is such a hard job. Mr. Beast, Jimmy Donaldson's his name. His work ethic is way up here. He like never stops. He's always thinking about how to make things better, and he's driven, and he expects that of all of his employees. And some of them just get burned out. They just get worked out. Anyway, good stuff. All right, we have, there was a Mercedes-Benz reference. Maybe we can put a Mercedes-Benz, well, they'll probably sue us. I don't know. We'll think of it. Only a small party. That's all it was. All right, we're going to wrap up here for tonight. Mrs. R.A. has already left. She's gone to do an activity with our kids over at a friend's house, which sounds cool. But here I am trying to figure out dinner for myself. That's going to be sad. You've seen what happens when you rent to California, people, says Tian. I've been warned. Daybell is done. We're going to go ahead and close that down. Thank you very much for that. We're going to stop the share. Court starts tomorrow morning at 11. All right. Thank you very much. Ashley, appreciate what you do over there. We might... Anyway, Ashley, text me real quick. No, never. You can't. Mrs. R.A. has the phone. Don't text the burner phone. I won't get it. All right. Thank you to the amazing mods who had their work cut out for them today. As this trial sort of went off the rails a little bit, chat got a little spicy, and made the mods work extra hard. Thank you very much for the work you do. You are absolutely incredible. Tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe until we go live again, which will be tomorrow morning, 8:30. Ashley, I'll talk to you over on the Top Mark chat before I shut it down. All right, I think that's it. Y'all have a wonderful night. Be good to each other. We'll see you tomorrow. It's going to be fun. There was something else. This court to fix their audio problem, all they need to do is turn the speakers up in the courtroom. They've got the gain cranked too high on the microphones and the volume turned too low on the speakers. So people are like yelling into the microphones to be heard. They could just talk normally, turn the speakers up. It would solve all the problems. All of the problems would be solved if they did that. I'll give you a quick link to the, here it is, copy link. Anyone with the link, it's gonna be in chat. The last thing in chat, here's the link to the Canva. Wait for it. I'm gone, but it's still gonna be there. Just wait, it's coming. There you go. Do you see it? Do you? There you go. All right, have a good night, guys. We'll see you. Bye.
How does he do that?
The zombie apocalypse may be upon us.
Alex stole it.